The House will come back to order. Representative Benavides.
Thank you, Madam Speaker Pro Tem. I move for a call of the House.
A call of the House has been requested. 10 or more members must now stand. Count 10 hands raised. The motion is properly sustained.
Thank you.
Will the sergeants please close and lock the doors? Mr. Reader, turn on the chimes. Members, push your buttons to indicate your presence. Mr. Reader, please call the names of those who are absent. And will the sergeants please locate the members who are missing?
Wait just one moment.
Isn't he supposed to be whipping? Whipping good? What's that? Something we sent to the vote.
Yours, or the one up there.
I mean,
That'd just be so much easier or something.
Well, I thought I've been trying to get
Oh, I see.
Yeah.
That's not
Representative Buentale, Catlin, Coleman, Duran, Geithner, Gonzalez Gutierrez, Holtorf, Hooten, Humphrey,
Kraft Art, Landgraf, Larson, Melton, Mullica, you're not here. Representative Singer. He's here now, but a second ago, he wasn't here. Thank you. Soper. Representative Larson, please push your button. Thank you. Valdez D. You're standing right here, and yeah, you haven't pushed your button. Please push your button. You are pushing my buttons. Van Winkle, you're sitting here in the front row, and I'm going to stop now.
This should be a bipartisan effort, don't you think, Representative Coleman? But we need a little bit more flair. So I'd ask that Representative Melton come down here, because there needs to be a little bit of dialogue when we're shaming members into being here and pushing their buttons like Dave Williams. And the Speaker of the House. And Marcus Catlin.
Do George W. Come on. You could do George W.
That wouldn't be prudent.
All right. We need Soper,
Geithner.
Williams,
Mullica.
We need to call out Geithner first, and then Gonzalez Gutierrez.
Humphrey. Hooten. Holtorf.
Mollica. Soper.
I'm Bill Clinton. We're looking for Geithner. We got Gonzalez Gutierrez. How y'all doing?
Williams D. I need you to push your button. It did say Soper. All right, where's Melton at? Where's Melton?
Representative Catlin. Mullica. Soper. Williams. It's Bill Clinton. Hey, you got to do somebody. Who do you do?
I don't know.
I could do George Bush
Who do you
again.
think I should do?
I could do George Bush again. Representative Soper. Representative Gonzalez Gutierrez. George W.
He's George W.
I'm a war president.
All right,
I can't do it right now because I forgot it's been a long time. Texas, Lower Texas.
lower Texas. Read my lips.
No, that's that guy who talks like this. Do we have representative?
And I got a Geithner. Pull your push button. Geithner. Do I have a Geithner?
Auctioneer.
And the longest name in the house, Gonzalez Gutierrez.
She is. I saw her do it once. No, am I gonna make that up?
That may be.
Did you do it?
I want to see that. I'm the one that did it.
You did it, and then she bid on it.
Do you know there's no such thing as a student athlete? Geithner. Gonzalez Gutierrez.
On YouTube. If they want to
Holtorf.
If they want to
Bueller.
go on YouTube and rock it out.
Geithner. Representative Geithner. Representative Geithner. As you are walking away, we need you to push your button. If you. This is old school. You'll show me how to do it?
I'm here.
I always wondered how Humphrey unpushed his button.
Been an easy day. I'm here, Mr. Randall. Thank you, sir.
I've been here for 4 years. I never figured it out.
I don't think I have it.
What's the
You must have a very special one.
special button? To unpush? Oh, yeah, to unpush. Hold down the, yeah. You hold down both of them? No, it's just the no, I thought. Excuse me, we locked the doors. The doors are locked. We're supposed to lock the doors.
Yes, we are. Yes, we are.
Geithner. 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 I'm just gonna keep saying it. Geithner. Geithner. He just likes hearing his name called.
Geithner.
Ooh.
Hooty-hoo!
She's not here. Hooty ooh.
Gonzalez Gutierrez till win one, and Hooten and Mullica till they get back.
Courtroom, you can
You can raise it.
Representative Benavides.
Thank you, Madam Speaker Pro Tem. I ask that the call of the House be raised.
It has been moved that the call be raised, and all those in favor say aye. All opposed, no. The ayes have it. The call is raised.
The House will come back to order. The next order of business is general order, second reading of bills. Majority Leader Garnett. Oh, we're doing third reading. We need to proceed out of order. Okay, Assistant Majority Leader Kennedy.
Thank you, Madam Speaker. I move the House proceed out of order for general orders, second reading of bills.
Seeing no objection, the House will proceed out of order for second reading general orders. Representative Esgar. You all have heard the motion. Representative Esgar will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there's a request for reading a bill at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen and on your iPads. Bills will be laid over upon motion of the Majority Leader, and the court rule is relaxed. Mr. Randall, please read the title to House Bill 1147.
House Bill 1147 by Representatives Buckner and Ransom, also Senators Smallwood and Moreno, concerning allowing children reasonable independence to engage in activities without finding that the child is abused or neglected.
Representative Ransom.
Thank you, Madam Chair. I move House Bill 1147 and the Judiciary Committee report.
To the Judiciary report, Representative Ransom.
Thank you, Madam Chair. The Judiciary Committee, removed Section 2 of the introduced bill. We moved the language from 19-3-102 to 19-1-103 because that is the definition section of the Children's Code. That was where this language belonged. And we fixed, we expanded the overly broad definition of sufficient maturity. So I urge adoption of the Judiciary Committee report.
Is there any further discussion on the Judiciary Committee report? Seeing none, the question before us is the adoption of the Judiciary Committee report. All those in favor, please say aye. Aye. Those opposed, no. Judiciary report is passed. Representative Buckner to the bill.
Thank you, Madam Chair. We appreciate the Judiciary Committee accepting our strike below amendment. The strike below amendment represented a vigorous stakeholder process to make sure that we are both maintaining the spirit of the policy and making sure we don't create unintended consequences. At this point, all of those who were stakeholders who shared their concerns in testimony have moved to neutral with the adoption of this amendment. These stakeholders include the following people: the County Human Services Directors and attorneys that testified, Denver County, Jefferson County, Adams County, Arapahoe County, Boulder County, and the Kemp Foundation, as well as the Office of the Child's Representatives, the Colorado Department of Human Services, and the Colorado District Attorney's Council.
Representative Ransom.
Thank you, Madam Chair. What this bill does is actually let kids play outside. It's called reasonable independence because children need the opportunity to become self-reliant and responsible, and parents are the best ones to know when they are ready for those additional responsibilities, such as walking to school, walking to stores, riding their bike to school, playing outside, possibly being at home unattended. These are the types of things that this bill will allow parents to permit their children to do when they're ready. So with that, I urge an aye vote and ask for your support.
Is there any further discussion on House Bill 1147? Representative Williams.
Thank you, Madam Chair. Please have this bill read at length.
You have heard the motion.
Second regular session 72nd General Assembly State of Colorado introduced LLS No. 20-0676.01 Breda Darling X 2241 House Bill 22-1147 House Committees Senate Committees Judiciary A Bill for an Act concerning allowing children reasonable independence to 101 engage in activities without finding that the child is 102 abused or neglected. 103 Bill Summary. Note, this summary applies to this bill as introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes third reading in the House of Introduction, a bill summary that applies to the re-engrossed version of this bill will be available at http://leg.colorado.government. Under current law, a child is neglected or dependent if the child's environment is injurious to the child's welfare. The bill clarifies that the child's environment is injurious to the child's welfare because the child's parent has placed the child in or failed to remove the child from a situation that a reasonable person would realize requires judgment or House sponsorship. Buckner and Ransom. Senate sponsorship, none. Shading denotes House amendment. Double underlining denotes Senate amendment. Capital letters or bold and italic numbers indicate new material to be added to existing statute. Dashes through the words indicate deletions from existing statute. Child's level of maturity, physical condition, or mental ability and that results in bodily injury or a substantial risk of immediate and grave harm as a result of a blatant disregard of parent or caretaker responsibilities. A child is not neglected or dependent if a child who is of sufficient maturity, physical condition, and mental ability is left by the child's parent, guardian, or legal custodian, under conditions that are reasonably deemed safe and secure sufficient to avoid substantial risk of physical harm, to engage in independent activities specified in the bill. The bill amends the criminal code to reflect that a person does not commit child abuse if the person is exercising reasonable judgment in allowing a child to engage in independent activities as described in language added to the dependency or neglect statute in the bill. Be it enacted by the General Assembly of the State of Colorado 1 Section 1. In Colorado Revised Statutes, 19-3-102, amend 2, 1, B, and 1, C, and add 3, as follows 319-3-102. Neglected or dependent child, definition. 1. A child 4 is neglected or dependent if 5, B, the child lacks proper necessary parental care through the 6 actions or omissions of the parent, guardian, or legal custodian. 7. C. I. The child's environment is injurious to his or her the 8 child's welfare because the child's parent, guardian, or legal 9 custodian has placed the child in or failed to remove the child. 10. From a situation that a reasonable person would realize. 11. Requires judgment or actions beyond the child's level of 12 maturity, physical condition, or mental ability and that results 13 in bodily injury or a substantial risk of immediate and grave 14 harm as a result of a blatant disregard of the responsibilities of 15 the parent, legal guardian, or legal custodian. 16. 2. For purposes of subsection 1, C, I, of this section 17 blatant disregard means a situation where the real 18 HB 20-1147-2 an imminent risk of grave harm would be so obvious 1 to a reasonable parent, guardian, or legal custodian that it is 2 unlikely that a reasonable parent, guardian, or legal custodian 3 would have exposed the child to the danger without exercising 4 precautionary measures to protect the child from harm. 5. 3. A child is not neglected or dependent if a child who is 6 of sufficient maturity, physical condition, and mental ability is 7 left by the child's parent, guardian, or legal custodian, under 8 conditions that are reasonably deemed safe and secure. 9 sufficient to avoid substantial risk of physical harm, to engage 10 in independent activities, including 11, A, traveling to and from school, including walking. 12 running, bicycling, or other similar mode of travel. 13, B, traveling to and from nearby commercial or 14 recreational facilities. 15, C, engaging in outdoor play. 16, D, remaining at home unattended. 17, E, remaining for less than 15 minutes in a vehicle. If 18 the temperature inside the vehicle is not, and will not become 19 dangerously hot or cold and for such longer reasonable 20 amount of time if the circumstances make it a reasonable 21 parenting choice that the child remain in the vehicle, and 22, F, engaging in a similar independent activity. 23 Section 2. In Colorado Revised Statutes, 18-6-401, amend 24, 1, A, as follows 25 18-6-401. Child abuse, definition. 1, A, I, a person commits 26 child abuse if such person causes an injury to a child's life or health, or 27 HB 20-1147-3. To be unreasonably placed in a situation that poses a threat 1 of injury to the child's life or health, or engages in a continued pattern of 2 conduct that results in malnourishment, lack of proper medical care, cruel 3 punishment, mistreatment, or an accumulation of injuries that ultimately 4 results in the death of a child or serious bodily injury to a child. 5, 2, for purposes of subsection 1, A, I, of this section, a 6 person does not commit child abuse if the person was exercising 7 reasonable judgment as described in section 19-3-102, 3.8 section 3. Act subject to petition, effective date. This Act 9 takes effect at 12:01 a.m. on the day following the expiration of the 90-day period after final adjournment of the General Assembly, August 11, 2020, if adjournment signed die is on May 6, 2020, except that, if a 12 referendum petition is filed pursuant to section 1, 3, of Article V of the 13th state constitution against this act or an item, section, or part of this Act 14 within such period, then the act, item, section, or part will not take effect 15 unless approved by the people at the general election to be held in 16 November 2020 and, in such case, will take effect on the date of the 17 official declaration of the vote thereon by the governor. 18 HB 20-1147-4.
Is there any further discussion on House Bill 1147? Representative Singer.
Thank you, Madam Chair. Members, I want to thank the bill sponsors for the work that they put together on this bill. It is very hard to change what happens in our child abuse statute because these are very tough conversations. But I want to make it very clear, just given what's been said in the media about this issue and these bills, that caseworkers do not traumatize kids and families every single time they go out there. They are there to help. These are primarily young women in their 20s who are trying to do what's best for Colorado's kids and actually help them stay together with their families. This bill is a great example of bringing together both sides of an issue to make sure we don't undershoot or overshoot what ultimately involves the safety of our kids. And so I want to thank the bill sponsors for what they put together here today, and also say thank you to the caseworkers that are doing their best every day to make these tough judgment calls under a magnifying glass of scrutiny that most of us don't even face as elected officials. So thanks again to the bill sponsors for amending this bill, putting it in the right place, and I encourage an aye vote on House Bill 1147.
Is there any further discussion on House Bill 1147? Seeing none, the question before us is the passage of House Bill 1147. All those in favor, please say aye. Aye. Opposed, no. House Bill 1147 passes. Mr. Assistant Majority Leader.
Thank you, Madam Chair. I move to lay over Senate Bill 47 until the end of the second reading calendar.
Senate Bill 47 will be laid over at the request of the Assistant Majority Leader. Mr. Randall, please read the title to Senate Bill 48.
Senate Bill 48 by Senators Donovan and Courtroom, also Representatives Roberts and Catlin, concerning a study to consider the strengthening of the prohibition on speculative appropriations of water.
Representative Roberts.
Thank you, Madam Chair. I move Senate Bill 48, and there is no committee report.
To the bill.
Thank you, Madam Chair. Senate Bill 48 is a Water Resources Interim Committee bill. It is already illegal to appropriate water for the purposes of speculation in Colorado. However, there is feeling that given our limited water resources, and probably even more so limited going into the future, that we should take a look at our laws and make sure they're as strong as possible to protect against water speculation. This bill will set up a task force in order to do that under the Department of Natural Resources and report back to the Water Committee so that we can make sure we're keeping our laws as up to date as possible. It has no fiscal note and has been unanimous thus far, and would ask for an aye vote.
Representative Catlin.
Thank you, Madam Chair. It's an honor to serve with you.
It's an honor to serve with you, sir.
Thank you. You know, in our Constitution of the state of Colorado, it says that speculation on water will not be acceptable, will not be legal. In 1876, they knew that. They've made arrangements for that. But now in 2020 vision?
It is 2020.
2020,
we are starting to find there are new and different ways of being able to speculate on things. And one of the ways would be to buy a piece of land and hold that piece of land until there's an opportunity to do something with the water specific. I understand the private property issues, but here's one of the things that we're not talking about, and that's the value to the community. So this is an opportunity for the state of Colorado to take a look at how things have changed in our marketplace as we've moved forward with more people, with more ways of figuring it out. This is an opportunity for the state of Colorado to get ready for the future that we're looking at. It's a good bill. Vote yes.
Is there any further discussion on Senate Bill 48? Representative Williams.
Thank you, Madam Chair. Please have this bill read at length.
Second regular session 72nd General Assembly State of Colorado reengrossed. This version includes all amendments adopted in the House of Introduction LLS No. 20-0330.02 Thomas Morris X 4218 Senate Bill 20-048 Senate Committees House Committees Agriculture and Natural Resources A bill for an act concerning a study to consider the strengthening of the 101 prohibition on speculative appropriations of water. 102 Bill Summary. Note, this summary applies to this bill as introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes third reading in the House of Introduction, a bill summary that applies to the reengrossed version of this bill will be available at http://lake.colorado.gov/. Water Resources Review Committee. Current law specifies that an appropriation of water cannot be based on speculation, as evidenced by either of the following. The applicant does not have either a legally vested interest or a reasonable expectation of procuring such an interest in the lands or facilities to be served by the appropriation. Senate third reading unamended January 29, 2020. Senate second reading unamended January 28, 2020. Senate sponsorship Donovan and Courtroom, Bridges, Crowder, Fields, Gonzalez, Hill, Heisey, Lee, Moreno, Tate. House sponsorship Roberts and Catlin, Arndt. Tie-tone shading denotes House amendment. Double underlining denotes Senate amendment. Capital letters or bold and italic numbers indicate new material to be added to existing statute. Dashes through the words indicate deletions from existing statute. Unless the appropriator is a governmental agency or an agent in fact for the persons proposed to be benefited by the appropriation, or the applicant does not have a specific plan and intent to divert, store, or otherwise capture, possess, and control a specific quantity of water for specific beneficial uses. The bill requires the Executive Director of the Department of Natural Resources to convene a work group to explore ways to strengthen current anti-speculation law and to report to the Water Resources Review Committee by August 15, 2021, regarding any recommended changes. Be it enacted by the General Assembly of the State of Colorado 1 Section 1. In Colorado Revised Statutes, 37-98-103, add 8.2 as follows. 337-98-103. Annual Recommendations, Bill Limitation -4 Deadlines for Introduction, Repeal. 8.a. The Executive Director 5 of the Department of Natural Resources shall convene a Work 6 group during the 2020 interim to explore ways to strengthen 7 current water anti-speculation law. The Department and the 8 Attorney General shall support the efforts of the work group. 9. B. The work group consists of current or former 10 employees of the department from the State Engineer's Office 11 and the Colorado Water Conservation Board appointed by the 12 Executive Director, 1 or more current employees of the 13 Attorney General's Office appointed by the Attorney General 14 1 or more current or former employees of the Judicial 15 Department appointed by the Chief Justice of the Supreme Court 16 and such other stakeholders as the Executive Director 17 determines would be helpful to promote the work group process 18 or work product. Point 19. C. The work group shall submit a written report to the 20048-2. 15, 2021, regarding any recommended 1 changes. Point 2. D. This subsection, 8, is repealed, effective September 1, 3, 2022.4 Section 2. Act subject to petition, effective date. This Act 5 takes effect at 12:01 a.m. on the day following the expiration of the 690-day period after final adjournment of the General Assembly, August 7, 2020, if adjournment signed die is on May 6, 2020, except that, if a referendum petition is filed pursuant to Section 1, 3, of Article V of the 9-state Constitution against this Act or an item, section, or part of this Act 10 within such period, then the Act, item, section, or part will not take effect 11 unless approved by the people at the general election to be held in 12 November 2020 and, in such case, will take effect on the date of the 13th official declaration of the vote thereon by the Governor. Point 14048-3.
Is there any further discussion on Senate Bill 48? Seeing none, the question before us is the passage of Senate Bill 48. All those in favor, please say aye. Aye. Opposed, no. Senate Bill 48 passes. Mr. Randall, please read the title of House Bill 1300.
House Bill 1300 by Representatives Buenteo and Pelton, also Senators Bridges and Corum, concerning technical changes to the local school fund purchasing program.
Representative Buenteo to the bill.
Thank you, Madam Chair. Well, you know, the best laid plans in the entire world and the best of intentions, et cetera, you know what they say about them. This is a cleanup bill. Some of you guys might remember one of our greatest hits last year is the local school food purchasing program. Essentially, we passed a bill to incentivize school districts to buy local produce and local beef. And there's just 5 lines in there that need some cleaning up, and the clock's a-ticking because this program's supposed to be implemented March 1st. So with that, I urge an aye vote.
Representative Pelton, would you like to move the bill, please?
Yes, thank you, Madam Chair. I move House Bill 1300.
1300.
To the committee of the
Yes, to the committee.
To the committee of the whole. One of these years, maybe I'll get it.
It's all good.
Maybe. Again, this is a very good local producer bill, a good ag bill, and ultimately it's for the kids. So good bill, vote yes.
Is there any further discussion on House Bill 1300? Any other discussion? Representative Williams.
Thank you, Madam Chair, and I do appreciate the bill sponsors. It does sound like a great bill, but nonetheless, please have the bill read at length.
Second regular session 72nd General Assembly State of Colorado introduced LLS No. 20-0703.01 Jerry Berry X 4341 House Bill 20-1300 House Committees Senate Committees Rural Affairs and Agriculture Appropriations A bill for an act concerning technical changes to the local school food 101 purchasing program. Point 102 Bill Summary. Note, this summary applies to this bill as introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes third reading in the House of Introduction, a bill summary that applies to the re-engrossed version of this bill will be available at http://leg.colorado.government. For the local school food purchasing program, the bill makes technical changes to when a local education provider may apply to the program and when the Department of Education, selects providers. Requires the department to ensure geographic and district pupil size diversity among providers. House sponsorship Buentello, Senate sponsorship Bridges and Corum, shading denotes House amendment. Double underlining denotes Senate amendment. Capital letters or bold and italic numbers indicate new material to be added to existing statute. Dashes through the words indicate deletions from existing statute. Changes the limit for the number of lunches that all local education providers provided in the prior year to 10 million. Changes the reimbursement formula to 5 cents for every meal that the local education provider provided in the previous year, and specifies that if the department does not spend the full appropriation for the program, up to 5% of the appropriation is available to the department in the following year to pay for the required evaluation and report. Be it enacted by the General Assembly of the State of Colorado 1 Section 1. In Colorado Revised Statutes, 22-100-102, amend 2, 2A, 2B, and 3, and add 6, as follows 322-100-102. Local School Food Purchasing Program, Creation 4, Rules, Report. 2A, on or before December 1, 2019, and on or before 5 December 1 of any year thereafter, a school district, charter school, Board 6 of Cooperative Services that operates a public school or residential child 7 care center may apply to the department on a form developed by the 8 department to participate in the school food purchasing program. To 9, receive reimbursement for the purchase of Colorado grown, raised, or 10 processed products pursuant to the section .11 b I on or before March 1st, 2020, and on or before each March 12 thereafter. The department shall select participating providers. The 13 department shall select participating providers that, in the previous year 14 for which numbers are available, the total number of lunches provided by 15 all participating providers was 10 million or fewer, and no 16 participating provider may have provided more than 2,017,150,000 school lunches in the previous year. 18. 2. The department shall give preference to applicants that 19 HB 20-1300-2. I. Demonstrate a commitment to local purchasing or food and 1 agricultural education. 2. B. Have a kitchen with the ability to store, prepare, and serve 3 local food products. 4. 3. C. Have greater than 25% of its their 5 students eligible for free or reduced price lunch pursuant to the Provision 6 of the Federal Richard B. Russell National School Lunch Act, 42 U.S.C.7 Sector 1751 ETSEQ, and 8. D. Served fewer than 1,259,000 school lunches in the previous year's count, and 10. 4. E. Satisfy any other eligibility requirements established by 11 the State Board of Education by Rule Department. 12. 3. To the extent possible, in selecting participating 13 providers, the department shall ensure diversity in geographic 14 location and district pupil count. 15. 3. A. I. In October 2020 and each October thereafter, the 16 department shall reimburse each participating provider participating in the 17 school food purchasing program. As of the previous December 1st for the 18 amount spent for meals for students on Colorado grown, raised, or 19 processed products, up to the maximum incentive established pursuant to 20 subsection 3. B. Of this section, 5 cents for every school lunch 21 that the participating provider provided in the previous school 22 year, except that a participating provider shall not be reimbursed for the 23 amount of value-added processed products that exceeds 20-5 24% of the total of the Colorado grown, raised, or processed products 25 at purchase. 26. 2. Notwithstanding the provisions of subsection 3. A. I. Of this 27 HB 20-1300-3. The maximum amount of reimbursements that may be awarded in any year is $500,000. If the total of all eligible to reimbursements as calculated under subsection 3. A. I. Of this section 3 exceeds $500,000, each participating provider S4 reimbursement amount must be reduced proportionately. 5. B. Each participating provider is entitled to be reimbursed for an 6 amount up to the number of school lunches provided by the participating 7 provider as reported to the department pursuant to subsection 2 of this 8 section, divided by the total number of lunches reported by all 9 participating providers, multiplied by the total appropriation for the 10 school food purchasing program for participating providers. 11. 6. If in any fiscal year the department does not expend or 12 encumber the full amount of the appropriation for the school 13 food purchasing program, up to 5% of the appropriation 14 is available to the department in the next fiscal year to pay for 15 the evaluation required by section 22-100-104, 1, E. Point 16 section 2. Safety clause. The General Assembly hereby finds 17 determines and declares that this act is necessary for the immediate 18 preservation of the public peace, health, or safety. 19 HB 20-1300-4.
Is there any further discussion on House Bill 1300? Seeing none, the question before us is the passage of House Bill 1300. All those in favor, please say aye. Opposed, no. House Bill 1300 passes. Mr. Randall, please read the title to Senate Bill 100.
Senate Bill 100 by Senators Gonzalez and Tate, also Representatives Arndt and Benavides, concerning the repeal of the death penalty by the General Assembly in all circumstances charged on or after July 1st, 2020.
Representative Arndt.
Thank you, Madam Chair. It is with profound respect that I move Senate Bill 2100.
To the bill. Representative Arndt.
Thank you, Madam Chair. Members, it's just, I'm going to say one thing, and I'm going to say that it is my heartfelt and long-held opinion that the death penalty shall be repealed in the state of Colorado.
Representative Benavides.
Thank you, Madam Chair. And members, this is a bill that is a really heavy, gut-wrenching bill, so we hope that everyone will be respectful of all the speakers that come up. With that, there were changes made to the bill in the Senate that are very important changes, particularly at the onset of the bill. So I ask that the bill be read at length so everyone can maybe follow along and understand what's in the bill.
Second Regular Session 72nd General Assembly State of Colorado Reengrossed. This version includes all amendments adopted in the House of Introduction LLS No. 20-0009.01 Michael Dorr X 4347 Senate Bill 20-100 Senate Committees House Committees Judiciary A Bill for an Act concerning the repeal of the death penalty by the General 101 Assembly in all circumstances charged on or after 102 July 1, 2020.103 Bill Summary. Note, this summary applies to introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes third reading in the House of Introduction, a bill summary that applies to the re-engrossed version of this bill will be available at http://leg.colorado.government. The bill repeals the death penalty in Colorado for offenses charged on or after July 1, 2020, and makes conforming amendments. Senate third reading unamended January 31, 2020 Senate amended second reading January 30, 2020 Senate sponsorship Gonzalez and Tate, Williams A., Garcia, Bridges, Hill, Priola, Rodriguez, Donovan, Fenberg, Hansen, Lee, Moreno House sponsorship Arndt and Benavidez, shading denotes House amendment. Double underlining denotes Senate amendment. Capital letters or bold and italic numbers indicate new material to be added to existing statute. Dashes through the words indicate deletions from existing statute. Be it enacted by the General Assembly of the State of Colorado 1 Section 1. In Colorado Revised Statutes, add Part 9 to Article 211 of Title 16 as follows: 3 Part 94 Repeal of the Death Penalty 516-11-901. Death Penalty Repeal, Applicability, Current 6 Sentences. For offenses charged on or after July 1, 2020, the 7 death penalty is not a sentencing option for a defendant 8 convicted of a Class 1 felony in the state of Colorado. Nothing 9 in this section commutes or alters the sentence of a defendant 10 convicted of an offense charged prior to July 1, 2020. This 11 section does not apply to a person currently serving a death 12 sentence. Any death sentence in effect on July 1, 2020 is valid. Point 13 Section 2. In Colorado Revised Statutes, 13-4-102, amend 14, 1H, as follows: 1513-4-102. Jurisdiction. 1. Any provision of law to the contrary 16 notwithstanding, the Court of Appeals shall have initial jurisdiction over 17 appeals from final judgments of, and interlocutory appeals of certified 18 questions of law in civil cases pursuant to Section 13-4-102.1 from, the 19 district courts, the probate court of the City and County of Denver, and the 20 juvenile court of the City and County of Denver, except in 21H, cases appealed from the district court granting or denying 22 post-conviction relief. In a case in which a sentence of death has been 23 imposed for an offense charged prior to July 1, 2020.24 Section 3. In Colorado Revised Statutes, 16-8-103.6, amend 25, 1A, and 2A, as follows: 2616-8-103.6. Waiver of privilege. 1A. A defendant who places 27-100 to 2. Mental condition at issue by pleading not guilty by reason of 1 insanity pursuant to Section 16-8-103, or asserting the affirmative 2 defense of impaired mental condition pursuant to Section 16-8-103.5, or 3 disclosing witnesses who may provide evidence concerning the 4 defendants' mental condition during a sentencing hearing held pursuant 5 to Section 18-1.3-1201 or 18-1.3-1302. CRS Section 18-1.3-1201 for 6 an offense charged prior to July 1, 2020, or pursuant to Section 718-1.3-1302. For an offense charged prior to July 1, 2020, waives 8 any claim of confidentiality or privilege as to communications made by 9 the defendant to a physician or psychologist in the course of an 10 examination or treatment for such the mental condition for the purpose 11 of any trial or hearing on the issue of such the mental condition, or 12 sentencing hearing conducted pursuant to Section 18-1.3-1201 or 1318-1.3-1302. CRS Section 18-1.3-1201 for an offense charged 14 prior to July 1, 2020, or pursuant to Section 18-1.3-1302 for an 15 offense charged prior to July 1, 2020. The court shall order both the 16 prosecutor and the defendant to exchange the names, addresses, Report 17 and statements of any physician or psychologist who has examined or 18 treated the defendant for such the mental condition. Point 19, 2a. A defendant who places his or her mental condition at issue 20 by pleading not guilty by reason of insanity pursuant to Section 16-8-10321 or disclosing witnesses who may provide evidence concerning the 22 defendants' mental condition during a sentencing hearing held pursuant 23 to Section 18-1.3-1201 or 18-1.4-102. CRS Section 18-1.3-1201 for 24 an offense charged prior to July 1, 2020, or pursuant to Section 2518-1.4-102, or, for offenses committed on or after July 1, 1999, by 26 seeking to introduce evidence concerning his or her mental condition 27-100-3. Pursuant to Section 16-8-107, 3, waives any claim of confidentiality or one privilege as to communications made by the defendant to a physician or to psychologist in the course of an examination or treatment for such the 3 mental condition for the purpose of any trial or hearing on the issue of for such the mental condition, or sentencing hearing conducted pursuant to 5 Section 18-1.3-1201 or 18-1.4-102, CRS Section 18-1.3-1201 for and 6 offense charged prior to July 1, 2020, or pursuant to Section 7. 18-1.4-102 the court shall order both the prosecutor and the defendant aid to exchange the names, addresses, reports, and statements of any 9 physician or psychologist who has examined or treated the defendant for 10 such the mental condition. Point 11 Section 4. In Colorado Revised Statutes, 16-8-106, Amend 12, 2, C, 3, B, 6, Introductory Portion, 6, B, 7, Introductory Portion 13 and 7, B, as follows 1416-8-106. Examinations and report. 2. C. The defendant shall 15 cooperate with psychiatrists, forensic psychologists, and other personnel 16 conducting any examination ordered by the court pursuant to the section. 17 Statements made by the defendant in the course of such the examination 18 shall be protected as provided in section 16-8-107. If the defendant does 19 not cooperate with psychiatrists, forensic psychologists, and other 20 personnel conducting the examination, the court shall not allow the 21 defendant to call any psychiatrist, forensic psychologist, or other expert 22 witness to provide evidence at the defendant's trial concerning the 23 defendant's mental condition including, but not limited to, providing 24 evidence on the issue of insanity or at any sentencing hearing held 25 pursuant to section 18-1.3-1201 or 18-1.4-102. CRS Section 2618-1.3-1201 for an offense charged prior to July 1, 2020, or 27-100-4. Pursuant to Section 18-1.4-102. In addition, the fact of the defendant S1 non-cooperation with psychiatrists, forensic psychologists, and other 2 personnel conducting the examination may be admissible in the 3 defendants' trial to rebut any evidence introduced by the defendant with regard to the defendant's mental condition including, but not limited to 5 the issue of insanity and in any sentencing hearing held pursuant to 6 Section 18-1.3-1201 or 18-1.4-102. CRS Section 18-1.3-1201 for and 7 offense charged prior to July 1, 2020, or pursuant to Section 818-1.4-102. This paragraph, C, shall apply subsection 2, C, applies to 9 offenses committed on or after July 1, 1999.10, 3, B, to aid in forming an opinion as to the mental condition of 11 the defendant. It is permissible in the course of an examination under this 12 section to use confessions and admissions of the defendant and any other 13 evidence of the circumstances surrounding the commission of the offense 14 as well as the medical and social history of the defendant, in questioning 15 the defendant. When the defendant is non-cooperative with psychiatrists 16 forensic psychologists, and other personnel conducting the examination 17 an opinion of the mental condition of the defendant may be rendered by 18 such psychiatrists, forensic psychologists, or other personnel based upon 19 such confessions, admissions, and any other evidence of the 20 circumstances surrounding the commission of the offense, as well as the 21 known medical and social history of the defendant, and such opinion may 22 be admissible into evidence at trial and in any sentencing hearing held 23 pursuant to section 18-1.3-1201 or 18-1.4-102, CRS section 2418-1.3-1201 for an offense charged prior to July 1, 2020, or 25 pursuant to section 18-1.4-102. It shall also be permissible to conduct 26 a narcoanalytic interview of the defendant with such drugs as are 27-100-5. And to subject the defendant to polygraph 1 examination. In any trial or hearing on the issue of the defendant's sanity 2 or eligibility for release, and in any sentencing hearing held pursuant to 3 section 18-1.3-1201 or 18-1.4-102, CRS section 18-1.3-1201 for and 4 offense charged prior to July 1, 2020, or pursuant to section 518-1.4-102, the physicians and other personnel conducting the 6th examination may testify to the results of any such procedures and the 7 statements and reactions of the defendant insofar as the same entered into 8 the formation of their opinions as to the mental condition of the defendant 9 both at the time of the commission of the alleged offense and at the present time. This paragraph, B, shall apply subsection 3, B, applies 11 to offenses committed on or after July 1, 1995.12, 6, with respect to offenses committed on or after July 1, 1995,13 The report of examination shall include, but is not limited to, the items 14 described in paragraphs A, 2, C, of subsection 5, subsections 5A, 15, 5B, and 5C of this section, and 16B, separate opinions as to whether the defendant was insane or 17 is ineligible for release, as those terms are defined in this Article 18.8, and, in any Class 1 felony case for an offense charged prior to 19 July 1, 2020, an opinion as to how the mental disease or defect or the 20 condition of mind caused by mental disease or defect affects any 21 mitigating factor. The nature of the opinions required depends upon the 22 type of examination ordered by the court. 23, 7, with respect to offenses committed on or after July 1, 1999, 24 when a defendant has undergone an examination pursuant to the 25 provisions of this section because the defendant has given notice pursuant 26 to section 16-8-107, 3, that he or she intends to introduce expert opinion 27-100-6. Concerning his or her mental condition, the report of one examination shall include, but is not limited to, the items described in 2 paragraphs, A, 2, C, of subsection 5, subsections 5A, 5B, and 3, 5C, of this section, and 4B, separate opinions as to the defendant's mental condition 5 including, but not limited to, whether the defendant was insane or is 6 ineligible for release, as those terms are defined in this article, Article 8.7, and, in any Class 1 felony case for an offense charged prior to July 8, 2020, an opinion as to how the mental disease or defect or the 9 condition of mind caused by mental disease or defect affects any 10 mitigating factor. The nature of the opinions required depends upon the 11 type of examination ordered by the court. 12 Section 5. In Colorado Revised Statutes, 16-8-107, amend 13, 1B, 1C, and 1.5B, as follows: 1416-8-107. Evidence. 1B. Evidence acquired directly or 15 indirectly for the first time from a communication derived from the 16 defendants' mental processes during the course of a court-ordered 17 examination under Section 16-8-108 or acquired pursuant to Section 1816-8-103.6 is admissible at any sentencing hearing held pursuant to 19 Section 18-1.3-1201, 18-1.3-1302, or 18-1.4-102. CRS Section 2018-1.3-1201 for an offense charged prior to July 1, 2020, or 21 pursuant to Section 18-1.3-1302 for an offense charged prior to 22 July 1, 2020, or pursuant to Section 18-1.4-102 only to prove the 23 existence or absence of any mitigating factor. 24. C. If the defendant testifies in his or her own behalf upon the trial 25 of the issues raised by the plea of not guilty, or at a sentencing hearing 26 held pursuant to Section 18-1.3-1201, 18-1.3-1302, or 18-1.4-102, C.R.S.27-100-7. Section 18-1.3-1201 for an offense charged prior to July 1, 2020, 1 or pursuant to Section 18-1.3-1302 for an offense charged prior to July 1, 2020, or pursuant to Section 18-1.4-102. The provisions of 3. The section shall not bar any evidence used to impeach or rebut the 4 defendants' testimony. 5. 1.5b. Evidence acquired directly or indirectly for the first time. 6. From a communication derived from the defendant's mental processes. 7. During the course of a court-ordered examination under Section 16-8-1068 or acquired pursuant to Section 16-8-103.6 is admissible at any sentencing hearing held pursuant to Section 18-1.3-1201 or 18-1.4-102. C.R.S.10 Section 18-1.3-1201 for an offense charged prior to July 1, 2020, 11 or pursuant to Section 18-1.4-102 only to prove the existence or 12 absence of any mitigating factor. 13 Section 6. In Colorado Revised Statutes, 16-8.5-103, amend 14, 8, as follows: 1516-8.5-103. Determination of competency to proceed. 8. If the 16 question of the defendant's incompetency to proceed is raised after a jury 17 is impaneled to try the issues raised by a plea of not guilty and the court 18 determines that the defendant is incompetent to proceed or orders a 19 court-ordered competency evaluation, the court may declare a mistrial. 20 Declaration of a mistrial under these circumstances does not constitute 21 jeopardy, nor does it prohibit the trial or sentencing or execution of the 22 defendant for the same offense after he or she has been found restored to 23 competency. 24 Section 7. In Colorado Revised Statutes, 16-8.5-108, amend 25, 1b, and 1c, as follows: 2616-8.5-108. Evidence. 1b. Evidence acquired directly or 27-100-8. For the first time from a communication derived from the one defendant's mental processes during the course of a competency to evaluation or involuntary medication proceeding is admissible at any sentencing hearing held pursuant to Section 18-1.3-1201, 18-1.3-1302, or 418-1.4-102, CRS Section 18-1.3-1201 for an offense charged prior 5 to July 1, 2020, or pursuant to Section 18-1.3-1302 for an offense 6 charged prior to July 1, 2020, or pursuant to Section 18-1.4-1027 only to prove the existence or absence of any mitigating factor. Point 8, c. If the defendant testifies on his or her own behalf upon the trial 9 of the issues raised by the plea of not guilty, or, for offenses that occurred 10 before July 1, 1995, a plea of not guilty by reason of impaired mental 11 condition, or at a sentencing hearing held pursuant to Section 1218-1.3-1201, 18-1.3-1302, or 18-1.4-102, CRS Section 18-1.3-120113 for an offense charged prior to July 1, 2020, or pursuant to 14 Section 18-1.3-1302 for an offense charged prior to July 1, 2020, 15, or pursuant to Section 18-1.4-102. The provisions of this section shall 16 not bar any evidence used to impeach or rebut the defendant's testimony. Point 17, Section 8. In Colorado Revised Statutes, 18-1-409, amend 1-18 as follows: 1918-1-409. Appellate review of sentence for a felony. 1. When 20A sentence is imposed upon any person following a conviction of any 21 felony, other than a Class 1 felony in which a death sentence is 22, automatically reviewed pursuant to Section 18-1.3-1201, 6, for an 23 offense charged prior to July 1, 2020, or pursuant to Section 2418-1.3-1302, 6, for an offense charged prior to July 1, 2020, or 25 pursuant to Section 18-1.4-102, 6, the person convicted shall have the 26th right to one appellate review of the propriety of the sentence, having 27. 100-9. Regard to the nature of the offense, the character of the offender, and the one public interest, and the manner in which the sentence was imposed to, including the sufficiency and accuracy of the information on which it was based, except that, if the sentence is within a range agreed upon by the 4 parties pursuant to a plea agreement, the defendant shall not have the 5 right of appellate review of the propriety of the sentence. The procedures 6 to be employed in the review shall be as provided by Supreme Court Rule. Point 7, Section 9. In Colorado Revised Statutes, 18-1.3-104, amend 8-1, introductory portion, and 1-c, as follows: 918-1.3-104. Alternatives in imposition of sentence. 1. Within 10 the limitations of the applicable statute pertaining to sentencing, and 11 subject to the provisions of this title. Title 18, the trial court has the 12 following alternatives in entering judgment imposing a sentence. 13, c. The defendant shall be sentenced to death in those cases in 14 which a death sentence is required under pursuant to Section 1518-1.3-1201 for an offense charged prior to July 1, 2020, or 16 pursuant to Section 18-1.3-1302 for an offense charged prior to 17 July 1, 2020, or pursuant to Section 18-1.4-102.18 Section 10. In Colorado Revised Statutes, 18-1.3-401, amend 19-1-A, V, A.1, and 4-A, and add 1-A, V, F, and 1-A, V.5, as 20 follows: 2118-1.3-401. Felonies classified, presumptive penalties. Point 22, 1-A, V, A.1, subject to the provisions of subsection 23, 1-A, V, F, of this section, as to any person sentenced for a felony 24 committed on or after July 1, 2018, and prior to July 1, 2020, felonies 25 are divided into 6 classes that are distinguished from one another by the 26 following presumptive ranges of penalties that are authorized upon 27 100 to 10. Class minimum maximum mandatory period 2 sentence of parole 3 1 life imprisonment death none 4 2 8 years 24 years 5 years if the offense 5 imprisonment is a crime of violence 6 as described in section 718-1.3-406 2 8 3 years if the offense 9 is not a crime of 10 violence as described 11 in section 18-1.3-40612, 2, 13 3 4 years 12 years 3 years 14 imprisonment 15 4 2 years 6 years 3 years 16 imprisonment 17 5 1 year 3 years 2 years 18 imprisonment 19 6 1 year 18 months 1 year 20 imprisonment 21 F. Notwithstanding any other provision to the contrary 22 the maximum sentence for a Class 1 felony that is charged after 23 July 1, 2020, is life imprisonment. 24, v.5, a. As to any person sentenced for a felony for an 25 offense committed on or after July 1, 2020, felonies are divided 26 into 6 classes that are distinguished from one another by the 27 to 11. Following presumptive ranges of penalties that are authorized: 1 upon conviction, 2 class minimum maximum mandatory, 3 sentence period, 4 of parole, 5 1 life imprisonment, none 6 2 8 years 24 years 5 years if 7 imprisonment offense is a 8 crime of 9 violence as 10 described in 11. Section 1218-1.3-406, 2, 13 3 years 14 if the offense 15 is not a crime, 16 of violence, 17 as described 18 in section 1918-1.3-406, 2, 23 4 years 12 years 3 years 21 imprisonment 22 4 2 years 6 years 3 years 23 imprisonment 24 5 1 year 3 years 2 years 25 imprisonment 26 6 1 year 18 months 1 year 27 100 to 12. Imprisonment 1, b. Any person who is paroled pursuant to section 217-22.5-403, or any person who is not paroled and is discharged 3 pursuant to law, shall be subject to the mandatory period of 4 parole established pursuant to subsection 1, a, v.5, a, of this 5 section. Such mandatory period of parole may not be waived by 6 the offender or waived or suspended by the court, and shall be 7 subject to the provisions of section 17-22.5-403, 8, which permits 8 the State Board of Parole to discharge the offender at any time, 9 during the term of parole upon a determination that the 10 offender has been sufficiently rehabilitated and reintegrated 11 into society and can no longer benefit from parole supervision. 12, c. Notwithstanding the provisions of subsection 13, 1, a, v.5, a, of this section, any person sentenced for a Sex 14 offense, as defined in section 18-1.3-1003, 5, committed on or 15 after July 1, 2020, shall be sentenced pursuant to the provision 16 of Part 10 of this article January 3, 17, d. Any person sentenced for a felony conviction entered 18 on or after July 1, 2020, involving unlawful sexual behavior, as 19 defined in section 16-22-102, 9, or for a felony committed on or 20 after July 1, 2020, the underlying factual basis of which 21 involved unlawful sexual behavior, and who is not subject to 22 the provisions of Part 10 of this article 1.3, shall be subject to 23 the mandatory period of parole specified in subsection 24, 1, a, v.5, a, of this section. 25, e, the mandatory period of parole imposed pursuant to 26 subsection 1, a, v.5, a, of this section shall commence 27 to 13. Immediately on the discharge of an offender from 1 imprisonment in the custody of the Department of Corrections. 2 If the offender has been granted release to parole supervision 3 by the State Board of Parole, the offender shall be deemed to 4 have discharged the offender's sentence to imprisonment 5 provided for in subsection 1, a, v.5, a, of this section in the 6 same manner as if such sentence were discharged pursuant to 7 law, except that the sentence to imprisonment for any person 8 sentenced as a sex offender pursuant to Part 10 of this Article 9 1.3 shall not be deemed discharged on release of said person on 10 parole. When an offender is released by the State Board of 11 parole or released because the offender's sentence was 12 discharged pursuant to law, the mandatory period of parole 13 shall be served by such offender. An offender sentenced for a 14 nonviolent felony offense, as defined in section 17-22.5-405, 5, 15 may receive earned time pursuant to section 17-22.5-405 while 16 serving a mandatory parole period in accordance with this 17th section, but not while such offender is reincarcerated after a 18 revocation of the mandatory period of parole. An offender 19 shall be eligible to receive earned time while on parole or after 20 re-parole following a parole revocation. The offender shall not 21 be eligible for earned time while the offender is reincarcerated 22 after revocation of the mandatory period of parole pursuant to 23 the subsection 1, a, v.5, point 24, f, if an offender is sentenced consecutively for the 25 commission of 2 or more felony offenses pursuant to 26 subsection 1, a, v.5, a, of this section, the mandatory period of 27 100 to 14. Such offender shall be the mandatory period of 1 parole established for the highest class felony of which such 2 offender has been convicted. 3, 4, a person who has been convicted of a Class 1 felony 4 shall be punished by life imprisonment in the Department of Corrections. 5, unless the offense was charged prior to July 1, 2020, and a 6 proceeding held to determine sentence according to the procedure set 7 forth in Section 18-1.3-1201, 18-1.3-1302, or 18-1.4-102 results in a verdict that requires imposition of the death penalty, in which event such 9 persons shall be sentenced to death. 10. 2. A person who has been convicted of a Class 1 felony 11 shall be punished by life imprisonment in the Department of 12 Corrections if the offense was committed during a period of time. 13. When Colorado's death penalty was unconstitutional. 14. 3. As to any person sentenced for a Class 1 felony, for an Act 15 committed on or after July 1, 1985, and before July 1, 1990, life. 16. Imprisonment shall mean imprisonment without the possibility of parole. 17. For 40 calendar years. As to any person sentenced for a Class 1 felony. 18. For an act committed on or after July 1, 1990, life imprisonment shall 19 mean imprisonment without the possibility of parole. 20. Section 11. In Colorado Revised Statutes, 18-1.3-801, amend 21, 1, e, as follows. 22. 18-1.3-801. Punishment for habitual criminals. 1, e, nothing. 23. In the subsection, 1, is to be construed to prohibit a person convicted of 24 a Class 1 felony from being sentenced pursuant to Section 18-1.3-120125 for an offense charged prior to July 1, 2020, or pursuant to 26 Section 18-1.3-1302 for an offense charged prior to July 1, 2020, 27 100 to 15. Or Section 18-1.4-102.1 Section 12. In Colorado Revised Statutes, 18-1.3-1201, add 2, 9, as follows. 3. 18-1.3-1201. Imposition of sentence in Class 1 felonies -4 appellate review, applicability. 9. This section applies only to 5 offenses charged prior to July 1, 2020.6 Section 13. In Colorado Revised Statutes, 18-1.3-1302, add 7, 8, as follows. 8. 18-1.3-1302. Imposition of sentences in Class 1 felonies for 9 crimes committed on or after July 1, 1988, and prior to September 10, 1991, appellate review, applicability. 8. This section applies 11 only to offenses charged prior to July 1, 2020.12 Section 14. In Colorado Revised Statutes, 18-3-107, amend 13, 3, as follows. 14. 18-3-107. First-degree murder of a peace officer, firefighter. 15. Or emergency medical service provider, legislative declaration. 3. A 16-person convicted of first-degree murder of a peace officer, firefighter, or 17 emergency medical service provider shall be punished by life. 18. Imprisonment without the possibility of parole for the rest of his or her 19 natural life, unless the offense was charged prior to July 1, 2020, 20, and a proceeding held to determine sentence according to the procedure 21 set forth in Section 18-1.3-1201, 18-1.3-1302, or 18-1.4-102 results in a 22 verdict that requires imposition of the death penalty, in which event the 23 person shall be sentenced to death. Nothing in this subsection, 3, is 24 construed as limiting the power of the governor to grant reprieves. 25 commutations, and pardons pursuant to Section 7 of Article 4 of the 26 Colorado Constitution. 27 100 to 16. Section 15. Safety Clause. The General Assembly hereby finds one determines and declares that this act is necessary for the immediate preservation of the public peace, health, or safety. 3 100 to 17.
We're on Senate Bill 100. Representative Benavides.
Thank you, Madam Chair. Members, thank you for listening to the bill be read, and I just want to point out some highlights of the bill, which is, as you may have noted, there was a change to the title. The title now reads, Concerning the Repeal of the Death Penalty by the General Assembly in All Circumstances Charged on or After July 1st, 2020. So the bill also expressly on page 2 of the bill expressly does not apply to anyone currently serving a death sentence, and it changes the penalty in those cases to a maximum penalty of life without parole. Members, I think Making these crimes subject to life without parole serves the interest in the state with regard to sentencing, and I ask for a yes vote on the bill.
Representative Arndt. Okay. Mr. Minority Leader.
Thank you, Madam Chair and members. As was previously stated, this is an incredibly important discussion that we have here in the House. And I just wanted to start off this debate by actually thanking the majority party for slowing down the reading. I certainly do think that was intelligible and was done correctly. So thank you guys for contributing to a healthy process.
Representative Sane.
Thank you, Madam Chair. Members, I'm going to read you some very important words by somebody who's very involved in a quadruple homicide that happened in my district, just down the street from me. I do not refer to this defendant by name when discussing the murders of Shanann, Bella, Celeste, or Nico Watts. I don't speak that name because he is a murderer, evil to the core, and not deserving of such respect. The defendant absolutely deserved the death penalty for the horrific crimes he committed, for the manner in which he disposed of the bodies, and for the way he attempted to deceive law enforcement and the public for days. However, it was the existence of the death penalty as a possible consequence for his actions, and the strong possibility of that penalty being sought and imposed by a jury of his peers that I truly believe caused the resolution of that case. During the course of exercising my due diligence in obtaining the thoughts and wishes of all involved in that matter, law enforcement, members of my senior staff, community leaders, the defense attorneys, and the family of the victims, it became obvious and clear that I had every intention of seeking the death penalty, and how could I not, when he stuffed his daughter's bodies in 2 separate oil tanks. It was during our meeting with the defense team organized for them to offer any mitigating evidence they wished for my consideration. And they shared with me his desire to plead guilty to multiple life sentences if the death penalty was not sought. Absent that possible sentence, such an offer would have never been extended. And the reality is this: without the death penalty as a possible consequence, that case would still be pending today. No closure for the victims' families, no closure for my community, and no justice for victims. I have asked, as vile as this crime was, a plea that was reached to avoid the death penalty saved all of us from incredible misery and suffering through a protracted litigation process. Simply put, the death penalty, though not sought and imposed in this case, ensured that justice was obtained for Shanann, Bella, Celeste, and Nico. The death penalty is a tool which is essential for prosecutors in this state to use as part of our arsenal in the name of public safety, and it is used to obtain justice in the worst of the worst cases. Again, the repeal of such an important part of our arsenal in the name of public safety cannot be stripped away in the name of political achievement. If the voters of this state, through referendum, vote to abolish the death penalty, then so be it. That is the will of the people. But they have not been afforded such an opportunity, and by all polling measures will not vote that way today. Michael J. Work, District Attorney, Weld County District Attorney's Office.
Representative Carver.
Thank you, Madam Chair. Members, the gravity of the bill before you is evident. We have been debating the death penalty for many years in Colorado. And in fact, the voters twice in the last few decades have weighed in on this issue. strongly in support of the death penalty. But I want to spend my opening remarks touching on a few aspects of the death penalty process in Colorado, because there is this narrative out there that the death penalty is applied in an arbitrary fashion. That of the many homicides that are committed in Colorado, it is purely hit and miss who gets life imprisonment and who is punished with death. Members, that is not the case. And while I'm not going to go through every detail of the Colorado statute, I do want to give you an overview to show that, in fact, this is a process fully compliant with Supreme Court constitutional jurisprudence on the death penalty and the Eighth Amendment. And it is a structure to not have arbitrary decisions. And how do we do that? We start out by saying, first of all, that the death penalty is never authorized for defendants convicted of murder if they committed the murder while under age 18. We say that the death penalty is never authorized if the defendant had some level of mental incapacity or intellectual disability. So those cases are off as well. But then we also say that unless at least one aggravating factor is found, the death penalty can never be authorized by the jury or the judge. And so when a homicide is charged, the defendant has a choice in whether to do a jury trial or judge alone. If they choose a jury trial, it is also the jury that will, in a separate hearing, if the defendant is convicted of murder, there is then a separate hearing, separate evidence about whether the death penalty should be authorized. And in that second hearing, our statute says that only if the jury finds unanimously that certain aggravating factors are present, only then can the death penalty be voted and approved. What are some of those aggravating factors? The killing of a witness to a crime, which is what happened to Senator Field's son and fiancé. Their murders were ordered by individuals who had been, were already in jail serving a sentence, and Senator Field's son was a witness to murder, or this individual had been charged with it, excuse me. And this individual ordered the murder of Senator Field's son. If you want to know why those individuals got the death penalty, it's because the jury found aggravating factors. The intentional killing of a witness to a crime of violence. The killing of a police officer is an aggravating factor. The killing of multiple persons in one crime spree is an aggravating factor. The killing in particularly heinous, cruel, and barbaric ways is an aggravating factor. Members, only if aggravating factors are found by a jury unanimously, and there is proof beyond a reasonable doubt, not just to the underlying conviction of murder, but to the additional aggravating factors. The burden is on the government, proof beyond a reasonable doubt. But even then, members, the jury's task is not done in determining whether the death penalty can be authorized. If they find one or more of these aggravating factors, they still must go through a long list of mitigating factors. And if they find those mitigating factors are present, and they make specific written findings on all of these, if they find mitigating factors such as the person had mental illness or mental incapacity, even if it didn't rise to the level of insanity, that's a mitigating factor. If they found that the individual was under the influence of drugs or alcohol, there's a whole list of mitigating factors. And even in the aggravating factors, the jury is walking through, is this the first time offense? Is there criminal history of this particular defendant? Was the defendant under unusual or substantial distress when the murder was committed? Does the defendant have the capacity to appreciate the wrongfulness of their conduct? Will the defendant be a continuing threat to society? Did the defendant have the mistaken belief that circumstances existed which provided a moral justification for their action? So members, I go through this process because in Colorado, and we have struggled with the death penalty for decades. There is a long history of dealing with this issue in the Colorado Legislature, the courts, and going to the people. This is not an arbitrary process that is hit and miss on those convicted of murder and who is considered for the death penalty and when it is authorized. And if we think through some of the horrible tragedies we've had here in Colorado, and we think through the aggravating and the mitigating factors as those trials played out, we can then see why the jury made the findings that they did. Now, you can agree or disagree with that outcome, but it is not arbitrary. It is a process specifically in compliance with Supreme Court constitutional jurisprudence. I'm just going to briefly touch on, and then my colleagues will go into more detail. You know, the witnesses that appeared in the committee, very thoughtful, all in good faith. But I was struck by even those that from the DA's office in Denver and Boulder who talked in support of the bill. And we had a really good discussion about how the juries take the jury instructions, how they take this so seriously in knowing their duty in sorting through the evidence on aggravating and mitigating factors. And so, the jury, without, I'm sure on a Monday afternoon you don't want to hear about English common law and how the jury system was instituted for ordinary citizens, not the prosecutor, not the judge, picked through a governmental structure, but ordinary citizens listening to the evidence, determining guilt or innocence, and determine the just sentence. And that's what we have here in Colorado, in a way that has guardrails, in a way that, at least when I read the statute in process, we have a careful process here in Colorado. And I rise in opposition to this bill.
Representative Benavides.
Thank you, Madam Chair. And members, I just want to talk a little bit about arbitrariness, when things are arbitrary. We heard from some professors from DU. They did an analysis, a study of all of the eligible death penalty cases from 1999 to 2015 in Colorado. There were 795 what are called death-eligible cases. Of those, only 3%, 27 of those, went forward. Most of them didn't end up in a death sentence. But one of the things that the law professors in their study said, and I'll read this sentence to you. They said that prosecutors in Colorado pursued the death penalty in only 3% of eligible cases, but people of color, they were 5 times more likely to seek the death penalty against people of color than they were against white people. That's an analysis of all of the death-eligible cases between 1999 and 2015. That makes it arbitrary. They go on to say that the arbitrary and racially disparate implementation of the death penalty in Colorado is a violation in their determination of the 8th Amendment because it is arbitrary. And yes, there are a lot of aggravating factors, which makes most murder cases eligible for the death penalty. And we, as the legislature, have heard bills, over a dozen of them, that have tweaked those aggravating factors, that have installed the unitary process and the direct appeals and the mandatory appeals in these cases. Yes, we figured out how to do it, and once the case gets there, it generally follows that, unless there is other information that was withheld or that comes up after the fact. That's why there's been at least 166 people in this country who have been exonerated from a death sentence. It wasn't because the process didn't go well. It wasn't that we didn't have good laws on the books. It was because we were wrong. People make mistakes. Juries make mistakes. We heard testimony from DAs that said this death penalty cases are not consistent throughout the state, and that in and of itself should be a statewide concern. We had one DA that said she ran specifically on saying she will never bring a death penalty case. So it depends where you live. That's what makes this arbitrary. We had someone testify that if you live in Arapahoe County or across the street from Arapahoe County, you can commit the same crime and you will not be charged with the death penalty. That's what makes it arbitrary. It is not a coincidence that the 3 individuals currently serving death sentences are all black, are all from the same neighborhood, that they were all went to the same high school, that they were all charged in the same judicial district. Last year, at the hearing in the Senate, one of the DAs said, you know, really, because of the costs and all of everything involved in bringing a death case, that it becomes really only something that will be brought in counties in this state, in judicial districts, that have the ability, the financial wherewithal to do that. They testified to that. So somebody living in a smaller county or a county where a DA will not bring the case, doesn't matter what nice and precise aggravating factors, mitigating factors we have in place, it's not going to be brought consistently. That's what makes this arbitrary, not because the process is not being followed. So I would urge you to consider that. There was one other thing that was brought up, people with disabilities. You know, in 2002, the Supreme Court did rule in the Atkins case that we cannot bring a death penalty against people that are mentally ill. But guess what? In that case, out of Virginia, it's still being litigated because there's the issue of what is competence, what is not, what happens with people's mental health if they have stimulation. That case is still being brought forward. And we had a representative from ARC that testified about that. And that is different on how a determination is made depending on which doctors, which evaluators are used. So it is important to understand we can set up a nice, very nice, precise methodology, but it's still humans that are implementing that. And there is still margin for error, or those 166 people would not have been exonerated.
Representative Wiseman.
Thank you very much, Madam Chair. You know, I do want to acknowledge at the outset, my colleague from El Paso County gave what I think is a fair summary of the current statutory framework by which we attempt to sort out this question of who should live and who should die. I think the question, though, is not really the adequacy of that framework, but whether even that's enough, whether we should have even that. And what I wanted to come up here at this point to share is that even among victims and among law enforcement officials, opinions are split. And, you know, I guess I'm lucky I have not been a victim of a heinous crime like this, nor have I worked as a law enforcement official. So I'm not going to try to tell you what I think, but I am going to give voice to some of what we heard in committee and some of the testimony that we received. We heard a few minutes ago from a certain elected DA who believes in utilizing the death penalty. And I want to be very clear, nobody is for a minute forgiving or condoning the heinous crime that was spoken of here, and I'm not going to say that name either. But we did hear from elected district attorneys and some former district attorneys and some folks who work as prosecutors for those who are elected. We did hear other things. We heard from a prosecutor in one of our judicial districts in Colorado. This is just about a direct quote. As a prosecutor, my job is justice. The death penalty is not justice. We heard from another prosecutor. I do not believe the state should be in the business of killing people. Direct quote. We heard from a former prosecutor who had a bit of a different philosophy. His office did not seek the death penalty, neither did he offer plea deals in first-degree felonies. His philosophy seemed to be that it was good for the community to pursue a trial, and he would always seek to conclude them in a year so that the community could see justice being done, could see the burden of proof being met, could see the life without the possibility of parole sentence being meted out at the end of all of that. You know, those of us on judiciary at least received what I think is a pretty remarkable letter. And in case not everybody got it or has had the chance to review, I want to share part of that. Dear Colorado State legislators, we are current and former prosecutors and Department of Justice officials who currently work, live, or have worked in Colorado. It goes on. Some have said that without the death penalty, prosecutors will be disadvantaged in their ability to negotiate plea bargains and that this will lead to additional expense. We find this notion to be deeply troubling. Whatever one may think about the merits of the death penalty, using this ultimate sanction as a threat to leverage pleas is both unethical and may increase the instances of unjust and unreliable convictions. Recent reports have underscored that these concerns are more than theoretical. More than 25% of DNA exonerations are the result of a false confession or incriminating statements by innocent defendants. It goes on. Numerous studies have shown that using the death penalty to obtain pleas does not result in cost savings. While obtaining pleas can eliminate the costs associated with a trial, even these savings pale in comparison with the costs of preparing for a death penalty prosecution, even if it never goes to trial. It goes on. Our experience as prosecutors has shown us that whatever one thinks about the death penalty, it is simply wrong to use it as a tool or threat to coerce a plea. That is not justice, and it is not what our system of laws should embrace. This letter was signed by 27 law enforcement officials who live in Colorado in different places. One other detail to note about the mechanics of prosecution is that even in a jurisdiction where the elected district attorney has chosen in his or her discretion to never seek this penalty, having it on the books requires time, requires work of those in the office. They have to go through the statutes that my colleague from El Paso County alluded to. They have to do what's called a proportionality review. They have to at least start to evaluate the question, where does this offense rank in all of the criteria? Because their work may be looked at down the road by another prosecutor, or even by a court. So even where it is never sought, having this penalty on the books imposes an operational cost on our system. I also want to share, and I deeply respect that opinions are personally held and vary on this subject, but I want to share that there is a variety of opinion among victims, among people whose families have been marked and touched in the most horrible way by these most horrible offenses. And another letter that we got is also quite remarkable, and I'm going to read from it. Each of us has had a loved one taken from us by senseless violence. At a moment none of us could have predicted or prepared for, tragedy robbed from us children, parents, spouses, siblings, and other family members. Our direct experiences with the criminal justice system and our struggles with grief have all led us to the same conclusion. Colorado's death penalty fails victims' families. We never asked to be in this position and would do anything to change it. Nothing can erase the pain that a senseless act of violence brought into our lives, but we can honor the memory of our loved ones and other families who may face tragedy by working for effective responses to violence. The reality of the death penalty is that it drags on for decades. In Colorado, only one person has been executed in more than 50 years. Victims' families in capital cases go back to court for years on end, where the press replays the details of the crime again and again. The result is that the defendant is turned into a celebrity while the victim's family waits for justice that never comes. This system burdens the justice system, taking resources from both programs that are proven to improve public safety and also from solving over 1,300 homicide cold cases in Colorado. The death penalty is said to be reserved for particularly heinous murders. We have difficulty understanding this position. The implication is that other murders are ordinary. From experience, we can tell you that every murder is heinous to the family of the victim. As Colorado holds on to its broken death penalty system, cherry-picking cases to receive the disproportionate attention and resources of a capital trial, it wastes millions of dollars that could be spent on policies that benefit all victims. Or as one of the prosecutors that we heard from in committee last week put it, who works with victims in her job on a regular basis, every victim's pain is equal. So members, we're going to hear a lot more tonight, but I wanted particularly non-judiciary members of the body to hear some of what we have heard, those of us who serve on the committee, and to appreciate that victim and law enforcement views on the subject are varied and complex. Thank you.
Representative Soper.
Thank you, Madam Chair. So I want to thank my judiciary colleagues for summarizing portions of our very long committee meeting. One element that I think we need to talk about in this great debate is the history of the death penalty in Colorado law. You see, Colorado abolished the death penalty in 1897, but we reinstated it in 1901. Then in 1966, this body referred a measure to abolish the death penalty, and that was defeated, 66% to 33%. As many of you may remember, The United States Supreme Court halted all death penalties in 1972, finding they had been carried out unfairly. In 1974, Colorado voters approved a ballot measure to reinstate the death penalty, which had been legislatively referred. It was approved 61 to 38%. Then in 1978, the Colorado Supreme Court temporarily froze the practice. In 1979, this body amended statute to ensure that the death penalty could once again be a penalty. It was a slight amendment there. The underlying basis came from the 1974 vote. I mentioned this timeline, and since then, I mean, there have been numerous bills. Both current and former members have attempted. But one thing that I do want to talk about is that the current death penalty that we're operating under came to us by a vote of the people. And I would like to stress that anytime we as the legislature refer things to the people, and the people have the opportunity to weigh on that issue, they own that issue, and that it becomes quasi-constitutional at that point in time. And that the only proper way to be able to change or amend the death penalty would be to ask the people whether or not it should be amended or abolished. And I would ask that we certainly refer this to the people because of how the death penalty came into being, which was from the vote of the people. Shifting slightly, I do want to talk about how the case for abolishing the death penalty has picked up speed in recent years. And we heard in committee that out of the 50 states, up to 25, I believe, have now abolished the death penalty. However, doing a little bit of research, this momentum actually came to a halt on November 8th, 2016, a date that I'm sure many members remember. The death penalty was on the ballot in 3 states: California, Nebraska, and Oklahoma. California had 2 questions on their ballot. The voters had the opportunity to end the death penalty or expedite the death penalty. In Nebraska, they were asked to reinstate the death penalty, and then in Oklahoma, voters were asked to enshrine the death penalty in the state's constitution. In all 3 of these states, the voters actually chose to side with having the death penalty. In California, voters voted to expedite the death penalty rather than abolishing it. In Nebraska, they did choose to reinstate the death penalty, and then in Oklahoma, they did reinstate it in their constitution. It shows that certainly the public has a view that they, A, would like to weigh in on the death penalty, and B, it's not as clear-cut of a debate as some would like to make it sound. For example, in California, a state not necessarily known for its conservative politics, voted a way in which, if I was a betting person, I would have probably bet the other way. So to see the results is kind of shocking in retrospect. But it shows that the people have very strong feelings about the death penalty. And that's once again why I would urge that we refer this to the people. In committee, we heard quite a bit about the number of cases where people have been exonerated. The number was 166 that was thrown out there. And from the Harvard Law Review, I'd just like to quote that a study was done between 1900 and 1985. There were 7,000 persons who were executed in the United States. And of those, we believe that 25 were innocent of their capital crimes. However, this includes Sacco and Vanzanetti, and Ethel and Julius Rosenberg. And I do understand that the data may be questionable there. However, there is also an argument to be made that if you're on death row, you actually get that second look. You have good organizations out there like the Innocence Project who are willing to actually go step by step through a case to see if you're innocent. I had the opportunity once in Washington, D.C. to meet one of these individuals who was completely found innocent. He had been on death row. And we spent some time visiting. And there was one thing that I will never forget he told me. He said, "Matt, if I had been in prison for life without parole, no one would have ever looked at my case." He said the fact that my life could have been ended by the state meant that there were different lawyers out there, different civil rights groups out there, different projects like the Innocence Project out there that were actually willing to go through every detail in my case. And he said, with the pending date of his execution, hastened the need to ensure that he was either guilty or innocent. And he said, thank God they found I was innocent. The death penalty, according to John Stuart Mill, merely hastens a person's death because we all are doomed to die one day. And that without it, meaning our toughest penalty here in Colorado would be life in prison without parole, it still ends the same way. It would be to die in any case, and likely it would be a much longer, much more bodily suffering involved with having to wait until your natural date were to come. The death penalty debate is certainly not an easy debate by any means. We heard a lot in committee, both pros and cons. And if there's one thing that I definitely want to stress to this body, it's that there's a lot of working parts and minutia, but it's also very philosophical here in Colorado. Our last execution was in 1997. Do you know when the previous execution was? It was in the mid-60s. So in the last 67. So in the last 50 years, we've only had 2 executions here in Colorado. The real issue is we're not using it in Colorado. That's why, I do understand at this moment in time, this is much more of a philosophical debate, but it's good that we have this debate from time to time. And I once again would just like to reiterate the fact that we gain the death penalty by the vote of the people, and that if we are to abolish the death penalty, it should be done by a vote of the people. Thank you, Madam Chair.
Representative Benavides.
Thank you, Madam Chair. And I just wanted to make 2 quick points, is that when we talked about life without parole, and we talked about this being a philosophical argument. We had one witness, David Lane, who has done, is a criminal defense attorney, has done a lot of these cases. And one of the points he made was that life without parole does impact deterrence because it incapacitates the defendant. They are no longer out there. And so if that's what we want to do, if we want to stop this person, whoever it may be, from further committing murder or other heinous crimes, then life without parole does do that. One of the points he made was that if it didn't work, that it wouldn't make sense that in Texas, where they have one of the highest uses of the death penalty, of executions, they also have one of the highest murder rates, where states with the lowest murder rates have abolished the death penalty. So it is more than a philosophical argument, it's a real argument. We had Ms. Hollis Whitson come in and talk to us, also a criminal defense attorney. And she showed us the amount of work on these cases. She showed us a stack about 4 inches high that amounted to 20 different opinions, final decisions on life without parole cases. Those were opinions of the court, about 4 inches high. Then she showed us one order of a court in a capital murder case, and it was 1,600 pages. It was well over a foot high. And that order, that decision, was on the appeal of the post-conviction review that's required under our process. It wasn't even the mandatory or the direct appeals. It was the initial appeal of just the post-conviction review. So these death penalty cases have real consequences to everyone. You know, many of them talked about, actually, I'm going to tell you a story from a guy that I spoke to last year who was exonerated from death row. His name was Juan Menendez, and he had been, and this is where it really becomes real. He was a young person initially from Puerto Rico. He came to this country, and he, as a teenager, he got in a little bit of a problem, so he had a record. He served a little bit of time, and then he was out. He had no other issues until he was in his 30s. When he was in his 30s, he was working in a field with picking fruit, and all of a sudden people came and arrested him. He didn't know what was going on because he didn't speak English. He was arrested. He went to trial. He was charged with a capital murder that he didn't commit. He was, his trial was within a couple of weeks, and this is Florida, it wasn't here. A couple of weeks, he was sentenced, and he was put in prison. He was in prison for 17 years before he was exonerated. And I asked him, well, what happened? Was there DNA evidence? Was there something that freed you? He said, no, it was, he told me the story, which started with he had defense attorneys that he thought were great. They had done 3 appeals, and they had lost. But one of his defense attorneys said, this has taken such a toll on me personally. She had lost 3 people by execution. She said, I can't do this anymore. She told him, I found another set of attorneys that'll take your last appeal. He was a little worried, but he said, okay. Those new attorneys started from scratch. They went in and they went back to the defense attorney, and they wanted to see everything, to see if there was anything they could use on his appeal. And what they found in there was a tape recording of a confession by someone else that said they had done this, not him. He had always said he was innocent. So then these attorneys then went to the prosecuting attorney. Remember, this is 17 years later. They went to the prosecuting attorney, same thing. They asked, let me see your files. So they gave him a couple of boxes. And in their boxes, there were 17 copies of the transcription of the confession, which means both attorneys knew that this man did not commit that crime. Neither attorney brought this forward. With that evidence, he was exonerated. And it was because of having those new attorneys. So this is not a philosophical argument. This is a real argument that impacts everyone involved in that process. I'm not even going to talk about some of the people we heard from who are families of people, of victims, but also people who are serving death sentences. Everyone is impacted by this. And if we're not doing this, if we haven't executed anyone since 1997 and 1967 before that, why do we continue this? What is the point? So members, this is more than a philosophical argument. This is an argument about what is the appropriate sentence for these crimes and what do we determine as legislators.
Representative Arndt.
Thank you, Madam Chair. So, members, I'd like to address the notion that this is not the proper venue to take up a bill like this, and the proper venue is before the voters. So when I got elected, I have a PhD and I don't let people call me doctor. And I'm married for 30 years and I don't let people call me Mrs. I don't like being defined by my marital status or by my degrees. So when I came down here on the very first day of freshman orientation and Marilyn was there, I said, I have one question. I've never let myself be called anything but Jenny. Do I have to let people call me representative? And she said, with all due respect, representative, yes, you do. Because we don't actually care that it's you who's here. You're only here because the people sent you here. And it could be you or the next person. And that was one of the neatest things I've ever heard in my life. And that's the only title that I've ever let myself be called is representative. Because it's not about me. It's about the people. It is absolutely about the people who sent us here to do our job. And our job is to take big bills, tough bills, hard bills, and to work through them, talk about them, debate them, argue them, amend them, read them aloud, do all of the process that we have and all the rules that we have that guide us in our work to represent the people who sent us. They didn't send me down here to say, you know what, this seems tough. I think I'm just going to pitch it back to the voters. No. We also have a very liberal and generous process for doing that with our ballot initiatives. They are welcome to, if we pass this bill, and if the governor signs it, they are more than welcome to run a ballot initiative, and they will if they want to. We are generous in our participation. We are not taking their voice away. We are simply doing our jobs by debating this bill and being the representatives that we were sent down here to be. And I am not going to dodge the hard issues by sending them to the people. We are the people.
Representative Champion.
Thank you, Madam Chair. I rise in opposition to this bill, and I think it's time for us to get a little up close and personal. December 14, 1993, 4 employees were shot and killed, and a 5th employee was seriously injured at the Chuck E. Cheese restaurant in Aurora, Colorado. The perpetrator, 19-year-old Nathan Dunlap, a former employee of the restaurant, was frustrated about being fired from working at the restaurant 5 months prior to the shooting and sought revenge by committing the attack. He fled the scene of the shooting with stolen money and restaurant items. So let's talk about what he did. Dunlap entered the restaurant at 9 p.m., where he ordered a ham and cheese sandwich, played an arcade game. Then he hid in the restroom till 9:50. He exited the restroom after closing, and at 10:05, he shot 5 employees with a .25 caliber semi-automatic pistol. He first shot Sylvia Cronwell, 19. She was 19 years old, who was cleaning the salad bar. She was hit from close range in the right ear and was mortally wounded. Ben Grant was 17 years old. He was fatally shot near the left eye as he was vacuuming. He was vacuuming the floor. Colleen O'Connor, 17 years old. She pleaded for her life, sank to her knees, but Dunlap fatally shot her once through the top of the head. Bobby Stevens. Bobby was 20 years old. He's the lone survivor of the shooting. He returned to the restaurant after taking a break by smoking outside, thinking that the noise he heard from the restaurant when he was outside having a cigarette were children popping balloons nearby. As he walked into the restaurant and unloaded the utensils into the dishwasher, Dunlap came through the kitchen door, raised the handgun at him, and fired a shot that struck Stevens in the jaw. Stevens then fell to the floor playing dead. Dunlap then forced Marge Kohlberg, now she's 50 years old, so she's 18 years younger than I am, the store manager, to unlock the safe. After she opened the safe, Dunlap shot her in the ear. And as he was taking out the cash out of the safe, Dunlap fired a second fatal shot through Kohlberg's other ear after he noticed that she was still moving. The manager who fired Dunlap was not present at the restaurant. Stevens escaped through the back door and walked to a nearby Mill Pond apartment complex where he pounded a door to alert someone that he and others had been shot at the Chuck E. Cheese. Stevens was hospitalized at the Denver General in fair condition. As authorities arrived at the scene, they found 2 bodies in the restaurant hallway, a third in a room in the hallway, and the fourth in the manager's office. Sylvia Cromwell was sent to DG, Denver General, where she was declared brain dead. She died from her injuries the next day at the Aurora Regional Medical Center. Dunlap, he fled the scene. He had $1,500 of cash and game tokens that he stole from inside the restaurant. Dunlap was arrested at his mother's apartment 12 hours later. So what happened? Dunlap was found guilty of 4 counts of first-degree murder, attempted murder, robbery, and burglary in 1996. On May 17, 1996, Dunlap was sentenced to death an additional 108 years. During his sentencing, in response to an accusation by Cromwell's older brother that the murders were motivated by race, Dunlap exclaimed profanities in an outburst that lasted over 3 minutes. In 2008, Dunlap filed a habeas corpus petition with the court, arguing that his trial attorney was ineffective by not presenting a defense for his mental health issues and child abuse. In August 2010, this federal appeal was rejected. Senior U.S. District Judge John Kane wrote that Dunlap had been fairly tried, competently represented, and justifiably sentenced to death. On April 16, 2012, in the 10th Circuit Court of Appeals, they denied Dunlap's appeal for his death sentence. Dunlap's lawyers argued before the 10th Circuit that Dunlap's trial lawyers were negligent in their sentencing by not providing evidence that Dunlap suffers from a mental illness. They argued that the jurors heard evidence. If the jurors had heard evidence of Dunlap's mental illness, it would have spared Dunlap from being sentenced to death. On May the 1st, 2013, Judge William Sylvester announced that the execution date for Dunlap would be in mid-August 2013. To you all who sit in judgment of this particular bill, and that's what you're doing, Dunlap denied the lives of 4 people and almost killed a 5th. He deprived the parents of those children to watch them grow up, maybe have kids, maybe sit in this particular chamber. He deprived them. He deprived their friends. He deprived their family. He took everything from them that had something to do with that child. Is he entitled to live? The families have no closure, and for that they have no choice. Madam Chair, I rise to the opposition of this bill. Thank you.
Representative McKean.
Thank you, Madam Chair. The older I get, the more I have to walk through these things slowly. My heart hurts. Now don't stand up. The fact that I'm an old softy and my voice cracks is fine. I appreciate the respect, but what I'll tell you is my heart hurts because we know what we are wrestling with tonight. We're wrestling with one of the largest questions we will ever have to ask or answer. I said in Judiciary Committee, I'm very torn about this, and partly the reason I'm torn is because I was raised a Quaker. I was raised somebody who says, there is that spark of God in every single one of us, and I don't care what you do, I don't care what sin is not worse than another, all I care is that you are that creation of God. So is it ours to take your life? That's what I wrestle with. Do I trust the state to do it perfectly? Do I trust the state to have the power over taking its citizens' lives? Well, honestly, I don't. But what I will tell you is that I actually am opposed to this bill. Because I will tell you that on its face, we can make this a very facile argument. We can stand here and we can say, we don't do it perfectly, therefore we shouldn't do it. We shouldn't be able to deprive someone of their life, therefore we shouldn't do it. We had an argument in this chamber about a week and a half ago about prisons. And if you remember, some of the more poignant moments in that debate was when we said it does not matter how much it costs. We are talking about depriving someone of their freedom. Do we all remember that? Because what we kind of got into was, hey, private prisons are a cheaper alternative that we can use, but then we say, hey, it doesn't matter what it costs. We had the example just given to us of when we heard testimony of 4 inches of paper and how many cases that was in a foot high of paper, and it's one case. I don't care. Shouldn't that foot of paper be the inspection and the decision when we still take someone's life? Don't sit here and think that this debate does not include that life in prison without the possibility of parole is depriving that person of their life. So don't sit here high and mighty and say, oh no, it's death penalty versus this. It is the death penalty. If we are going to parse these words, and part of the reason why when I stood up here, everything I had prepared, anytime you know that I'm thinking, anytime I filled out this many pieces of paper, is when I think of the people who didn't come home. And the system that we've established, because this emotion is not what we want from our jurors. It's not what we want from our victims' families who are seeking the degree of justice that our Supreme Court has said this is the right way to do this. I got tired in committee of hearing an instance in Florida, an instance in Alabama. Yes, we are humans and we do it wrong. Let's talk about Colorado. Let's talk about the fact that we should be damn proud of the way that we go about our business in this state. Let's talk about the fact that, in fact, when we get to this point of this discussion, we really ought to be saying, okay, is this an academic discussion? I believe it is. But I believe it's an academic discussion with a tremendous amount of import. Right now, we have people sitting on death row. I don't think anyone in this room thinks that they are in imminent danger of being executed. I think that their cases have deserved an incredibly close inspection, and I think they've gotten that. I was home over the weekend, and my son he's on his way here tonight because he wants to see his dad. He's 19. If he were at Chuck E. Cheese and he was standing there cleaning up, doing his job, do we not think that we would want to have the entirety of our judicial system to say this is how we can mete out justice? And because it's not some desire by the families that's carried out by somebody else. It is a deliberative process by a jury. Let's not forget that it is an incredibly deliberative process that requires 2 trials. It requires a conviction of first-degree murder, followed then by a trial on the merits for the death penalty, that by its very structure looks at the aggravating factors and the mitigating factors and says, does this deserve death? This is a really important question. If what we say is no, what we want is life in prison without possibility of parole, you are still giving someone death. If you say that we do want to keep it and we don't ever exercise it, what you in so many ways are doing is giving those individuals, as Representative Soper described, the ability to have this incredibly close inspection for the most heinous of our crimes. You know, up in northern Colorado, the case in Firestone hit home incredibly deeply. What did we see? We saw, please help me find my wife and my kids. We saw all of this theater going on during the time that those two little girls and Shanann were left to rot, left in a holding tank amidst unspeakable nastiness, left in a shallow grave. We heard that case and we all knew the neighborhood. I've knocked doors in that neighborhood. We know where these people live. We know who the neighbors are. The individual in question was not coerced. Under no duress did he give the information that helped law enforcement close that case. But it was a decision point. The pain that I have read in the interviews of Shannon's family is tough to take. That man sits in a prison cell and reads a book to the memory of his daughters every night. And that breaks into pieces the heart of that family's grandparent and their mother. You think about who is left behind, and you think about what the penalty to them is now to say that he's going to live out his life and they're going to have to hear that story. This, please, for the love of God, wrestle with this question. It is not just get rid of it. There is a consequence on the far side of that. I disagree when I hear that we need to do our damn jobs and vote on this. I disagree that we're not doing our jobs. This debate is that job. This debate is that job, and the vote at the end of it is interesting because we really had, in my opinion, please sit, we had probably one of the better moments in debate at the end of that, and I thank one of my colleagues for mentioning a town divided by the line of a judicial district, in which on one side of the street you might be tried for the same crime with the death penalty, and on the other side of the street maybe not. And the question was raised, is that equal justice? That the district attorney on one side might charge that crime and the district attorney on the other might not. I hold to what I said. It is equal justice because we leave it to the jury. We leave it to the jury, and we leave it to the jury with the full benefit of what that means. When we elect district attorneys, when we have people in the state of varying understandings and varying humilities about what we ought to impose as penalties, I would caution our body to take from a vote of this body where maybe a majority of the members here come from districts where that wouldn't be done, and maybe philosophical places where that wouldn't be done, and then impose by that majority on the rest of the state who clearly have a pretty big opinion about this. I mean, in my House district, I put out a survey and it came back 67% said, do not abolish this. So So when I look at what our job is, with the greatest respect for my seatmate up here, our job is to debate. I think at times our job is to wrestle and then literally say, yes, we think that because of the disparate nature of our state and its people, that they ought to weigh in on this. They have a chance. We could add a petition clause to this bill and they'd have a chance. That'd be neat. But I will tell you that I was a little disappointed when I did my poll because I got some responses that were just quick answers. Yeah, we ought to kill them all. We ought to make it super fast and not allow any appeals, right? Kind of not really deep thinking about what this really means. We're here to think deeply. I'm opposed to this bill because I think there is so much of this bill that gets left behind when it becomes more of a political statement, when it becomes less of what our citizens are bringing to us and more of the efforts that we see so often, where we have national interests that say, you know what, this is what we want things to look like. I think this is a truly Colorado question. When Aiden gets here, I hope you go say hi to him. He's 19 years old. He's full of life. And in my opinion, he deserves to live that long life. God forbid anything ever happens to him. But you know what? If it were, I would hope that I could be that person that we heard in testimony that found forgiveness, that went and talked to their folks that are still in prison. But I also would like to know that his justice was not hamstrung by some desire not to have something that we don't do. I would urge that you join me in opposition to this bill.
Representative Benavides.
Thank you, Madam Chair. I'd like to address a couple of things. First to say this is not an easy question for anybody in this room. This is a huge, probably the largest responsibility all of us will have in making our decision. So this is not the kind of bill that it's this or that. I'm going to talk about some of the things that were raised, and that had to do with people of faith and making those decisions. We heard in committee from Auxiliary Bishop Rodriguez, and he talked about the Pope changing his liturgical determinations or directions. I'm not sure exactly what he called it. And he said that it was the Pope's decision that even though some of the most terrible and horrific crimes are committed by people, and they are terrible and they are horrific, what he said was the dignity of the person is not lost. And if we believed that the dignity of the person was lost because they committed such a terrible crime, then we would have to admit that that person is less than human. And I don't think that's what we're saying here. We received a letter signed by 152 faith leaders in the state of Colorado. They said that the public often seeks their guidance on tough issues, and that they have concluded that the death penalty fails us. They said, "We join many in Colorado who question capital punishment due to its record as an ineffective, unfair, and fallible response to violence. The death penalty applies disproportionately to the poor and minorities and puts innocent lives at risk of execution. Innocent people have been sentenced to death due to serious legal errors in the administration of capital punishment. 166 people have been exonerated and released from death row. For every 9 people executed in this country, one innocent person on death row has been identified and exonerated. When a human life is at stake, there simply is no room for error. As religious leaders, we often serve as resources to victims' families in the aftermath of a murder. Given this responsibility, we have a special interest in advocating for policies that serve their needs and promote healing and well-being. And I think what they were saying there in part is that if there is no way to reverse a death sentence, an execution, if we make a mistake, there's no going back. And we brought up that this does occur in many other states, and that's because we've only had 2 executions in the last 50 years. But it doesn't mean we don't make mistakes in Colorado. In 2011, there was a posthumous pardon that was issued to Joe Arity. He was a young man at 23 years old who was executed in the state of Colorado. Joe Arity had the mental capacity of what's said to be a 6-year-old. He stayed in his cell playing with toy trains. When he was asked what his last meal should be, he said ice cream. He didn't understand what a last meal was. And yet, we executed him. One of the things about Joe Arity was, which later I mentioned the case, Atkins case in 2002, where the Supreme Court said we should not put people that have a mental illness to death. But one of the witnesses told us that people with developmental disabilities are 8 times more likely to confess. Joe Arity confessed because he thought that's what he was supposed to do. He didn't say that because he was there. He was not even in the location where that crime occurred. That was a mistake that we in Colorado have to own. Another case, which wasn't a death case, but it shows the mistakes we make in Colorado. In 1999, we sentenced Tim Masters to life without parole for killing a neighbor. But in 2008, evidence came forward that was withheld by prosecutors. He was exonerated. He was released from custody. And municipalities in the state paid him $10 million because of that error. This process, if he had been sentenced to death, he may have already been dead before that evidence came forward. And that is the risk. That is the risk we're taking. No one is saying these terribly heinous, egregious cases are all right and we should ignore that. No one is saying that. But victims' families, they're not in unanimity on what should take place. We heard from members of victims' families that didn't think the death penalty should be applied. So members, this is a really difficult decision that we all have to wrestle with. And this, though, is our responsibility. We make decisions about sentencing. So please support this bill.
Representative Melton.
Thank you, Madam Chair. You know, I guess I share Representative McKean's affliction of having notes written and then getting up here and feeling a different way. You know, my heart goes out to the victims and the families of victims that have really experienced terrible, terrible tragedies. And I had it in my head, I was going to talk about how the death penalty is a failed policy, how it's not a deterrent, how we could make mistakes, so many of the things that we've already heard here in the well. But I heard tonight, let's get up close and personal. I heard that phrase said down here in the well. Well, I can tell you that this is probably one of the most personal things, one of the most personal subjects that I've had to deal with in my 8 years down here. See, I represent House District 41. District 41 is the smallest geographic district in the state. The smallest district in the state. You'd probably drive across it in about 20 minutes. And when I look at the state and I look at the state's population, we're 4% African American, but yet 100% of those on death row are black. 100% of those on death row are about my age. 100% of those on death row come from my district. Every single one of them. You can't say that the death penalty is applied equally and justly when it's been able to pinpoint so accurately one community. It's painful. It's painful to me as a 40-year-old black man that comes from Southwest Aurora to know that this state has basically sent a message that your life is less than. That if I grew up on one side of the street, different, that justice would look different. That if I was a different color, that justice might be different. Or a different age, justice might be different. And so when I look at this bill and I think about what it is that we're debating, what it is we're talking about, it's not for lack of what the victims have gone through, but it's to ensure that we are just. Is justice blind? Right now, I would say it's not. It can't be. Because it singled out my community so accurately in a way that no one else in this chamber can share. It is very personal. And it should not matter. Justice should not matter where you come from. This is a failed policy, members. We need to get rid of the death penalty. And I agree that there should be punishment. I just heard here in the well that life without parole is a terrible thing. That should be the punishment that we abide by. So that way mistakes are not making. So that way we don't send a message that your life doesn't matter. And so that way justice can be served equally and fairly. I ask for an aye vote on Senate Bill 100.
Representative Liston.
Thank you, Madam Chair. Members, I come down to you to speak about this very important bill with a very heavy heart. I'm not an attorney, as you all know. I'm a very fair-minded person, and if I said it once, I'm always willing to give people a second chance, a third chance, and give them the benefit of the doubt. But we're speaking about heinous crimes, not just ordinary theft or a bank robbery or stealing a car or whatever it may be. We're talking about the most serious violation of human life that there is, murder. And I want to speak to you. I come down here to speak for the innocent, the people who have gone to work, out playing or working or minding their own business, their own lives, and then someone comes with careless regard or really malice, not just to shoot them randomly, which is horrible. And I look back at my good colleague, Representative Sullivan, I can only imagine what your heart goes through. My heart aches for you. I want to be a voice for the deceased. And Representative Champion kind of stole my thunder, but it bears worth repeating. I remember very well that December night back in 1993, and for some reason it really stuck with me, what happened at the so-called Chuck E. Cheese murders. And, you know, I've really thought about that. I know people who were involved with that case. But I too, like I say, it bears worth repeating, the people, that they're not just forgotten. As Representative Champion mentioned, Margaret Kohlberg, 50 years old, in the prime of her life. You know, great job. She was the manager. She was there that evening in December working. She was headed back to her office to take care of the evening receipts, and she was looking forward to going home. Sylvia Crowell was cleaning the salad bar. She was 19 years old. 19 years old. She was balancing a full-time schedule, going to school at Metro State. Something that I found out, I didn't realize this, that she said goodbye to her workmate, and her workmate said, "I love you," her closest friend. Ben Grant, a high school junior, he was just doing his job, I think, as Representative Champion said. He was vacuuming, just cleaning up that night. He was vacuuming. And then there was Colleen O'Connor, who was closing that night. She was just 17 years old and had called her mom, and she found out that very night that her parents were going to give her her first car. You can imagine how excited she was. She was working. We all remember, I bet every single one of us remember our first car. I know I do, and how exciting it was. And in the kitchen, there was another innocent person, Bobby Stevens. He was working away in the kitchen, cleaning. He was just 20, and he had a 7-month-old baby at home. And he'd asked for extra hours because he needed those extra hours to earn money to take care of his child. So he'd volunteered to come in that night. Now Sylvia, she didn't even, I mentioned her name, Sylvia Crowell. She didn't even hear the intruder come in. He silently came in and raised that semi-automatic pistol right to her ear and blew her brains out. He executed her. He didn't just randomly shoot her. He executed her. He knew full well what he was doing. He had hid that night, as we all know. He had hid in the bathroom, waiting for his chance to get back at innocent people. And as I say, he just didn't shoot at people. He went up and cold-bloodedly executed them. Executed her right in the ear. Bang! Just like that. Bang! As she fell, he looked away because he didn't like the sound of gore and blood. But he moved over to Ben, where Ben was vacuuming, just doing his job. Bang! Bang! The bullet entered Ben's eye, lodging in his brain where he fell. Colleen, this is what really gets me, Colleen saw him coming. And then she kneeled in front of him. She kneeled, pleading for her life. He put the gun to her head. Bang! And he executed her in cold blood. He just didn't randomly shoot her. Bang! he executed her. She was pleading for her life. I can only imagine what she was thinking or saying. Please. In fact, she did say, I won't tell. He murdered her. He executed her anyways. As I said, bang. He wasn't done, though. He wasn't done. Inside, Bobby was cleaning the dishes, and he heard these, as Representative Champion said, he heard these pops, and he thought, well, they were just popping the balloons. No, they weren't popping the balloons. Nathan Dunlap was executing these people. He was executing them. He knew what he was doing, but he wasn't satisfied. So he goes in and he shoots Bobby, and he shoots him right into the jaw, and Bobby falls down and plays dead but by the grace of God, had he not played dead, Nathan Dunlap still had bullets in his gun. He would have executed him. But he still wasn't done. He goes in to Margaret, and she sees him, and he tells her to open the safe. He forces her to open the safe, which she obediently did, probably praying for her life at the same time. I hope he doesn't shoot me. But he did. He executes her. Bang! He shoots her in the ear. You can imagine she's laying on the ground, withering, probably near death. But he wasn't finished. He goes up to her and bang! He shoots her again in the other ear. He executes her. He just he wasn't satisfied that he might have wounded her. He wanted to make sure that she was dead. So he shot her in the other ear. So in the period of less than 5 minutes, he's executed 4 innocent people only doing their jobs, only trying to live out their lives, only thinking about their friends, their family, and the Christmas to come that they will never see again with their families. I want to tell you a little bit about Nathan Dunlap. He was not just your ordinary, you can sit down, please. He was not just an ordinary, dissatisfied person. He was one of the people that has been called a super predator. He knew what he was doing. At 15, he already had a record. He had already committed several robberies. He started with a golf club. No telling what he did, but that wasn't good enough, so he later worked his way right up to guns. He ended up in juvenile court again and again and again. He was given numerous chances, again, again, and again. He had the opportunity to turn his life around. In fact, they gave him a job at Chuck E. Cheese, but he apparently had a disagreement with the manager, unfortunately. Had the manager been there, he would have been executed. There's no doubt in my mind, or probably anybody's mind. Had the manager been there that evening, he probably would have been the first to go. But instead, Margaret, the other probably assistant manager, was there. He was arrested in 1993. He was arrested 5 times on misdemeanor charges. So he was totally dissatisfied, Nathan Dunlap. He was angry at everybody because we didn't give him enough chances. So then what else has not been disclosed? During the trial, his own mother refused to testify on her own son's behalf, his own mother. So now then, here we are, and he had a fair trial by all accounts. It's been given to you numerous times, appeal upon appeal. And today, he's 40 some odd years old. I think he's 41 or 42 years old. And he sits on death row, and we're about ready to take away a tool. You know, we don't go out and seek the death penalty for just any ordinary murder. It's got to be heinous And there's the other terminology, I'm sorry, I can't remember, but you just don't go out and use the death penalty for any regular, not that it's regular murder. It's got to be extremely premeditated and so forth. So here we are, some 23, 24 years later. We had a chance. What frustrates a lot of people about the death penalty, we say, well, the death penalty is never a deterrent. Well, it's never a deterrent because it's never been used. We had a governor that just 3 years ago, all he had to do was put his initials on the sentence, and Nathan Dunlap would have faced his ultimate maker. But we had a governor who wimped out and refused to do it. So, you know, when people say that the death penalty is not a deterrent, well, it's not a deterrent because we never use it. And no wonder people are frustrated. You know, I've been out speaking to a lot of my constituents. It's been brought up numerous times in my district. And I hear it again and again from constituents in my district about their frustration. They're not looking for vengeance. They're just looking for, on these heinous crimes, that we utilize this tool. Let's not take it away from our prosecutors, that they can use it in a wise fashion. It's not used just indiscriminately. It's not used for any crime or whatever. But let's not take this tool away from our prosecutors. So, members, you know, I just bring this up about what happened 27 years ago so that these people are not forgotten. Because today, those teenagers would be in the prime of their lives, having good jobs, good families, whatever, pursuing their careers of their choice. But they were snuffed out by a cold-blooded murderer and killer. And let's just not do this. I never hear this from my constituents, that let's repeal the death penalty. I just never hear it. And I'm sure there's people who feel that way, but the vast majority of my constituents that I speak to, and I've represented my district off and on for 12 years, they feel that this is a reasonable, correct thing to happen for those few people. Remember, as it's been said before, we've only had one execution in 50 years. One execution. We're not just out there using the death penalty for, you know, any old murder. So with that, I rise in opposition to this bill. Thank you for listening, and God bless you all.
Members, I want to take a moment to thank everyone for being so respectful tonight. I don't think I've ever heard the House as quiet as this. I do want to ask, though, that we be careful using loud references that may invoke some traumatic experience. Just remember that there's members who have had experiences in this area, so let's be respectful of that as well. Representative Holtorf. Okay. Representative Roberts was next, but Representative Sane.
Thank you, Madam Chair. And to that point, if we didn't want to relive traumatic experiences, we wouldn't be bringing this bill. I have the honor of reading a statement from the family of an American hero in the fight against domestic terrorism. While they are not technically a Gold Star family, it is us to remember their sacrifice and their wishes. Kendrick Castillo loved people, and on May 7th of 2019, he gave his life to save 28 people. At the STEM school, and who knows how many more, we will never get to see him again. But the two killers will go on to live, talk to their families, celebrate birthdays. Can you imagine not even being able to hear what his last words were? After he was murdered, we didn't see him until a week later in a casket. Please keep in mind that there are 28 witnesses to our son's murder. We oppose this bill. John and Maria Castillo. They're with us on the floor today, and I'll take the fine, Madam Chair.
Representative Roberts.
Thank you, Madam Chair, and thank you, members, everybody who's spoken tonight and everybody who will speak tonight. I wanted to come down here and just offer my perspective, and we'll couch it with that it's just my perspective. I don't feel I have the right to speak, certainly as a victim of crime or as a racial minority. But as some of you know, when I'm not here as a legislator, I'm a deputy district attorney for Eagle County. And I'm not that experienced. I certainly have never prosecuted a murder case or a death penalty case, of course. But the reason why I took that job and why I still continue to do that job is for victims. It's fighting for victims, it's defending victims, and it's making sure that justice is applied. And we've heard some tragic and graphic details at the well tonight, and I just want to make it clear that just because somebody votes to repeal the death penalty does not mean they don't believe that those victims deserve justice. And it's not our place, just because somebody votes for this bill, doesn't mean that those individual victims should feel that that killer not be put to death. I don't think that's any of our places to render judgment if we haven't been in that situation. I've heard from constituents on both sides of this issue. One of them is my mom. Her father was killed as a victim of crime when she was 10 years old. So I never met my grandfather, and that wasn't a death penalty case. But she's telling me to not vote for this bill because she remembers her mother crying and wishing that that person would die. But he got jail. He went to prison. But as an attorney and as a legislator, I believe in the words that are above the United States Supreme Court that say equal justice under law. Those 4 words. And the reason why I'm going to vote yes on this bill is because of that first word, equal. And my colleague from Larimer County brought up an example that I brought up in Judiciary Committee, but I'd just like to fully flesh it out here for everybody. I represent Eagle County. One of the towns in Eagle County is the town of Basalt, and you can all be seated, thank you. Is Basalt. The county line of Eagle County and Pitkin County runs right through the town of Basalt on Two Rivers Road, and it actually runs right through the middle of a 7-Eleven, right through the middle of the store. And because of the system we have in Colorado, those 2 county lines mean the difference between 2 judicial districts. On the Eagle County side, the district attorney in that judicial district would never pursue the death penalty under any circumstances. The district attorney on the other side in the 9th district, when you're in Pitkin County, could pursue the death penalty. That means you could commit the exact same murder on one side of the 7-Eleven and not ever have the threat of the death penalty, and then go over to the other side of 7-Eleven and commit the exact same murder, and you could face the death penalty. That is not equal justice. When we have a system like that in Colorado, we need to take note of it. And I believe that somebody who commits a heinous murder should spend the rest of their life in prison, and that's the system we have. The prosecutors we heard in the Judiciary Committee said, if somebody has committed first-degree murder, I can prove it. I don't need the death penalty as part of the plea bargaining. I would never hold that above somebody's head. And in fact, one of the district attorneys said that's unethical for them to do. First-degree murderers will spend the rest of their life in prison, and I believe that that is justice. And if we cannot have a system where it's equal justice with the death penalty, then we're not living up to our oath as attorneys or as legislators. So with that, I rise in support of Senate Bill 100.
Representative Landgraf.
Thank you, Madam Chair. I want to talk about a situation that's a little further from Colorado. I moved here from Washington State, and in 2002, Scott Peterson killed his wife. Of course, we didn't know this for quite a while. It was all over the TV. Lacey Peterson was 8 months pregnant. He killed his wife. When she was found in a barrel in the lake, her body was decomposed. And I remember her mother crying that her daughter could never hold her son, her grandson, who was 8 months pregnant when she was born. So he was a baby. He had a name, Connor. She would never have been able to hold her baby in the coffin because he had cut her arms off and her head off, and that's the condition they found her in. He was given the death penalty. He is still on death row. Their son, Connor, would be 18 years old now. And I remember when that verdict came down, that was what I thought about. I thought, how unfair is it that Scott is going to be able to live for how long on death row when his son had no life? And we see that all the time. People, and then I actually wanted to talk about the case much closer to home because I can't get it out of my head, and that's another young woman who was pregnant with a little boy, went to bed, maybe she was asleep, when the man that she loved and was having this little boy with choked her to death. And then I think about two little girls who were taken out of their bed, put in the car by the man that they loved, they trusted their dad to take care of them like we all do. And instead, he drives them out to a field, chokes them, and sticks them in a barrel that we probably would not know of today had not the death penalty been used to get him to confess to the crime and admit to the disposal of the bodies. Those children could still be in barrels today. And I think about these two little girls. We have children. I think about my grandson, and I think if somebody hurt him, I don't think we'd need the death penalty if I had any ability to get to that person. And you probably all agree with that when you think of your children and you think of somebody harming them. And then I think of Rhonda Fields and her son. Aren't our sons just as important if something happened to them? So her son's killer will still be on death row, as I believe he should be, because I believe in the death penalty. But what about your sons? What about your daughters? If something happens to them, what about your grandchildren? If something happens to them, wouldn't their murderers deserve the same treatment? I think they would. I ask for a no vote on this bill. And I ask that you think about those two little girls in a barrel who could still be there if not for the death penalty.
Representative Larson.
Thank you, Madam Chair. So there's a lot to be said on this bill. I rise in opposition, and I'm sitting over here thinking of the litany of reasons why, and I'm sure there's an argument prepared on each and every one of them. I know a big argument that is often bandied about is the cost of going and bringing somebody through the full death penalty process and the cost and the burden that it places on our system. And if I had one iota of faith that if we were to repeal the death penalty right now, that those attorneys who have dedicated their lives to helping exonerate murderers would stop there, I would think that might be a valid argument. But I posit to you that the moment that this bill passes and is inked on the governor's desk, the very next thing we're going to start hearing about is attacking the life without the possibility of parole. This is not where this ends. This is where we're at now. And yes, I think it is important, and we've heard numerous cases from the bill sponsors and from people who are opposed to this bill's passage, myself included. We have made horrific and heinous mistakes with the application of the death penalty in this country, in our history. And we should own up to that. And we should acknowledge that particularly in certain states, not Colorado, but in certain states, there was a particularly heinous racial component to that misapplication. And we need to own up to that. But what I would tell you today is the 3 people on Colorado's death row there is no question in anybody's mind that those people have committed those crimes. This is not a case of a coerced, out of an individual with IDD coercing a confession that didn't happen because the DA had a political motive or something like that. These people did their crimes. There are people in this world that do these heinous crimes. And there are victims. And there are people that live on. And I'm going to break up here. But someone I knew, not a constituent of mine, but my dad's best friend was a guy named Jason Dahl, who was the pilot of United Flight 93. And he died in September 11, 2001. Now, obviously, there was no justice to mete out for the people that killed him because they died on the plane about an hour after they had slit Jason's throat and let him bleed out on the floor with a box cutter. But the next 10 years of my life, I would go to dinner parties with Sandy Dahl, Jason's widow. And I will tell you that her life was ruined. And she'd never lived another day after September 11th. She physically lived, for sure, for 10 years, until she succumbed to substance abuse that was absolutely 100% tied to what had happened to her husband, because she had to relive every single day of her life. Her husband, didn't die in some obscure way. He died in a way that was for the public to see. And everywhere she went, she relived that every single day. So she was never able to get away from it. And I saw the toll that took on her until she finally passed away. And I think of her, and I often think of what I would do to those men if they were still alive. And yes, it would be, very savage and brutal. But you know what? That's not the system we have. And you know what? I would agree. If we just had a system where it was, hey, this happened to your family, so, act out your most primal desires on these people, that probably wouldn't be such a good system. But that's not the one that we've designed. We've designed a system of laws with protections, and please sit down. I made that through it a little better than I thought I would. We've designed a system of laws that have check after check. I don't need to run through it again because we've heard it and I suspect we'll hear it again, where we agree that we have an application. And yes, there are some DAs that have made a statement that they will never pursue the death penalty. But that doesn't change the fact that that is still a possibility under the legal protections that we are allowed. That is a function of an elected official making a conscious decision, but that does not mean that he could not exercise his right to pursue that if he felt the proper situation arose. So really what it comes down to, and what I was thinking mostly on the bench about, was the word justice. Because at the end of the day, this is a part of our justice system. And I just can't get over, with my experience with Sandy and watching what that did to her life, and what we've heard from all the other families and all the other people, I just cannot get over the idea that a system where somebody can commit such a heinous crime, where they can deprive a family of their loved one, and if the best we can offer that family is that they get a 40-year vacation in a prison cell watching television and being fed 3 square meals a day. And yeah, you know what? It's not something I would ever choose. I would never aspire to live in jail. But you know what? If the alternative was being dead, sign me up. And I cannot imagine calling a system like that, where the only thing that we can offer a family who has been robbed of a child, who has been robbed of life in the most heinous and premeditated way possible, the best thing we can offer them is that the person who did that gets to live till the end of their natural life. I don't think we can call it a justice system. There is no justice in that. And that's, I mean, you know, that's how I feel. I have a personal connection to this. So you know what? Maybe I'm not the most qualified person to be making this dispassionate judgment, but that's how I feel. And I've talked to a lot of the constituents that I represent, and I've heard a lot of similar feeling. So when we do this tonight, I ask you to think about what the word justice means, and really think about those cases, and think about the families that have to suffer through this. And then also to think about the constituents that you represent and what they feel about this, what they would feel like if their child were murdered, and if they had to sit through here and watch on the television or hear about it in the Denver Post tomorrow, that, you know, this elected body, which I suspect none of us campaigned on repealing the death penalty, had gone and taken this off the table. And think about what the people in your district are going to be saying tomorrow. And think about the ones that have been touched by murder, and think about the ones that will be touched by murder tomorrow, and the day after that, and the day after that. And think about that. Because, you know, I know where my answer is, and I've thought about this a lot. And I just ask all of you, I know that there's political games at play here. I didn't mean to use the word games, I apologize, but I know there's a political consideration here. But I just ask on a personal, on a compassionate human level, to think about the individuals in your district, to think about your families, to think about their families, and to understand what you are doing, the message that you are sending, and whether this is truly what the people wanted us to do when they sent us down here. So I strongly urge opposition to this bill.
Representative Holdorf.
Thank you, Madam Chairman, esteemed colleagues. It saddens me that tonight we are going to pursue this red herring to its logical conclusion. Now, what do I speak of? I speak of a flawed argument. It would be different if in Colorado we had lined up tens, if not hundreds, of heinous murderers, and we were applying the death penalty in quick and short order. Then we'd have a problem, and we could be talking about how we need to repeal something that is being used heavy-handedly and doing harm to the citizens of Colorado. And this is not an issue for any other state but Colorado. Make no mistake about it. So don't bring the statistics of Illinois into this. And oh, by the way, with respect to the argument about the mistakes that are made within our judiciary, I have studied and found statistics that the error of mistake is between 2% and 0.5%, depending on the analysis and the study that you read. So if we're applying the law even at 90 or 95 or 98%, I would argue that the judicial system is doing a very good job of applying the death penalty. Now, I know we're all humans, and we all have human failures, including lawyers, district attorneys, and everybody in the judicial system. And I understand the mistakes of this country and the mistakes that have been made. And I've talked to those in the past. And I believe that we are getting better. In fact, in Colorado, we do an exceptional job because we don't even apply the death penalty. Nobody has died in how many years? So don't tell me that tonight we have to hurry up and pass this legislation for the people of Colorado because there is such great injustice. Because it is not true. It is not true. And that we must do this to protect whomever we think we need to protect. It's a flawed argument. It's a political football, and we're going to play it tonight. And we're going to take the emotions of our citizens all the way up and down the field, through the fourth quarter, and maybe into overtime. And that's what you've signed up to do when you bring this bill to the floor. It saddens me that we have to do this. Is the death penalty morally just? Is it barbaric? Is it an act of vengeance? Many would argue yes. Others who have fell victim to the savagery, to the lifelong pain of these heinous murders, crimes, may argue no. Now, at the end of the day, we all have to reconcile this with our Maker. It is not ours to decide. We all will die. And God will take us when He determines that time has come, if you believe. And I do believe. I have been in places where I thought the end was near. And I've experienced things that told me that it was not. It is not easy for me to say these words, but I feel obliged to say them. But I will tell you, we always overlook as we try to protect those that are facing the criminal justice system. We almost always overlook the victims. They become collateral damage in many cases. And it saddens me that that is what happens. And it will happen here tonight. Most assuredly, I will speak to the entire state. I think there's no greater harm than murder, and the termination of life. And it appears to me that this bill will hold the value of the criminal's life above the value of the victim's life. If Lady Liberty, or Lady Justice rather, is supposed to be blind, I think many lawyers are in this room. I think everyone attempts to meet that oath and that obligation. And most of the people that are on death row didn't get there because of the good choices they made in life. I often think about the rights of the victims who were murdered in cold blood, without reservation or hesitation. Their lives, their precious lives, and that spirit that grows in all of us, that little bright light that is within all of us, that comes at conception and leaves at death. And it's real. It's a spirit, and we all have it. It will go to meet our Maker, and there will we be judged. And I've heard the discussions about the lawyers and the judicial systems here tonight and how they're different, and they are. And that's our judicial system. If you don't like the system, ladies and gentlemen, let's run some legislation to change that, if you think that's the problem. But this is not a problem. Make no mistake about it. When's the last time we commuted anybody to death in the state? 20, 30, 40, I don't know how many years. It doesn't matter what you think might have happened. What matters is what has happened, what we do. And at the end of the day, the governors decide whether the death penalty should be invoked or not. And that is the greatest of responsibility. And it is reserved to our highest executive to make that decision. And within our laws, we respect that. If he says no, we respect that. And that's his decision. We have a system that allows for that. And you know, in the court of history, what our governors have said and decided when that heavy burden of taking somebody's life who's done the most heinous of crimes gets to their desk. What do they say? Well, history has said in Colorado, we say no. The governor says no. It's still a political football and continues to be. So based on what is happening in the state of Colorado, what we are doing, what history proves, there is no rush to repeal the death penalty that I can see, because we don't even do it in Colorado. And depending on how you feel and what you believe in, that may be a good thing. The system is working. My fellow colleagues, the system is working. It's not a failed or broken system in Colorado. It's a painful system. It's a heartbreaking system for the victims' families. But it is not a broken system, and I will argue, based on what I have mentioned previously. The fact that previously one of our representatives said that the stack was this high for the death penalty and was only this high for other crimes, I believe, life in prison. Well, that is a testament right there to what our system does. Our system takes the greatest of care. In what great measure, based on this comparison, have we taken to make sure that we are not making a mistake? But everyone here is quick to say, oh, we make mistakes, the judicial system is flawed. And that we just can't do this because it's replete with error. And there's so much criminalization of the criminals. I will argue that that, albeit true, statistically is in a super minority. And I'm thankful to hear that that stack of paperwork will be this high. And cost is not an issue. When you're talking about somebody's life, cost should not be an issue. No matter if they're in life in prison or whether they're being tried for the death penalty. Which I will argue, and I have my colleagues here on the other side of the aisle say, well, there's so many lawyers that say, no, we shouldn't do this. And we heard testimony that we shouldn't do this. I will argue that there are just as many who say we should, but they will not speak up in some cases because it's unpopular to speak up. It's difficult to say what I say. But it is the truth. It is the truth, ladies and gentlemen, and make no mistake about it. I wish we could do other legislation and work on things that really matter, that I believe to this state. Because this issue right here, repealing something that we don't even do, does not make sense to me. It's a political football. We're going to have this rugby match tonight, and emotions are going to be painstakingly exposed on all sides. And I don't understand why. I don't understand why. I don't believe this is the people's work. I don't believe the citizens of Colorado are overly concerned, although some of them are, about the effects of the death penalty on the criminals because we're over applying the death penalty. To repeal it and afford heinous criminals life in prison, I would argue, may be fair in some people's minds. In other people's minds, particularly if you're the family of a victim, despite all that you were taught and all the fundamental Christian beliefs that you may have, still, in your heart, may not be fair. But when you make that decision, that is between you and God. And that will be adjudicated not on this earth. I really get tired of all the things we try to adjudicate. I will tell you, I've seen evil. I've seen it. It's real. The devil is real and evil is real. And I will tell you, in this country, we have one of the best judicial systems in the world when it comes to this. So as you sit there and shoot holes in our judicial system and complain about the injustices that we have, make no mistake about it, we get an A+ in the world court for how we handle and what we do. And the world looks to us. The world looks to us in so many ways, and I would argue that it looks to us today. I feel sorry for the district attorneys and the assistant district attorneys and the lawyers that are out there trying to protect the people. When this body decides to repeal this and takes that one tool away that they don't even use, take that tool out of the toolbox and throw it behind the shop or the shed. We're not using that anymore. That's not a good tool. Well, the history of this state determined that you better not forget where you put that tool, because you might need to go back and get it and shine it up, because you might need it someday for something else as history plays out. With that, Madam Chairman, I'm going to yield to the next speaker, and thank you for your attention.
Thank you, Representative Holtorf. Members, I know we're speaking from the heart, and this is a tough, tough conversation and a tough deliberations for everybody. But I ask that we don't impugn motivations by talking about political games, political football. Let's respect that we are all struggling through our own issues here. And I understand I have restrained from interrupting the last two speakers, but I ask, let's speak from the heart, but let's speak about our own experiences and not impugn others' motivations. Thank you. Representative Jackson.
Thank you, Madam Chair. So I could never speak from a victim's viewpoint. But I will say that I have spent a great deal of time with a lot of people who have been victims of violent crimes. You know, I heard the terms up close and personal. I heard the terms easy decision. And I can tell you that, at least for me, this will certainly not be an easy decision. So, many of you know that I used to be a reporter. I have been in the middle of so very many crime scenes. Horrific, heinous crime scenes. Representative Landgraf, I covered the Peterson murder. I stood there with Scott Peterson when he was looking for Lacey. I have interviewed people. I interviewed a guy out of Texas who, I can't remember how long he spent in prison. I believe he was actually there for a life sentence. This was when DNA was just coming to the fore. And he was in prison for another heinous crime. And DNA evidence exonerated him. And in that moment, the governor pardoned him and released him. I remember he'd never seen an electric door open. He kept going to the 7-Eleven and going like, wow. The first thing he did was run around a track because he hadn't run free in decades. Lives are affected. And the fact of the matter is mistakes actually are made. One of the other things that you may not know, and it's an experience that I don't believe that anybody else in this chamber has, I've been there in San Quentin. I've stood there right next to the red phone when it rang, when the governor pardoned somebody at 2 strokes to midnight. I have also, members, witnessed an execution. I remember, you know, journalists are there to bear witness to the event. And I remember watching the families on both sides. And I will tell you from my own experience, for both of those families, their faces were very blank. There was they were both void of any emotion, pain, sorrow, relief, vindication, completely blank, completely void. So I don't know that the death penalty offers closure. I have interviewed families after the fact on both sides. So I don't say that lightly at all. I do not know what it's like to be a victim, but I have spent many, many years with people on both sides of this issue. And so all I wanted to share was that experience, and simply to say that this is absolutely no easy decision.
Thank you, Representative. Representative Catlin, you're next.
Thank you, Madam Chair. It's an honor to serve with you.
It's an honor to serve with you, Representative.
Thank you. I come down here tonight. You know, I usually don't speak too much about things that I don't know much about or that don't move me. This is one that I think is something that bothers me deeply. We're here tonight discussing whether or not we're going to pass a bill that will repeal something that the people of the state of Colorado have said they wanted. Granted, in the history that was given by one of the representatives before me, that was a number of years ago, a generation ago, or more. But I still think that these are the kind of questions that we should turn back to the voters and ask them for direction. Now, I'm not saying that I want to shirk my duty or that I want to take the easy way out. What I'm saying is, all of the time that I've been involved in public works, my previous life and this one of the things that I've learned and that I try to follow is that I trust the public. To make a joke of it, they sent me. So I trust them. But in reality and true deep down in my soul, I believe that the people of Colorado can make the right decision. This is a time where we've seen lots of things happen in our society. We talk about it, some of us bemoan it, some of us cheer it. But there is change here now. We see it every day. That's the reason that I think today might be the right answer for this House to look to one another across that aisle and say we can do something that the people have asked us to do. And that is, they've asked us to be more bipartisan. They've asked us to talk to one another. They've asked us, can't you guys do something together? This is one of those items. We could agree to send this to the people as a referendum from us. We could do that tonight. And you know, really, I think that might be the right answer in this day and age. That the state of Colorado has always been a leader, and we've talked about that in the past. That the state of Colorado has led this nation in a number of different places and in a number of different ways. That we've been the ones that have said, we'll turn to the people, we'll do this in Colorado. From what I'm seeing, that may be the right answer for Colorado today. is for us to turn to one another and say, let's try this. Rather than waiting for us to have taken an action and write petitions and do the things, maybe tonight would be the night. If it needs to be changed, and I'm not going to argue if it should be or if it shouldn't be, but if we decide that we want to ask, we want to decide should it be changed, the best way for us to do that is together turn to each other and say, let's take this home. Let's take this to our districts. Let's let the people vote on it. That would be new and different. That would be something that we could say. And we've been successful with those kind of initiatives where we've turned and said, we're going to ask you folks. We had one this last fall. Bipartisan. Yeah, it wasn't nearly as heavy as the life and death, but it did have something to do with our future in the state of Colorado, where we turned and looked at it together and said, we'll ask the people. And the people said yes. What I'm asking from you tonight is for an opportunity for the state of Colorado to look back to the people they've sent to this amazing building to do this amazing job. Because I want you to know that when I come into this building, there are times when it overwhelms me with what's gone on in this building and in this room in the past of the state of Colorado and some of the decisions that have been made that have made Colorado what Colorado is today. And I'm proud of each and every one of you, regardless of what the initial is behind your name. You've done some great things for this state. And I know that every one of us, want to do what we can to make this state that much better. Tonight, we could do that. We could do that tonight. And if you want to make headlines, be the one that makes the motion. If you want to make headlines in your district, if you want to make headlines in the nation, be the people that decide we're going to take this to the people. We're going to ask the people. You know, we live by surveys and polls and all of those things nowadays. We don't make a move unless we've checked the polls. Everybody's quoting what the survey said, the numbers. There's only really one number that counts. And that's when we've gone in that voting booth and made a check mark and said, this is how I feel. Or we send it to people's homes so that they can make that vote. That's the poll that matters. That's the survey that will count. Otherwise, we are just arguing about who's right, who's wrong, who gives a care, and who don't. But in this day and age, I think this would be something that says the state of Colorado is well on its way to being that leader again in the United States. We sit on top of the world here in our geographical condition. Let's set on top of this country with being somebody who said, let's try something different. Let's go back and ask those folks a generation ago or more how they felt about this. And they gave the word then. And I know those people that are out there today will give us the right answer for them and for the state of Colorado. So I'll ask you again, let's be leaders. Let's go back and ask the people that trusted us enough to send us here how they want the state of Colorado to deal with this issue in this day and age with this generation. Thank you.
Thank you, Representative. Representative Williams.
Thank you, Madam Chair. And thank you, colleagues. I do appreciate the level of respect and discourse that we're having on this. This is a weighty issue, and I do believe that no one's making any decisions here lightly. Case in point, we've been debating, and there hasn't even really been a single amendment, if I remember correctly. Don't worry, they're coming. I have a stack over here. But I wanted to jump in here and just kind of share a few things that are on my mind. And before I get into what I want to say, I do want to say that I in no way, believe that the intent of the bill sponsors are bad. I think there is a genuine desire to ensure that no one who may have been wrongfully convicted should ever have to be executed. And I would agree. I think we should all work to fix that system, the death penalty system, to ensure that innocent people aren't being executed. But I don't believe that we should remove it as an option. There are just too many heinous crimes. There are just too many examples of criminals that have had wanton disregard for other people's lives. And so I'll say this, I don't know if I'll do it now, I don't know if I'll do it later, but at some point I will get emotional. The past, couple weeks as I've been thinking about this, I've gone through many examples of heinous crimes and the impact that's had on victims, and they're tearjerkers, they all are. And we've already had some of that tonight. And I'll ask ahead of time, if I do get emotional, please don't stand for me. I'd rather you stand for the victims and the voters who I think are being denied justice with the passage of this bill. If you go to page 16, at the very end, in section 15, it has a safety clause. We all know what that says, but I'll read it. The General Assembly hereby finds, determines, and declares that this act is necessary for the immediate preservation of the public peace, health, and safety. I find that to be insulting. Again, I don't impugn the motives or the character of the bill sponsors, but that is absolutely inappropriate, especially with this debate. What this implies right here is that we want to protect heinous criminals who are in fact guilty of doing diabolical things that are beyond imagination. Right here, and Madam Chair, I'll take the fine as well. Right here, right now, you have John Castillo and his wife. Representative Sane read a statement from them at this well. You know what they said? They said they oppose this bill. And a decision hasn't been made yet, but I think one will be soon, whether or not the death penalty will be sought in that particular incident. And here's an example right now of a victims who lost their son, their heroic son. And they still think it's important that we keep the death penalty as an option. And I would ask any one of the bill proponents or one of the bill sponsors or supporters, can you seriously go over there and look in their eye and tell them that it shouldn't be an option? I think you'd be hard-pressed to do that. I'm sure there's some of you that would absolutely do that and could do that. But at the end of the day, that would be one of the hardest things I think anyone who supports this bill could ever do. And I would ask you to do it. I'd ask you to at least talk it over with someone who's experienced something so unimaginable. I couldn't imagine losing my child. So I ask you, go talk to them, get their perspective. But at the end of the day, I just cannot believe that we would have a safety clause on this. At the very least, we should have a petition clause. We should allow for the people to have an option, just like they did on other bills, to go and gather signatures and have the opportunity to overturn this bill. Ideally, what we should do is we should send it to the people. We should have a referendum. That was attempted actually in the Senate. In fact, the first time it was attempted in the Senate on this bill was in the Senate Judiciary Committee. Guess what? The title, it fit within the title. It wasn't ruled out of order. Then we get to the floor. We try it again. That's when it was ruled out of order. And I got to say, that's beyond me. I understand that, we can play with the title. we can try and make it tight. But I've never heard of an instance when sending a bill to the voters for them to decide was ever against our single subject rule. That's outrageous. That's outrageous. The fact that if we were to come up right now and offer that kind of amendment that would maybe, possibly, most likely be ruled out of order is beyond me. The fact that we can't even have that debate really is sad. I think it's a sad state of affairs. And I don't know why we can't have it. I mean, I have my thoughts. My thoughts are that if we did send it to the voters, they would reject it soundly. And that's based off of, history. It's based off of some polling. As an example, in I believe 2015, there was a Quinnipiac poll concerning James Holmes, the Aurora shooter. They asked Coloradans whether or not he should be executed, whether or not the death penalty should be an option. 63% supported it. That's where the people stand on this. And I think that's important to point out. Because at the end of the day, there are people who should be put to death. Period. End of sentence. We can talk about Nathan Dunlap. We can talk about, the other two individuals who are on death row. I think no one disputes that they're guilty as hell. They did what they did. And what really frightens me about this particular bill is what happens to those individuals. You've already heard, and I know the bill says, right here in the title, that it's only going to apply to people charged on or after July 1st, 2020. I know that's what it says. But at the end of the day, we've already seen signals from the governor's office saying that if this passes, he's inclined to commute their death sentences. So make no mistake, when you make this vote to pass this bill, you very well may help those 3 people who deserve death, who deserve that justice. You may be helping them to escape it. And that's a problem that I have. But even if the governor doesn't do that, that doesn't mean that the courts won't intervene either. There have been examples from around the country when a state removes the death penalty as an option, where defense attorneys will come in and through the appeals process will argue that the death penalty for people who are currently on death row should be invalidated. They should be resentenced to maybe life without parole because of changing community standards, because the legislature ended it. So even if the governor doesn't follow through on what we think he's going to follow through on by commuting those sentences, the judiciary very well may do that. So I implore everyone here absolutely to vote no, but at the very least send it to the voters. Because this isn't just about crimes that are going to be committed after July 1st, 2020. This could have very real impact on the current people on death row right now that absolutely did what they were accused of doing. No one disputes that. And if that's what this body wants to do, then I would say shame on us. I can tell you there's at least 24 of us that don't want to vote for this. And I would hope that there would be more from this side. But don't kid yourself. This is not going to solely apply to people convicted after July 1st, 2020. This is going to have a very real impact on people that should be brought to justice. And that's why I think ultimately this bill is a miscarriage of justice. I don't care about arguments of deterrence. I don't care about arguments of cost. For me, this is a moral question. This is a matter of justice. And the practical effects of this are injustice. It's immoral. At the end of the day, for me, it's immoral for us to pass this bill, despite the intentions of the bill sponsors. The practical effect is haunting. Because there are various people who have suffered very heinous crimes. And, members, I'm going to go ahead and leave it at there for the moment, but I will be back up here and I will share with you some of the things that I've researched and some of the things that I've seen. And they should haunt all of us, especially those who would vote yes to support this. So I ask right now that you vote no, but at the very least, send this to the people. Let them decide. Thank you.
Representative Milton.
Hey, Madam Chair. And I rise again in support of this bill because, well, I guess I got called down here to the well because I'm hearing some things that are taking place, and that's maybe that we are not willing to punish those that should be punished by passing this bill, which is not true. We're saying that you should get life without parole if you do many of the heinous things that I've heard here in the well. I've heard these stories not only here in the well, but in committee. And yes, there is evil out in the world, and that evil should be met with punishment. But let's not kid ourselves into thinking that jail is not punishment. I just heard it earlier tonight. Someone said that, oh, this person is going to get a 40-year vacation. If that's the case, then why have we debated about the Department of Corrections for year after year? Why have we talked about the validity of private prisons versus public prisons? Why have we talked about this subject for so long? When you downplay what prison is, then you might as well slap in the face of all other victims. All the other victims who maybe didn't lose someone in a heinous crime, but they lost someone, or they lost property, or they were still victim to some crime. And the person that did that is sitting in a jail cell right now. Because that, again, is punishment. Punishment doesn't have to be death. I repeat that, punishment does not have to be death. These people will never see the light of day again. But I say, in order to make sure that we as a state don't mess up, that we don't execute the wrong person like we've done in the past, then let's take this off the books. I don't want to see another governor have to commute a sentence after it's been executed. As a legislator, I can't live with that, knowing that I could have done something to protect an innocent life. So I can't sit here and listen to us pretend that jail time is not punishment. Jail is not a vacation. Maybe you don't know someone that's been through jail. Trust me, in my neighborhood, from my community, I know plenty. I know plenty that have fallen subject to a broken judicial system. They'll tell you that it's no picnic. And trust me, they got out. These people won't. They won't. They will live every day for the rest of their lives understanding what it is that they did, hopefully feeling the impact of what they did to those families. If they die, they don't feel anything. They die, they go to sleep. They get the needle, they go to sleep. They won't have to live with the guilt of knowing what they did to those families. Let's not ignore the victims that are out there right now, whose accusers, who have people in prison right now. And let's not downplay it. Jail is real. Life without parole is real. I just heard it from another member who said that they're still against this bill because they said that life is still death. It's death in a different way, but it ensures that we don't execute an innocent life, and that justice is applied evenly, equally, and fairly. So again, members, I ask for an aye vote.
Thank you, Representative Weissman.
Thank you very much, Madam Chair. And, you know, members, I think I wanted to touch on a number of things that we've now been talking about at length here. A wise person once said, and I wish I could remember who and where, because I believe in giving credit where it's due. It might even have been in this chamber. But somebody said recently that grief is love with no place to go. And I think when you hear this bill in committee, when you engage with people whose lives have been changed by heinous crimes, you appreciate the reality of that. You appreciate the love of a mother or a father for their children. So I'm a little bit afraid that we've drifted into a question that I truly do not believe this bill is about. The question is not whether heinous crimes are committed by the hands of men and women whose hearts have gone dark, because we know that they do happen. And the question is not whether those heinous crimes should be grievously punished, because the answer is, of course, they should be. You know, I think at the bottom of it, we wish that we could bring people back. We wish that we could undo what was done. We wish that maybe some punishment could do that, but we know that they can't. You know, some words got into my head when I was a lot younger from an English poet, John Donne. Oh, how feeble is man's power that if good fortune fall, cannot add another hour nor a lost hour recall. We wish we had that power, but like the poet said, we don't. We are left with love that has been, we're left with love with no place to go, and now we call it grief. And we know that we can't bring back people who have been taken from us. So the only question is, what do we do now? Do we seek to turn the wheels of the machinery of death, which we know is difficult and slow? Or do we seek justice by a very grievous sentence, life in prison without the possibility of parole? So as we struggle with that question, I think we need to bear in mind a couple things, and I'm not going to repeat what's been said earlier, but, you know, we've talked about the cost of the system, and I agree the dollar cost is about the least thing that we could talk about. But there's the human cost, there's the psychic cost. One statistic I saw is that the average district attorney spends 4,000 hours on a capital trial. That is a lot of hours that could be put to prosecuting justice in other offenses. You know, why? Why are these capital trials so long? I would submit that it's because the gravity of the sentence and the Constitution itself requires them. The American Bar Association has a document, a set of standards that capital defense attorneys are obliged to follow. It's been cited to by the United States Supreme Court. It's almost 200 pages long. You know, any defense attorney will tell you that when you are defending a felony one charge, it is not a small matter, but a capital matter is so much more beyond that. Typically, there is not just one attorney, but a whole team of them, 2 attorneys, 1 investigator, 1 what they call a mitigation specialist. Gets back to the statutory mitigating factors we've talked about. In some cases, investigators have to travel to other states and other countries to interrogate those mitigating factors, because that's what the law requires. Here in Colorado, it's a fact that typically defendants in capital matters do not have their own counsel. They are represented by attorneys from the Office of the State Public Defender. And on appeal, it necessarily involves the alternate defense counsel, the conflict counsel for the OSPD, because necessarily the question of ineffective assistance is going to be raised. So we have to think about all of that if we're going to try to put capital sentencing into issue. You know, we've heard about deterrence and public safety, and again, I'm not going to repeat there. But there are some really suggestive, curious data out there. It happens that a lot of states in the American South still have the death penalty on their books, still execute defendants. And if you look at the data, you would find that the homicide rate, for some reason, perhaps against intuition, is higher there. FBI reports that the homicide rate in states with the death penalty is anywhere from 25 to 46% higher than in states that don't have it on the books. Why? Candidly, I have not managed to answer that question satisfactorily, but one of the witnesses we heard from in committee suggested simply that government is the great teacher, whether we mean it to be or not, whether it wants to be or not. How do we send the message that killing is wrong if we do it in the name of punishing those who have killed? You know, we've talked about racial disparity and inequity, and I think we should be deeply bothered by these data, both here and in other states. And yes, we question the death penalty in Colorado and not other states, but when we make laws here, we do make them not just for our present time, but potentially for the rest of time. So I think we need to have a comprehensive look at what's going on. 34% of everybody executed in this country since the death penalty was re-legalized by the US Supreme Court in 1976 were African American. 13 to 14% of the US population is African American. So you've got a pretty profound disparity there, and I would suggest that we should be bothered by it. Death penalty is sought 4 times more frequently where a victim is Anglo than where a victim is African American. I would suggest that we should be very bothered by that. The Death Penalty Information Center records 21 instances of capital sentencing involving a white defendant and an African American victim, but 294 where there was an African American defendant and an Anglo victim. I would suggest that we should be very bothered by that. And we heard another statistic in committee that right now, 41% of all of the people on death row all across the United States are African American men. 6 or 7% of the US population are African American men. I would suggest we should be very bothered by that. You know, we've heard about the disparate impact of the death penalty on folks with developmental disabilities. One of the chilling things that I came away from our committee hearing with was the reality that the 2002 Supreme Court case, Atkins v. Virginia, is actually doing less than I had thought a week ago to prevent the application of capital sentencing to this population. We've heard that folks with an intellectual or developmental disability are 8 times more likely to falsely confess because they think that's the right thing to do. I think it is suggestive that Mental Health Colorado, NAMI, ARC, the Colorado Cross Disability Coalition, Disability Law Colorado, and the Colorado Psychiatric Society all support Senate Bill 100 for this reason, because it is their work to advocate for these communities, and they understand the disparate impact of this sentence on those communities. I think it's also pretty profound that the Colorado Bar Association supports repeal. You know, members there are over 50,000 lawyers in Colorado, and about half of those on active status. A lot of the members of that association. I'm sure there's a split of opinion among the membership, but nonetheless, the association took the position to get this sentence off the books. And Madam Chair, I appreciate what you said several minutes ago about how we characterize this issue, but I would like to underscore that because it's deeply important to me. There have been references to politics here. And I would really just ask all of us to refrain from any such references for the rest of the night or into tomorrow morning or until the sun comes up or however long we are here. because this is not a political question. This is the ultimate moral question that this legislative body can possibly grapple with and answer. I would further say, you know, the easy thing, if one were interested in politics, the easy thing would be to not bring this bill. The easy thing would be to not have this discussion. But we are not here simply to do the easy thing. We are here to grapple with the hard thing, and in grappling with the hard thing, to try to find a way to do the right thing. And some of us believe that the right thing is taking this penalty off the books, even if it is used infrequently in this state. Because having this penalty at the top of the pyramid of the criminal justice system defines everything else under it. Because if government can take a life and call it lawfully done, then government can do anything else. And I would suggest that we should be concerned about such a government. And finally, Madam Chair, I expected to come to some of these comments a little bit later in the evening, but you know, since it's been put into issue. You know, it's been suggested that to take this penalty off the books is immoral. I respect that opinion if another member hasn't. I happen to believe, very simply, that the death penalty is immoral. It is immoral in its application. We have seen that. It is immoral for a government to try to exert this power over its people. And in my research, I have found plenty of support for that proposition in faith traditions, various faith traditions going back 2,000 years or so. I take no pleasure in the death of the wicked, but rather that they turn from their ways and live. Ezekiel 33:11. From Maimonides, Sefer HaMitzvot, 290th negative commandment, 12th century. If punishment was based on estimation and circumstantial evidence, it is possible that someday an innocent person would be executed. And thus, as Maimonides relates, the sacred text in the Jewish faith, he urges against the death penalty. In 1995, then Pope John Paul II wrote, I'll read only part of this for now. Today, however, as a result of steady improvements in the organization of the penal system, such cases warranting capital punishment are very rare, if not practically non-existent. In the year 2000, the Orthodox Union, which is a collection of over 1,000 Jewish congregations, endorsed a moratorium in the death penalty, citing to all of the issues we've been talking about tonight. In 2014, Pope Francis said, all Christians and men of goodwill are called today to fight not only for the abolition of the death penalty in all of its forms, but also to improve prison conditions in respect of human dignity and persons deprived of freedom. And in 2018, the Catholic Catechism was officially and formally updated to state in part as follows. The Church teaches, in light of the gospel, that the death penalty is inadmissible because it is an attack on the inviolability and dignity of the person. And she, the Church, works with determination for its abolition worldwide. So, members, we are a diverse state. We are red and purple and blue and urban and rural and suburban and everything in the middle. But of all the questions that we could possibly debate here, to tax and spend, to regulate and proscribe, to incentivize and discourage, this is it. This is the question. This is the weightiest thing that we can possibly discuss. And I'll say again, I believe that it is not moral for this state or any government to say that it can execute people. So I ask for your support.
Representative Gray.
Thank you, Madam Chair. Members, I counsel humility. I counsel humility to everyone in this chamber. There are only a few of us who sit in this chamber who've ever been through a criminal trial, much less several criminal trials. And I will admit to you, without naming names, that there have been many things said this well thus far that betrays that betrays a misunderstanding of how criminal trials work, and that's all right. There's a lot of things we debate in this chamber that I haven't been through that I have to vote on anyway. But I counsel humility. I counsel humility about how the system works, about how certain people feel about it, about how it treats individuals, because the criminal justice system is something that everybody feels like they understand because they've sort of seen it in action a little bit, but it's a lot more complicated than you think it is. And we make a lot of really bold statements through these microphones. And those bold statements land on people who have had that experience, who have been through that justice system. And they hear it through the lens of actually having the experience that the folks in this room don't have. And so you don't know when you're saying things that don't make sense for folks who have been through the process, whether as a defendant, as an attorney, as a victim, you name it. You're expressing your best understanding of what's happening. And the way it's landing with folks who've been through the experience is, I can't believe somebody just said that when that's not at all how this goes, and it's such an important part of my life. And I'll say it most acutely with respect to victims of crime. A great number of us have come to this well this far and have talked about how this will affect victims of crime, and have made statements about how this will affect victims of crime without knowledge of what being a victim of crime is like. And there are victims of crime in this room right now, and they hear you, and they understand what you're saying, and they say the folks who are going to make this policy are about to make this policy not understanding what it's like to be a victim of crime, because they betrayed it by the way they stood at this microphone and spoke about it. And so what I would say is, speak to your beliefs, speak to your understanding, speak to how you feel. You were elected to make decisions in this body. Don't speak to the experiences of others if you don't know you fully understand them. Because when you do, the folks who do have that experience can hear and feel like this process is being removed from their control. And the folks who are making these decisions are doing it without understanding where they're coming from. And I will tell you, if you want to understand what it is to be a victim of crime, you're going to hear from one of the victims of one of the most serious crimes in the history of the state here in a little bit. And I would say, if you want to know and if you want to internalize as part of this debate what it is to be a victim of crime, if you don't know, instead of talking, get ready to listen. The way to understand what it is to be a victim of crime is to listen to victims of crime. And you're going to get to hear from at least one soon. There are others around. But instead of thinking about what your view is and then thinking about how that could be good for victims of crime, if you want to talk about victims of crime, listen first and then maybe talk later. But they're here in this room. You're going to hear from them soon. But they also hear every time one of us describes the experience of being a victim of crime in a way that's not accurate, which has occurred. And they hear it and they feel it all the time. So my request is just continue the debate, vote however you want to vote, but proceed with humility. Speak to what you know, and don't speak to other people's experience that you don't know, because those people may be in the room and you may be speaking to the hardest thing they've ever gone through in their life. Thank you.
Representative Singh.
Thank you, Madam Chair. It's not very humble to lecture us on humility. If you want to hear about other stories of victims of crime, let me share one with you from my community. There's a Frederick police detective. He fled a restaurant when two girls walked in. And even hundreds of miles away from when the crime occurred, he couldn't escape the reminders of the case he was trying to move past. At the sight of the girls, he's once again at Weld County at an oil site, where 8 months ago he discovered the bodies of Bella and Celeste Watts. In movie-like detail, he saw the hazmat crew pull their bodies from the oil storage tanks where they had been dumped by their father. He smelled the oil that coated them. He saw their mother's shallow grave nearby. The trip was supposed to be a chance for him to clear his head after leading the investigations of the murders of the girls and their pregnant mother, Shanann Watts. The killer, father, and husband to the victims had already confessed and received multiple life sentences. Detective Baumhover's work was done, but he bolted from the restaurant to escape a flashback. Rage, grief, anxiety flooded his body, and he knew it would take more than a trip to heal the post-traumatic stress disorder he was diagnosed with after the case. He knew it was time, he would need time before he could see little girls without being triggered. He says, like when you're a kid and you go to the wrong carnival ride and all you want to do is to get off, but you can't. You have no choice until the ride shuts off. Except he doesn't know when it's going to shut off. A year after the high-profile murder shocked Colorado and drew international attention to my small Colorado town, some of us are still grappling with this, including those who investigated the case. They suffer nightmares or are haunted by a lasting memory of girls' giggles. A veteran law enforcement officer can't shake the images of the well site where their bodies were recovered. And the continued media interest in documentaries are making it difficult for them to heal. Detective Baumhauer hasn't worked since his PSTD diagnosis in March because his symptoms are just so severe. He's not sure if he'll be able to return to law enforcement, a career that once drew him like a magnet. He doesn't think he can expose himself to the inherent trauma of the job. I have a hard time dealing with the possibility that my career has ended and not the way I wanted it to, he said. Some days you feel absolutely defeated. During the prison interview, Watts revealed how he killed Shanann and put her body on the floor in the back seat of his truck, and how he didn't put the girls in the back seat, their feet dangling above their mother's body during the entire ride to the rural oil site. He explained how he smothered the girls individually, how 4-year-old Bella had to watch her little sister die. Baumhover went to Wisconsin because he wanted to know what happened, and he thought knowing would give him closure. And it did, he said, but the answers came at a price. He said the night after the confession, he lay up in his hotel bed. His wife lit up his phone, anxious, but Baumhover couldn't answer. He couldn't think, he couldn't understand how such a horror was possible, and how Watts could coldly detail it step by step. His first morning back home at Frederick, Baumhover broke down sobbing at his kitchen table. He didn't know how he was going to tell Shanann's parents. He knew it would destroy him, and it was the first time his wife had ever seen him cry. He tried to go back to work, but the flashbacks worsened. He stopped sleeping. Gaps started to form in his memory. He couldn't remember names or control his emotions. After his diagnosis in March, he entered counseling. After taking some sick time, he registered with workers' compensation. Baumhover had worked in Colorado law enforcement for the bulk of the past 20 years in a variety of roles. It was just a calling, a nagging that kept pulling me back in. Baumhover had joined the Frederick Police Department full-time in search of more low-key police work in a smaller community. He was promoted to the agency's lone detective, and he loved the job despite the long hours. But every bit of the Baumhover family life has now been reshaped by PTSD. It's even hard to leave the house. Where do you go where you don't see little girls? It's dangerous to watch television or to go online. He is completely imprisoned. If they can go out, if there's a family, she'll say, don't look right, look up. I feel like if I don't catch one, like I miss one, that I failed him, she says, the wife. It's easier just not to go anywhere. Lasting trauma from the case was not limited to this detective. 2 days after witnessing the recovery, Colorado Bureau of Investigation agent Tammy Lee broke down at a Denver hair salon. A veteran investigator, she had handled scores of gruesome cases, and she expected this one would be taken in stride. Instead, she sobbed at the hair salon as her helpless mother and sister looked on, and she couldn't stop. She sat in her car, called the number for a counselor she'd be given, and said she didn't understand what was happening to her. She scheduled a therapy appointment for 8 a.m. the next day, and the counselor asked her to write down what would trigger her crying, and she listed the incidents, mostly seen moms with kids. It would make her think of how Shanann never went out to get those small moments with her daughters again. That Shanann would never go to lunch with them. She'd never buy him a new outfit. There are endless videos and photos of the girls that Shanann posted online, which Lee reviewed during the investigation and created a mental image of the sisters. And she kept thinking of the video of the girls when Shanann told them that she was pregnant. How the girls laughed and jumped up and down at the news and pulling their mother into a very long hug. I felt like I knew them, Lee said. I had been to many homicides of children. This one was different. I felt I knew what they sounded like. I knew what they looked like when they played and how they sounded when they giggled. I felt like I was mourning their deaths. I see those little girls, their faces and their names, and every time I think about them, the next thought in my mind is about my own daughter. In a way, I think I've become more hardened to what people can do to each other. Through counseling, Lee said she was able to process her grief, and she attended an interview with Chris Watts in Wisconsin, where his full confession helped her find some closure. But still, she says and reiterates, media interest makes it difficult to move on. The Colorado Bureau of Investigation still regularly receives emails, social media messages, and calls about the case. The office has been contacted by people as far away as the United Kingdom and Japan. And television stations continue to create documentaries. Lee said you can't get away from it. Excuse me. The Watts case was traumatic for law enforcement, for the general public, and for my community. Many of us have seen those same videos. The killings didn't make sense to people. And there are few of the hallmarks of other murders because there was no signs of violence before the killings. The Watts family seemed normal. In the meantime, Detective Baumhauer can't wait for summer to end for the neighborhood kids to go back to school so he can look at the playground visible from his back porch, walk the dog, and not worry about running into children that trigger his flashbacks. His wife says it'll be a big victory when we just get to have joy watching little kids play. The last words from Watts' daughter was, "Daddy, no." And that revelation came from a February 18th prison interview he gave to the FBI and the Colorado Bureau of Investigation. Watts said he initially woke up at 4 a.m. this morning and talked to his wife, who'd returned home from a business trip just before 2 a.m. about a separation. Watts said that despite the emotional conversation, during which they both cried, it did not get confrontational until he left work about 5:30 a.m. His wife and daughters were in bed. In the days that followed, he played the part of the worried husband and father, giving a television interview outside the family's home, pleading for their safe return. Shannon, who had lupus, was 15 weeks pregnant at the time with a son she planned to name Nico. Watts, who was having an affair, broke down and confessed August 15 to killing his wife, first to his father and the 2 investigators. He claimed he strangled Shanann in a rage after she killed her daughters because she wanted a divorce. But all of his previous claims that night were turned upside down with a new interview, which investigators conducted to obtain more information about the murders. He gave investigators more detail than before about what really happened when she returned home from a business trip. According to a report written by Lee, who we just heard from, he said he and his wife had sex 30 minutes after she got home. And in his head, he felt like she knew about the affair with his coworker. He told investigators he and Shanann fell asleep afterwards, and he woke her up after getting ready for work. When she woke, she turned over and back, and Watts said he straddled her to talk. Shanann told him she was possibly hurting their unborn baby and told him she knew there was somebody else and began crying. He denied the affair and told Shanann he didn't think their marriage would work. When he told her he no longer loved her, Shanann allegedly threatened to keep the children away from him. "You'll never see these kids again. You're never going to see them again. Get off me. Don't hurt the baby," Watts quoted his wife saying. That's when Watts strangled Shanann. Watts said she never screamed or fought back. He believes she may have been praying as he took her life. Watts theorized the noise from Shanann's death may have woken Bella, who walked into the master bedroom holding a blanket. She asked, "What is wrong with her mother?" "Mommy don't feel good," Watts told the little girl. And Bella watched as Watts dragged her mother down the stairs, and she began to cry. "What's wrong with Mommy?" she asked again. Watts repeated that Shanann didn't feel well, but told investigators during the interview, "Bella is a smart girl. She knew what was going on." The sound of Shanann being dragged down the staircase woke Celeste, who was getting out of her bed, when Watts returned from replacing Shanann's body in the rear floorboard of his truck, which he backed down the driveway. He loaded Bella and Celeste on the truck's rear bench seat, their mother's body at their feet. He had placed a gas can in the back of the truck, suicide on his mind. "Is Mommy okay?" Bella asked. At the time when the videos were played, they had thought the girls were already dead, but Bella and Celeste were still alive, each carrying a blanket and Celeste cuddling a stuffed dog, dozed on and off on the ride to the Anadarko site, Watts said. They held each other in their sleep. And they lay in each other's laps. At one point during the ride, Bella told him, "Daddy, it smells," the report said. The document indicates as Shanann was being strangled, her bowels had evacuated. Once at the tank battery, Watts removed Shannon's body from the truck and dragged her over to where he planned to bury her. Both girls asked what he was going to do to her, but he couldn't remember what he told them. Back at the truck, Watts grabbed the New York Yankees blanket Celeste was holding and put it over her head, the report says, and he strangled her on the back seat of the truck as her older sister sat by her side. He put his hand over Celeste's mouth and nose, over the blanket, his other hand around the front of Celeste's neck. Bella was seated right beside Celeste as he strangled her, but Bella didn't say anything. When Celeste was dead, he carried her from the truck and over to one of the oil tanks, where he opened the hatch and dropped her inside, feet first, and closed the hatch and went back to the truck. Bella asked what happened to her sister. Watts told the investigators he wasn't sure if he responded affirmatively or not. He put the Yankees blanket over Bella's head. "Daddy, no." Watts said those were Bella's last words. And Bella put up a fight for her life. Watts told the investigators he could hear her grunt as she tried to breathe, her head twisted back and forth under her blanket. Autopsy results on her small body showed she bit through her tongue multiple times as she struggled against her father. And the violence against baby Nico was so great he was partially expelled from his mother's body. So now we know she was possibly beaten before the horror of her strangulation. Members, I've heard some representatives say that they didn't think that the death penalty was moral. In the upside-down world here at the Capitol, there are legislators that will vote to let a cold-blooded murderer go free, some with 28 witnesses, without a shadow of doubt. but allow an innocent baby born alive to be slaughtered in front of his physician on an abortionist's table. I don't think you can make that decision. A representative on this prevailing side if you want to give the message that murder is wrong, then vote no on this bill. And don't tell us about humility.
Representative Will.
Thank you, Madam Chair. It's an honor to serve with you.
It's an honor to serve with you.
So, I have the utmost respect for the bill sponsors on this bill and for everyone in this room. I formed an opinion about, I think, the death penalty years ago. And, you know, we're talking about locking them up and keeping them for life without parole. I'd like to bring you back to the Ted Bundy story. He was in custody twice. Jumped out the second floor window, Pitkin County Courthouse. I was around there then. Then he got held in the Glenwood County Jail, Garfield County Jail. Starved himself. Lost 30, 40 pounds. Crawled out through a 12 by 12 inch light fixture into the night. So, you know, his victims were all beautiful. They're in their late teens, early 20s. They all had dark hair, parted their hair the same. Pretty creepy. So, you know, as children, we all had the innate fear of the boogeyman and things that go bump in the night. But what if the monster had a charming smile, dresses well? What if the monster's your friend, your coworker, your classmate? What then? Ted Bundy was one of those monsters hiding in plain sight. He was intelligent, was a good-looking man, studied psychology at the University of Washington, later went to law school at the University of Utah, had a pretty girlfriend named Elizabeth, volunteered at the suicide prevention hotline in his spare time. He also murdered over 30 women across 7 states in 4 years. So before Bundy made it to Colorado, he'd already killed about 21 women before he showed up and killed the one in Snowmass, Colorado. But after terrorizing Washington, Idaho, Utah, Ted arrived in Snowmass Village, my old stomping ground, my country, where I work. It's the beginning of January of '75. Probably a lot of you in this room weren't born. I happened to be around there. I remember Ted Bundy well. Was on winter break from law school. Within the first 2 weeks of the new year, he'd abduct and murder his first victim in Colorado, Carolyn Campbell, nurse from Dearborn, Michigan, staying at the Wildwood Inn. I trapped many a bear at Wildwood Inn. I know that place well. Disappeared January 15th while walking from the elevator to her room. Her battered body was found a month later. She'd become Bundy's first Colorado victim and his 14th verified victim at the time. In March, right over to Vail, Colorado, ski instructor Julie Cunningham, walking from her home to meet up with friends when she was approached by a handsome dark-haired man on crutches, asking for help carrying his ski boots to his car. Happened to be Bundy. He clubbed her, restrained her, drove her to Rifle, where he eventually killed her. Body was never found. Part of that, when Bundy was to be executed, he did admit to a lot of these murders. He gives some general direction, so Julie Cunningham was, and we were told, as a game warden at the time working there, we were told he got off a few minutes from the interstate, one of the exits, so we started really looking from Canyon Creek, which is just west of Glenwood Springs, clear to the Beck, right off the highways. We looked for many, many years. Anytime we were out in there, we were looking for her remains. Never found them, never was found. At the beginning of April, Denise Ulverson was riding her bike in Grand Junction. Many of you probably remember this. Just to clear ahead when she vanished without a trace. Her sandals and bike were found near the viaduct, but her body was never found. It wasn't until 1976 when the self-styled most colored SOB you'll ever meet was finally connected to these murders. More specifically, with Carolyn Campbell's murder, she was the only victim whose body was ever found. At this point, Bundy had been in prison for the kidnapping of a teenage girl in Murray, Utah. FBI technicians had impounded and dismantled his 1968 Volkswagen Beetle, discovered hair matching Carolyn Campbell's. By then, there were over 30 investigators working all over the different murders Bundy had committed, but his conviction had been finalized. They convened in Aspen in November of '76 to exchange information. By the end of the meeting, they were all certain Bundy was responsible for all the murders. Colorado authorities had charged him with Carolyn Campbell's murder, and in January of '77, Bundy was brought back to Colorado to await trial. Bundy was finally brought before a judge in Pitkin County Courthouse in Aspen to begin the trial for Campbell's murder. Bundy had insisted on representing himself to the court so the judge would remove his shackles and handcuffs. During a recess, Bundy was granted permission to use the law library to research his own defense. Using the bookcase to hide himself, Bundy leapt, broke out, jumped out the second-story window, Pitkin County Courthouse. If any of you have been there, that's a pretty good jump. Sprained his ankle upon landing, but he removed his jacket, altered his appearance, and walked out of Aspen to the mountains as the police set up roadblocks. For 6 days, Bundy was a fugitive, close to the summit of Aspen Mountain, broke into a cabin, stole clothes, food, supplies, to continue his evasion of police and search parties. He headed south as if he were trying to make it to Crested Butte, but for reasons unknown, he drove back to Aspen in a stolen car. He was apprehended and sent back to Glenwood Springs Jail. A couple officers thought he was DUI. That's how they ended up getting him. Then once he was in Glenwood, he planned his other escape. So those 6 days on the lam had given Bundy more attention than he wanted, and he insisted on his trial being moved to Denver so that any potential jurists wouldn't have skewed opinions of him. There's our judicial system at work. The judge declined to move him to Denver. Instead, he would be moved to Colorado Springs in January. Since his failed first escape over the summer, Bundy had formulated and implemented a more detailed escape plan. Over the months, his girlfriend, Carol Ann Boone, surreptitiously bought him $500, and he acquired a detailed plan of the jail and a hacksaw. This is in Glenwood. After sawing a hole in the ceiling of his cell by the bars, he dropped 35 pounds so that he'd be able to squeeze through the hole, which is that 12 by 12 hole I talked about. He piled books in his bed, covered them with a blanket, then slipped out of his cell, stole clothes from the jailer's apartment that he dropped into after he crawled around the ceiling of the jail, walked out the front door. So, you know, we talk about locking these people up and for life without parole, et cetera. I mean, Bundy escaped twice, so that's not good enough for me. And I know it's not good enough for the victims. So employees at the Glenwood Springs Jail weren't aware of Bundy's escape until around noon the following day. It's 17 hours he had head start. But then Bundy had hitchhiked from the mountains near Glenwood Springs to Vail, caught a bus to Denver, boarded a flight to Chicago. He would never set foot in Colorado again, thank God. Ann Arbor and Atlanta, then on to Tallahassee, Florida, where he'd committed his infamous murderous frenzy in the Chi Omega sorority house that we all know about. Left 3 women dead and 1 permanently disabled. It was for these 4 women's death that Bundy finally stood trial, again acting as his own attorney, was convicted and sentenced to die. Sent to elected chair January 24th, 1989. Florida State Prison. It's been 30 years, about 30 years, since Bundy was executed in Florida. Questions still remain about his murders. As mentioned at the beginning, the bodies of the 2 of the 3 women he'd killed and desecrated in Colorado were never found. He did confess to them while he was on death row. There are also a couple of cold cases in Colorado at the same time period, some of them right here on the Front Range, that could be tied to Bundy. There's never sufficient evidence. Bundy never admitted responsibility for them. One of Susie Cooley was a teenager attending Netherland High School, found in Coal Creek Canyon. Receipts from the gas station placed Bundy there and there at the same time. Shelley Robinson of Golden, found in Berthoud Pass Mine, August the same year, again with receipts proving Bundy was in the area. As time stretches on, continued advances in forensic science will hopefully continue to aid investigators in answering some of the lingering questions and infamy of the monster that was Ted Bundy. So I bring that up because I can tell you back in those days and dealing with the Ted Bundy and kind of being near and dear to that when he escaped. I was actually working temporary for the Division of Wildlife and actually around some of the roadblocks. There was always roadblocks around there, especially after he escaped from the Pitkin County Jail. But I worry that his escape like that, crawling out of that light fixture, that's not good enough for me. I don't think that's good enough for anyone in the room. So, you know, we can debate the issues on whether we should or shouldn't. My opinion is Ted Bundy of the world need a death sentence, and he got it. And I'll use a good analogy. I was in, as you all know, I was in the wildlife business for a lot of years. One time I was talking to a sheep rancher, me and one of my colleagues. We were talking about the merits of predator hunting. Shooting coyotes, we're eating sheep, right? Well, if you're a sheep rancher, that's what you do, protect your stock. You hunt the predators. My colleague, young kid, didn't quite understand. He was talking to the rancher. He said, well, you know, you can shoot these coyotes, but it really doesn't make any difference. You know, there's just going to be more replacement. In the big scheme of things, that dead coyote's not really going to make much difference, you know, in the amount of stock you lose. And I'll never forget what that rancher said. He said, well, you might be right, but I'll promise you that dead coyote will never eat another sheep. And I'll leave you with that. Thank you.
Representative Sandridge?
Thank you, Madam Chair. So it's kind of interesting, the debate this evening. I want to thank everybody for their opinion. As this is one of those debates, personally for me, I see great points on both sides. I see one side saying, hey, there's some issues with the death penalty. There's some holes. There's some racial components. And if you look at the statistics, yeah, there are some problems. There really are. But then you have another side that says, listen, we need this tool for the most heinous crimes. So it's kind of like a lot of debates we have. We have one side kind of focusing on one end and another side focusing on the other end. But I want to kind of go back to, actually, I think Representative Gray kind of brought this up about kind of people not knowing, sometimes talking about things maybe they're not really in tune with. That's one thing I've no idea how it would be to be the family member of a victim. No idea whatsoever. I can only imagine if one of my family members was a victim of a heinous crime where the perpetrator earned the death penalty. So that's kind of why I sit back a little bit and I give pause before I want to strip that tool away, because I just don't know. I just don't know. And I think for some of us to sit there and maybe act like we do know, or we know what's best for these family of victims of crimes is something difficult for me. And I'm just going to be real brief on this. Just because I can never put myself in their shoes, I don't want to take this tool away. And I know, sometimes I speak to that camera because I know people are watching, and I'm guessing maybe family members of victims are watching right now. And, I've seen documentaries where families of victims associated with Nathan Dunlap, where they cried over the loss of their family member. And maybe some of them are watching this evening. But I want to say to the family members of the victims of Nathan Dunlap, I'm here for you. And I'm not going to strip the death penalty away from you. And I think some of them are listening right now. To Senator Fields and her family, I support you, and I'm going to support you with my no vote, because I can never imagine what you've gone through. And for me to override your will is something that I can never do. To all the jurors who voted for death, I'm not going to erase your decision. You listened to the testimony. You were part of the process. And I'm not going to erase your decision. So I'll be a no today. To all the future victims and family members of victims who wants these tools. To all the victims that will suffer the murder, to all the family members who will have to deal with this on a daily basis, I will not strip this tool away from you. So again, there is room for improvement for the death penalty if we're going to keep it. I think I definitely hear you, and I have to agree with you. But do we improve it, or do we just take that tool away from these people who are hurting the most? I just can't do that. I can't take this tool away from them, because I can never put myself in these families' shoes. So to all who are listening, I'm with you, and I will support you with my no vote. Thank you.
Representative Buck.
Thank you, Madam Chair. And humility. Yeah, I heard that word, and it just kind of lit me up. No, I am not a prosecutor. No, I'm not a district attorney. I'm your Joe citizen. Joe citizen that knows in this legislator body where we think we are representing the people, we have seen bills pass that we had to get a ballot initiative to reverse it. National popular vote. Trying to mess with Tabor, so we all had to get out there and no on CC. Folks, you've overstepped, and this is another time where you're overstepping, where I ask you all to take this to the vote of the people. This is a big and large bill. A bill that we have such incredible victims that I could never even look in their eye if I ever did support such a bill. I couldn't do it. And I'm telling you that we have overstepped in this body many times, and we have to raise the money to get it on the ballot. And I ask for this bill alone because it is a big bill. And I don't think we have enough representation to think that we know what's better for our district attorneys, our victims. So I please ask you, for the love of God, please vote no on this bill. Thank you.
Thank you, Representative Buck. Again, we're speaking from the heart, and this is a difficult issue for everybody, and I ask that we stay with what's in our hearts and our thoughts and not impugn the motivations of others. Representative Ranson.
Thank you, Madam Chair. I have an email that was sent to me, a statement from one of my constituents named Linda. In the fall of 1993, I started my junior year at Smoky Hill High School. One of my classes included American law, and one of my classmates was my friend, Ben Grant. There were two activities during that class that are etched into my memory forever. The first activity was a field trip we took to the Denver County Courthouse. The purpose of the field trip was to explore the court system, trial procedures, and criminal law. Ben and I spent the entire field trip together visiting different courtrooms and cases and completing our assignment together. We rode home on the bus together, and Ben said goodbye to me on his way to work at Chuck E. Cheese. The second activity of our American law class, etched into my memory, is an in-class debate. In pairs, students had to pick from various topics of law, choose their position for or against their topic, and hold a debate in front of the class. The debate took place sometime before our field trip, but the topic of my debate was the death penalty. Ben and I had chosen to be partners. We were both proponents of the death penalty, but Ben was adamant that he would not argue the side against its implementation. I took on the role of arguing against the death penalty in a debate with my friend, but have never changed my stance in support of the punishment. The reason these two activities are etched in my memory is because they have also scarred my heart. My friend Ben Grant was murdered after our American law field trip. The trial against his killer included the death penalty. This is one instance where the opinion of the victim is known. Ben believed in the death penalty and clearly would have sought it in his own murder. Neither Ben nor I would ever imagine that our American law field trip, taken as students at Smoky Hill High School, was foreshadowing to the subsequent events and the actions of the person that took Ben's life. Thankfully, the jury deciding the fate of the mass murderer, Nathan Dunlap, was unanimous in sentencing him to death. Although we have not seen justice, there is still hope that his sentence will eventually be upheld. Other victims have not been as lucky in the pursuit of justice during sentencing, such as the People versus Alan Thomas Jr. and the People versus James Holmes. While a unanimous verdict of guilty was read in both cases, in each case, one juror was able to override the majority to dole out the death penalty sentence. Convicted murderers are heard repeatedly for years regarding their sentence every time they file an appeal. Even after appeals have been exhausted, in the 11th hour, criminals are able to fight against their death sentence. And then Linda ends her email with, "While I have shed many tears over this issue for over 20 years, my cry today is for justice." So again, thank you for listening to the email from my constituent Linda, who went to school at Smoky Hill High School with Ben Grant, and thank you for your attention.
Representative Pelton.
Thank you, Madam Chair. I come down tonight because I've spoken with both the DA's office that are in my district. I'm fortunate to only have two. Representative Holtorf has, I think, 3 judiciary districts in his House district. One of those small rural DA's offices has asked for the death penalty in the past. They want to keep that as a tool in the toolbox. We always talk about the different tools we can use in this body in many different subjects. And I think this is a tool that we need to keep, even though it is very rarely used. I think there's times it really does help get some information out to disclose locations and things like this. I think we can all agree there are different levels of crime. And with that, I think there needs to be different levels of punishment. I sat on a jury one time. It was just a property injury trial, not near to the level of this, but as a juror, I took it very serious, what I did, as I think every juror does. And I don't think we, as a body, need to diminish those findings of those jurors. I think voting for this bill would maybe do that. The people in my very small rural district don't have much trust in this building, in government in particular, in the judicial system. I think that they would very much appreciate a bill of this magnitude coming to them for a vote. We use the people's vote to institute the death penalty in this state, and I think it's only appropriate that we use it if people so choose to do away with it. And with that, I'll end my remarks.
Thank you. Representative Sullivan.
Thank you, Madam Chair. Give me just a second to get set up here. No, don't, please. It's going to be a while. Recently, the Senate had discussions and a vote on the repeal of the death penalty, just as we are having today. That day you heard from a mother who was impacted in a death penalty trial, just like I was, or at least I hope that you heard and listened to what that mother had to say. The senator from Aurora reached out to my wife, Terry, and asked her to come and sit in support with her while she stood up and delivered a series of passionate pleas to her fellow members. Terry went to the Senate floor and sat quietly along the side and took in the entire day of proceedings without ever taking a break. I tried on several occasions to get her to step outside, take a quick walk, or join me for a cup of coffee downstairs. She'd have none of that. The senator had asked for her support, and Terry wasn't going to leave for even a moment. It was right then that I realized how the pain that a mother and a father of a murdered child feel could be so much different. It took me until then. We've been dealing with it for 396 Fridays, and I didn't realize that we were feeling something different. Because you see, although I was there, when Alex was born, I can never understand the feeling that Terry must have had each and every day that she carried Alex to term. I'll never understand the pain or the joy she felt during labor. So it would be only natural that her feelings would be different from those that I feel since the day Alex was murdered. Compound that fact that Alex was murdered 27 years to the day he was born, and trying to understand how Terry must feel is unfathomable. But she sat quietly on that Senate floor because there was another one who was there who knew exactly how she felt. And because she had lost a son to gun violence just like Terry did. The day following the Senate actions, news reports spoke of a somber mood in the room. How those involved spoke with a reverence to the subject, that there was a deep sense of sadness that surrounded the room, and members had experienced difficulty sleeping and eating. To those of us who live in this experience, we call that Thursday. You see, it's just another day. But you don't have to worry about that here if you end up with any of those same kind of feelings that your Senate members had. That feeling will pass for you. You're just going to have to make a vote, and then you get to move on. Okay, that's never going to be that way for me or Terry. You see, I've already testified in a death penalty case. When I saw the headline in the Denver Post that this was coming to our chamber and the votes were already in, I could feel that darkness coming over me. The same darkness that had consumed me during that death penalty trial. The uncertainty that each day brought was the same as it was that time. Knowing that I had to play a part in this process, but not knowing if that was going to do any good, was so eerily similar. I know who I would become because I had already seen that man in the mirror looking back at me each day as I prepared to go to that trial. I don't like that man that I become, but I don't have anybody else to turn to. The anxieties, the lack of patience, the overall irritability I feel could at least be shared each one of those days when I entered the courtroom, because the others who were there were impacted the same way that I was. Not that way here. Every day I'd come in here to the Capitol and I'd endure insults that I'm not Mr. Sunshine for everybody. And then you're going to take my openness with my vulnerabilities and you'll use that as some sign of weakness. That, oh, we can get him now. I'm just going to remind you, you should never doubt my resolve and my determination. So today, you're going to hear from a father whose son was murdered. I'm going to start with showing you just what man is capable of. I will read to you the 165 charges that our killer was found guilty of, so that you can hear the names that were impacted. I'll do my best to convey to you what the sights and sounds inside that courtroom was like each and every day. Finally, I have some questions that I haven't heard answered, and then I'll return to my seat and remind you that I'm sitting there every day, just like I have since that tragic day in 2012. Now, I'm under no illusion that anything I say to you today will make any difference on the votes that you're going to take when we're all finished here. I can't imagine I have ever embarked on a more hopeless journey before in my life. But I refuse to allow the difficulty of that task in front of me to stop me from having my say. Since this session began, I've woken up every morning trying to put these thoughts together. I'm constantly thinking, I've got to get this right. I've got to say just the right things. I can't forget anything. And then each night when I try to go to sleep, those same thoughts just are running through my head. What am I going to say? How am I going to say this just right? I woke up recently, really early, and you get that time where if you're able to fall right back, if your mind doesn't turn on, you can fall right back to sleep, but I don't get those. My mind starts working, and I started thinking about what I was going to say, and then all of a sudden I could see a picture, and it really became clear to me because I'd never really understood what that picture was all about. And it was the picture of a struggle that a group of students had been having with their country's government. Struggle had been going on for a long time, and the government at this point was really pulling out the stops to get these students to get back in line. And I really could never understand why in this one photo that I remember that they wouldn't just step aside, and take the fight up on another day. Instead, they stood firm and they refused to move, knowing that they would only have that moment to be heard. And they were prepared for whatever those consequences were. Of course, I'm talking about the picture of Tiananmen Square. And those tanks are getting ready to run over that person. Now, I know exactly how that person feels. This is too important. I can't take the time off. I can't not let you know what this is all about. And I always was wondering, I mean, I was in the Air Force. We didn't have a lot of tanks in the Air Force. But I always wondered if that, while that student was standing there, if they could see into that tank and see who was driving that tank. I know who's driving this tank, okay? I know who's running this. So I got up, went online, ordered myself a picture of that, had it sent here, got it framed up. It's hanging on the wall in my office. Then I started to realize, I looked around my office, I'm turning my office into a little bat cave. I've got all my little mementos, just like Batman does, of failures and things that he's done and victories that he's had. So, I want to start here with, this is going to be count 1 and count 13. Murder in the first degree after deliberation. Murder in the first degree with extreme indifference. Jonathan Blunk. Count number 2 and count number 14 was murder in the first degree after deliberation. Murder in the first degree with extreme indifference, A.J. Boyk. Count number 3, count number 15, murder in the first degree after deliberation, Jesse Childress. Count number 4, count number 16, murder in the first degree after deliberation, Jessica Galway. Count number 6 and count number 17, murder in the first degree after deliberation, murder in the first degree with extreme indifference, John Larimer. Number 19 and number 7, murder in the first degree after deliberation, murder in the first degree after extreme indifference, Matthew McGinn. Count number 20, murder in the first degree, extreme indifference. Murder in the first degree after deliberation, Michaela Medic. Murder in the first degree after deliberation. Murder in the first degree with extreme indifference, Veronica Mosier Sullivan. Murder in the first degree after deliberation. Murder in the first degree with extreme indifference, Alex Sullivan. Murder in the first degree after deliberation. Murder in the first degree with extreme indifference, Alex Teeves. Murder in the first degree after deliberation. Murder in the first degree with extreme indifference, Rebecca Wingo. Here's the picture of the Aurora Theater. This is on the night of July 20th, 2012. At about 12:38 p.m., guy comes walking in through the back door, throws a couple of gas canisters up into the air. Switch to the next one. And he fires a 12-gauge Remington 870 Express tactical shotgun. First shot he fires into the air. The next 5 shots he fires out into the crowd. Here's where he dropped it. There's his extra magazines. He also brought a knife with him. He thought he was going to get into some hand-to-hand combat there. At that point, he had fired 6 shots. Then he pulled out a Smith & Wesson M&P 15 semi-automatic rifle with a 100-round drum. He had a scope on it, and he started shooting. He started in the back. He started up high and started working his way down. And he did that until after 65 shots, the magazine jammed. There's the magazine right there. Now I'm going to stop right there. One of the things that I heard in the testimony on the Senate side was they were talking about the evolution of our societies. What you see right there, that's going to be the last high-capacity magazine, 100-round drum that's ever going to jam up. Okay? The reason that is because these killers are evolving, folks. Okay? This guy, see, he thought 100-round magazine meant you put 100 rounds in it. The Patriots know better than that. They know that you can't put 100 rounds into a 100-round drum because that's all they are plastic boxes with spring-loaded parts underneath of them. They're not made for that. I mean, if he had watched the right videos on YouTube, he would have known you don't put 100 rounds in there. That's going to cause them to jam up. And when we're talking about the evolution of these killers, I'm hastened back to a couple of weeks ago. Emily's mom and dad were standing right over there, and they were telling their story. We were being told their story. Now, in the evolution of those kinds of killers, now that was one of our worst nightmares, was Emily knew what was going to happen. She knew something was coming. When we went and to try to find Alex, we were terrified about how much he knew of what was going to happen to him. She knew. And in this case, this killer, what he did was just locked the front door. And he put some desks around. Because since Columbine started, we know that they're coming. They're coming in. They're not waiting. So he knew that they were eventually going to come in, and sure enough, they did. And the desks and the locked door gave him a couple of moments for him then to kill himself. 3 weeks later, in Pennsylvania, guy drove up to an Amish school. Okay, he already knew about what happened up in Bailey. So he pulled up, and when he took over the school, he went back out to his truck, pulled his truck up to the front door, brought out wood and nails and hammers, and hammered the door shut, hammered the windows shut, and stacked all the desks all around. That was going to give him more time to do what he needed to do. And eventually they came on through, and he ended his own life. 3 months after that, in Virginia Tech, that guy had seen what those two had already done, okay? And so what he did was get chains and locks, and he went down on the first floor, and he chain locked all of those doors so that nobody could get in. And he went up on the second floor, and that's when he started murdering people. And then while they were trying to figure out how they were going to get in, to get to him, he put all of the desks all up. So then when they eventually came in, he had a little bit extra time to go ahead and kill himself. Now the same thing, I think we got another picture. So that's the same with the evolution there. This is the Route 66 massacre in Las Vegas. I happened to be not at the concert, I was down the street there from it. See, that guy, he evolved as well. He had 23 guns in his hotel room. He had 19 more of them at home. He had them hooked up with bump stocks. He had the high-capacity magazines. He got off over 1,000 rounds in 10 minutes. Folks, the killers are evolving, and our society isn't keeping up with the evolution of these killers. Now, our killer, what he did there, he moved on up to the, because now his gun's jammed, and he didn't watch the video to be able to figure out how to unjam this rifle that he had. A lot of people tell me they can do it quickly, and I believe them. Why would you lie to me about that? That you know how to unjam a firearm? This guy didn't know how to do it. So he went on up into where there was some light, and he tried to take the jam off, and he couldn't do it. So then he started moving, and a family was moving towards the door. A son got up out of his seat and started running to the door, and at that point, he pulled out his .40 caliber Glock 22 Gen 4 handgun and fired at the son. Knocked him down, didn't kill him, knocked him down. Kid got up, ran out the rest of the way. Mom came running, he shot her, mom went down. Dad came after, picked up the wife on his shoulders, carried him out. And then our killer walked out the door. There's his weapon. He left it there at the door. And then he went outside. Now this is where he was standing to get off. He had 6 shots from his shotgun, 65 from his semi-automatic rifle, and 5 from that .40 caliber that he fired from there. All of this took less than 90 seconds, folks. 90 seconds for him to do all of this. And here he came out to his car. Now he came out to that car and opened the door because he thought he was going to get away. He had road stars in there to throw at the cops who were going to be chasing him. He had another handgun inside of there. But he came out and he was so exhausted he just leaned up against the car. And what happened at this point, the cops are already coming, okay? There's a kind of a burn around the back there that they're coming down from Sable, and they're coming across the back of the parking lot towards him, okay? And if I was this person that I heard during testimonies on the Senate and the testimony in the House committee meeting, that I was just bent on revenge and vindictiveness and bitterness, that I would have wished that we had a police force who would have ventilated that car with that guy standing there. But that's not the case. The gun's sitting on top there. He's not a danger to anybody. And they did not shoot him because he was a 24-year-old white guy. They didn't know. He was covered in body armor, had a gas mask on, had a face shield on. They had no idea who he was, what he looked like, what any of that was. See this, oh, nope, back, sorry. See this wall right here? One of the women whose boyfriend was murdered in there, she crawled out from underneath of him to come out through the door just while this stuff was going on. She's probably all of about 5'1". And she came out and saw him standing next to that car, and she jumped up on, that's a trash area back there. She climbed back and squeezed herself in between all of the dumpsters back there, and she heard all of of what happened out there when they arrested him and took care of him, but they could hear her back there and they didn't know who it was. So when they finally opened everything, they all had their guns trained on her, and they finally got her out of there. I'm not doing a very good job on I wished that you had been able to be in the courtroom to hear the judge when he was reading off all of these names. There was 165 charges in the trial. It took him an hour and a half at the beginning of the trial just to name off the charges. But I want to, just at least get everybody's names out here so that you know who they are. And these were all guilty. Every single one of these. Attempt to commit murder in the first degree after deliberation with extreme indifference. And here's the names. Petra Hogan, Adam Avila Arredondo, Brandon Axelrod, Tony Villapando, Christina Blanche, Maria Carbonell, Alejandro Lamos, Louis Duran, Craig Anland, Alex Esponza, Jackie Fry, Joseph Gerby, Zachary Golditch, Eugene Hahn, Casey Hahn, Katie Medley, Jasmine Kennedy, Marcus Kaiser, Patricia Rose, Brenton Lovick, Ryan Lumba, Caleb Medley, Ashley Mosier, Stephen Moten, Joshua Nolan, Pierce O'Farrell, Rita Paulino, Christopher Rapaza, Carly Richards, Dion Roseborough, Carrie Rotman, Lucas Smith, Heather Snyder, Farah Sadami, Catherine Straub, Jameson Towes, Denise Axelrod, Marcus Weaver, Michael White, David Williams, Alan Young, Jansen Young, Samantha Yowler, Gage Hankins, Michaela Hicks, Stephen Barton, Nicholas Gallup, Evan Ferris, Jennifer Arredondo, Gerald Brooks, Amanda Hernandez, Kelly Lewis, Bonnie Kathleen, Ethan Rose, Nathan Jurek. Now, after this has all happened, the police went back inside and they started to move everybody out. Here's the 12 victims. The first one we're going to look at is little Veronica Mosier Sullivan. Now, when the police came in, she was already, and this is what they call it when you're dead at the scene, they call it a code black. She was already dead. But the captain who's taking control of that said that there is no way that I'm going to leave this 6-year-old lying on the floor here and have all of my people watch this the rest of the day. So they picked her up and took her out and put her in an ambulance and sent her on her way. So let's see, she was shot 4 times, once in the chest, once in the arm, and twice on her lower right side. The other one, Jessica Galway, over there next to Alex on the bottom row there, she was shot 6 times, 4 times in the torso and the limbs, and once in the head. And many of you have already heard this about her because her mom and dad come down here and testify on bills, and they've told you how the left side of her head were nearly blown off, but she was still breathing. So when the first responders came by, they thought they had a chance, so they picked her up, put her in an ambulance, and sent her out. But she didn't make it even to the hospital. 4 of these guys died protecting their girlfriends. Jonathan Blunk. Top row, second one in. He was shot once in the back and once in the head. A.J. Boyk, right next to him, shot once in the head, once in the chest, once in the shoulder. Jesse Childress, he shot once in the torso, in both legs, and in his right arm. Gordon Cowden, right next to him, he was there with his 2 daughters. He was shot once in the chest. John Larimer, second row, he was shot twice in the chest and once in the abdomen. Matt McGinn, and I didn't know this until I pulled all of this information up, getting myself ready to talk to you guys. Matt was shot 9 times. 9 times, including in the chest and the neck. Michaela Medic, she must have been one of the first. She was way up high. She was shot once in the chest. Alex Teves, he was shot once in the head. And Rebecca Wingo was shot in the head, shot once in the torso, and once in the limb. And then, of course, there's Alex. I don't know, but I think when Alex was born, I think what we had to do was put together a bag, like a go bag, to be ready. There was a time when you didn't have a phone that had the abilities to take pictures all the time. So you had to have a bag that you had your rolls of quarters to make your phone calls. You had a bag with a change of clothes and a camera in there. So we had the bag. And I'm looking here on the first pictures I ever took of Alex. So this is him and Terry laying in the room. And then there's one of them. He must have been exhausted. He's sleeping. And I spent the last 4 years trying to get Alex's last picture. And I got it. It's Exhibit 2083. It's right here. These are Alex's crime photos. This is the picture of my son lying on the floor in the Aurora Theater. And I'm not going to open them up, show you guys. I had to actually take the killer to court to get these released to me. Okay? And in the same way, I went and got myself Alex's autopsy so I can tell you exactly what happened to him. He was hit once. A gunshot wound in the right lateral chest. It perforated his liver, his right lung, and his heart, and it exited in his interior upper chest, so somewhere around up in here. This picture here that I would look at. Oh yeah, this is the one thing I didn't know. Alex spent his birthday in a body bag. When they released him, this is how they said the body was received in a sealed body bag. And this was they did the autopsy on the 21st of July, 2012. Alex was the body was received clad in the following articles of clothing, appropriately placed: a red T-shirt wearing a Batman design, a black tank undershirt, a black belt, khaki shorts, white boxer brief underpants, 2 gray socks, and 2 black athletic shoes. Around his neck is a beaded necklace, and on his left ring finger is a white metal wedding band. In his left front pocket of his pants is $130 in cash. You know what that tells me is his grandmother sent him a birthday card. She always sent him $100. So Alex had already gotten his birthday wishes from his grandmother, and he had that $100 in his pocket. He had his wallet bearing miscellaneous cards and papers and driver's license, his social security card. Left side pocket are 4 keys, a carabiner, and a green lanyard. Just like this one. He bought me one too. I had the same one as he did. Also accompanying the body is a Red Robin credit card, cell phone, writing pen, and a black Batman belt buckle and a notebook. Let me get a mess up here. That's what's left of my family. That was the photo that they took when Terry and Megan and I finally met up out in front of Gateway High School, probably about 7:30 that morning. That photo won a Pulitzer Prize, folks. That was one of the top 10 photos of 2012. You can go over to the Press Radio Club, they've got it hanging up over there, along with all of their accolades. You go to museums, that photo's hanging up there. Reason for that is because of, I would guess, not yet. Thanks. The reason is because of what that says, what it looks like, what it speaks to. I mean, that's, I don't know. That's unadulterated terror. We finally got together. We'd been on the phone back and forth for half hour, 45 minutes trying to get ourselves together, and we finally got the 3 of us together, and then we knew we'd be able to kind of figure everything out from there. But that spoke to people, and that's why they gave it all of the awards. Now, they'll let the picture speak, okay? It's all right for that picture to speak, but by God, one of those 3 can't talk, okay? Because if one of those 3 talk, then I'm taking advantage of this situation, right? You can look at that and figure out what you want. But if I say anything about what happened that day and what my life has been like since then, you're sending out fundraising letters, right? Because this guy is taking advantage of his situation. Now we can go to the courtroom. So now we've got a court case. So this is courtroom 201, Arapahoe County. First appearance of the killer is the 23rd. So this is 3 days afterwards. Some of the family members and people who were involved, they needed to be there. Okay, they had to see what that guy looked like. They had to glare him down or whatever. And I'll never say whatever it is, however you want to handle this is wrong. That's how you want to handle it. It wasn't for us, okay? I had people coming into town. I had to get my mom an airline ticket. We had to figure out what was going on. That stuff could all wait. And then from there, now we find out, and I remember talking when we were at Gateway High School with law enforcement, and all of them were there, and telling us different things. There was a point when they were giving us information about the bodies, and they told us that they had to get out of the theater because he tried to blow up his apartment building, and they were afraid that he had somehow put bombs inside of the theater. So they had to remove everybody because they thought that there were bombs underneath of the bodies that were lying in there. And they kept telling us we're going through things, and we were okay. I mean, Terry and I and Megan and everybody, it was like, take your time. Do what you need to do, because we don't want to have to do this again. We don't want to have to go through all of this again. So after a crime like this, or I guess any crime, when he first appears in front of the judge, they have 62 days in which to file charges. And so that was the point when they filed charges for 165 counts. Now, and I heard in testimony people were talking about the trumped up charges that people may claim in these types of events. Our prosecutors, our DA said, there were 400 people in that theater. We could have charged him for every single one of them, because that was his intent. His intent was to kill every single person that was in there. So the charges were finalized on the 11th of October in 2012. They had a preliminary hearing on the 8th of January 2013. Again, that's not something that we went to. My understanding is that was law enforcement was there, first responders were there. They were explaining what had happened all during that time, and that's when the judge said, yeah, we're going to go ahead, with this trial. And also during this time, now the theater is being rebuilt. And there's some of the families who wanted the theater to be rebuilt. There's others that didn't. We were in favor of having the theater be rebuilt. We went for the opening. I wrote a editorial that was in the Post about that day and all of this. During this time, Megan, my daughter, she had to quit her job because as much as people, are supportive of you, that doesn't last for that long. She was going, and Terry was going to therapists and talking to them, and the girls at work would say, Majis, how much longer is this going to go on? How much longer are you going to have to go through this? Also, this is the time then we started getting the reach out from the district attorneys. And I have a humongous file of all of the emails and information that they sent us over all of this time. We would do like a webinar at least once a week where they were updating us onto what was happening and how the process was working. And as you all recall, there was lots of starts and stops with this. But this is where then they had the questions to us about where are you going to be on this? And we're thinking about, having a death penalty on this case. And so they scheduled us to come in and talk to them about it. So Terry and Megan and I sat at the kitchen table. And this wasn't just a conversation, a philosophical conversation like we're having here about the yes or no of a death penalty and how it all works and what it's going to affect and all of this. This was a family that sat down. We actually had to say the words. We had to make the decision. Do we want this man put to death? And I remember Megan talking about it. I mean, Megan at the time is 24, 25. She's like, you know, Dad, I'm going to be 46. I'm going to be 48 when maybe something like this happens. I might not feel that way. Terry and I thought, well, geez, we might not even be here when something like this were to happen. And we knew, and they were telling us all of the stories about how long this would all take and how it would keep coming up and we would keep talking about it. But we had that discussion, and amongst the three of us, we decided, yeah, that's what we would ask for. So we went there and sat down in front of one of the prosecutors. It wasn't the DA, he was on the phone. I'm not sure what he was doing, probably working on some other part of the case. And we had the conversation, and we actually had to say the words out loud. You couldn't just shrug and say yes and nod. You had to say them out loud. And so they said they were going to have a death penalty. They announced that on the 1st of April, 2013. Then he started getting his mental evaluations. They set a trial date on February the 3rd, 2014. And between there and the jury selection, I mean, our life is pretty much on hold all during, this time. The jury selection started on the January the 20th of 2015. And I'll never forget, during this time, we got a letter from the defense team. They wanted to have a meeting with us. They wanted to invite us out to dinner or something. Because what they were looking for were parents or victims who would help them save this killer's life. I don't have that. I mean, we were so outraged, we started calling in, and they tell us that this is normal type of work that they do. That this is normally what they do. I think some people went. We threw the letter away and never had. And I remember having to actually write a letter to him to say, don't you ever contact my family ever again with anything like this. And I even went trying to think of, every mode of communication that we had up to 2015, but I knew we might be going, another 20 years. And so I had to even tell them, I don't even know what kind of communication process we're going to end up in another 20 years, but don't you contact me with that mode of contact. And so when the jury is going, so now we've got to figure out how we're going to get there and what that's going to look like. And so as they're going through the process, so I contact the DAs and make actually practice runs before the trial, because I have to figure out where I'm going to park. Oh, thank you. You could hear that too. So I'm taking practice runs on where I'm going to park and how I get through there, and then had to get myself together that I was going to walk in to that courtroom. And so when you walk into the courtroom, there's the killer. He's sitting over there on the side. I had to be ready for that, okay, because I hadn't been down there before. So we sat there, and I sat and watched some of the jury selection as they went through all of that. Went home and told Terry and Megan about it, and then Terry said, that she wanted to go. So then we made another practice run with her so we would be all prepared when the opening statements came up. Those came up on the 27th of April, 2015. And again, they had given us information prior to telling us not what the opening statements were going to be like, but you guys can sit down anytime you want. But not telling us what they were going to say, but they told us what we were going to see if we were there. And they had all of the crime scene photos. So they had the photos, and they were going to show those. And if any of you watched it on TV, they had an ability to show something just to the jury and the people in the courtroom, and you couldn't see it when you are on TV. So the three of us had the conversation, and we thought that might be a little too much to see like that. And so what they had a big room for us all, one of the holding rooms. They had TVs all set up there. That was the plan on the first day of the trial, was to go in there and watch it. And when they get ready to send people in, and of course, victim families, we got to go to the head of the line if we wanted to go in. And when they were asking who wants to, come up, all of a sudden Megan jumps up and says, "I'm going to go." Well, my mom was horrified. It's like, I thought we had talked. And Megan's like, "No, I'm going to go." Well, Terry wasn't prepared to go, so Terry and I sat in the room and watched it on TV. And Megan is the one that went in. During the trial, Alex he was there with 12 friends from Red Robin. They were there for his birthday, and they brought friends with them. There were 400 people in the theater that night. More people knew Alex than anybody else. Everybody else, normally you go to the movies by yourself. You might go with your girlfriend or somebody else. Alex came with 20 people. So these people all knew him. And then when they are interviewing all of the people in the theater, I think I've told you this story, that when the previews were coming up and there was a new Superman movie coming up, Alex stood up and started cheering for the new Superman movie. And when they would question the people who were in the theater and ask them anything that you remember about that night, a lot of them said, "Hey, I remember this kid that stood up and was cheering during the Superman previews." So the trial started on the 28th, and the way they would question each of these people, they would come up and they would have to give their names, and then they would ask them if they were in the movie theater that night. And then they would ask them, "Well, how is it that you were at the theater that day?" And then they would say, "Oh, well, I was there, I worked at Red Robin, and it was Alex Sullivan's birthday." And so then they would put Alex's picture up. And then they would say, have you seen Alex since that day? And of course, they hadn't. Well, there was 12 of them that got shot or injured or something, so there was a parade of Red Robin kids that were testifying all during this trial. So one of the defense attorneys, Christine Nelson, apparently this was her job. After the second person who had been with Alex, every time they would come in and want to show that picture, she would stand up and object. She would object for them showing Alex's picture and name off some law, some statute about we were doing something to the jury by them constantly seeing Alex's picture. During the trial there, I got to meet all of these kids that were there, and I actually had a chart of where everybody was sitting. I knew where everybody was sitting. There was Bryson and his wife Tony were sitting down at the end. Bryson came to Alex's viewing, and Bryson had bought Alex the ticket because, as a birthday present. Bryson is standing there bawling his eyes out, thinking it was his fault that Alex was there. Tony, his wife, was 8.5 months pregnant. Now, when our kids were born, and I don't know if they still do that, you're supposed to play soothing music to a woman's stomach. You're supposed to talk to it. You're supposed to show them pictures of other people. I cannot imagine what that little child was feeling with all of the stress and the trauma that his mother was running through, that night. She's 7 years older right now. I hope she's doing fine. Sitting next to her was Maria, and she had brought her 9-year-old and her 12-year-old daughter. Maria told me her whole story about the kids running outside and her getting them in the car and driving them across the parking lot and locking the doors, telling them to call their dad to come and get her. And Maria turned around and ran back into the movie theater because her friends were in there. Maria had a 4-year-old daughter who didn't come to the theater with them that night. Her birthday was the next day. So she's had 7. I can't imagine what those birthdays must be like. Everybody is so, there's her brother and her sister and her mom. And they endured this, and this little 4-year-old can't figure out, why is everybody so sad at my birthday? Sitting next to him was Edgar. Edgar was sitting next to Alex. Edgar, when he gave his testimony, that's how we heard Alex's last words. When everything started happening, Alex turned to Edgar and said, "Edgar, what are you doing?" And Edgar said, "Sully, we got to get down." And that was it. On the other side, there was a young girl. Her name was Chelsea. We got to meet Chelsea in the 3-year kind of interlude. She was taking Tai Chi with Terry and Megan. They had a resiliency center. We were getting our therapy. We were doing all of those things. After about 2 years, Chelsea said to my daughter Megan that, I would like to talk to your parents because I want to tell them about that day. And she hadn't gotten, up the courage to do it. So we actually had her over to our house for dinner, and she explained what that day was all like. And this was still about a year before the trial, happened. She told us what they had done and how she was sitting by Alex and all of that type of stuff. Then when the trial came about, she contacted us, and I remember we had to get into a room with her because she thought she was going to have to testify. Because Chelsea was one of the ones who she called 911. And so she wanted us to hear her 911 call before we heard it during the trial. So we sat in this room, and she's playing the 911 call, and you can hear her talking, and she's got her friends are around her. There's a young girl, Jasmine, who you can hear her yelling, that she needs to call her mom, and that you could still hear some shots going off. And Jackie, she's holding on to Jackie, and she's reached over to grab a hold of Alex, and she's shaking Alex's leg and saying, "Sully, you gotta get up." All this time she's talking to the 911 operator. She's giving the 911 operator all of the information about where she is and what's going on. The 911 operator is keeping her on the line. And I've never heard anybody so calmly continuing to talk. And she said to the 911 operator, "Please, would you hurry up? My friends are dying, and I think Sully's dead." And then you hear a man's voice, and he says, "Miss, we'll take her now. You have to let her go." And then the phone goes dead. So that's what happened all the time during this trial for us, because every time one of the Red Robin kids would testify, Terry and I would make sure to find out when they were going to be there, and we would make sure that we were sitting there. We have to check with them that it was all right for us to be there, because I didn't want us to be a problem for them to do what they needed to do. And overwhelmingly, they were all, "Yeah, we want you to be there." So Terry and I got to sit there and listen to everything, and hear all of the stories. On the 16th of July in 2015, that's when he was found guilty of all 165 charges. We had a couple of days off, and then we started into the aggravating part of the death penalty trial. I know some of you had asked questions during the committee hearings. This is those 17 aggravating charges. That's how we got the deliberation and the other two. Yeah, after deliberation and extreme indifference, that's what they found for him. And that phase lasted a couple of days, and they came back and it was unanimous. Then the mitigation started. And that's the point where his family and friends start to talk about what his life was like, or what had happened that would cause him to do what he was doing. They had a woman who was the attendance monitor of his kindergarten. They had a woman who went to church with his mom and saw him in his room one day. Some kid who had played soccer with him in high school. And of course, his mom and his dad and his sister. And the mitigation phase, again, unanimous. Now it starts with the phase 3. This is the victim impact part. This is where they were able to get one person to testify for each of the 12 victims, except for Veronica. Her mother testified and her grandfather testified. And that went on for 3 days. I know some of you, we sent out, I had wanted to show the testimony. I was the second person that testified. My daughter Megan was engaged. Her fiance was with her through all of this, and she had decided that they couldn't just wait any longer, and had decided to get married, and started putting the plans all together with this on the horizon somewhere. And of course, as our luck would have it, it happens right all during this. On the Friday, that would be the rehearsal dinner, I had to go to the DA's office and practice my testimony that I was going to give. So they let me have Saturday off so Terry and I could walk Megan down the aisle. And then Monday morning, I was the second one who got called in to give my testimony. And I remember on Friday when I was talking with Rich Orman, who was the district attorney that I was working with on this, I told him, I said, you need to, you need to get me ready to do the best job that I can, because I want to be the one. I want to be the one that puts him away by my testimony. So you ask me, we'll do whatever we have to do to put this all together. And some of them will tell you, that they don't remember, and these are the prosecutors, these are the FBI guys who were a part of the trial. They said they don't remember a whole lot about the day-to-day parts of the trial, but one of the things that they do remember is my testimony, talking about Alex while I sat several feet away from his killer. And that went on for 3 days. That was as hard a 3 days as I've ever endured, listening to all of the families talk about how and what that all meant to us. And then they gave their final statements, and it went to the jury. Now, we don't live too far from the courthouse, so we would have they would text us or email us or something when it was time to come in, and we got the message, and we all went into that courtroom, and it was, well, you didn't know what was going to happen. You didn't know if you had done enough. You didn't know what was going to be said. And they brought him in, and they stood up, and he started to read the charges and the results. And I think it took until we got to about the second or third name before I finally realized that we didn't have a unanimous jury, and that he was going to get life without the possibility of parole. So they gave us a couple of more days off after that, and then we got to come back for, this would be victim impacts from everybody else. So this was an opportunity for anybody who was involved who hadn't testified, or if you did testify, you would have the opportunity, because now the judge is deciding on all of the charges and how much time he's going to give for each one of those charges. So that went on for an entire day, where people would just line up, and the jury's already gone. They're not sitting there, but all of our prosecution team is all sitting there, and they're going through and explaining it. And you had family could send in letters, people could write in, and people would change back and forth, and they kept whittling it all down to where everybody had their opportunity to speak. And then it came to the very end, and Terry isn't really, this isn't her gig to get up in front of people and let them know. I mean, I hear it all the time, but she doesn't do this out in public. But it came down to it where this was going to be her last chance. This was going to be where she was going to get to tell everybody what she thought and what Alex meant to her. And she ended up being the last one. We were able to convince her to go on up and be the last one, and gave the victim impact statements. And so they ended up, giving him 12 consecutive life sentences and 3,318 years. That was the end of the trial. And now we've got to kind of get back on, get with whatever life we have left. So, I listened to the Senate committee a couple of times this past weekend. I listened to your House committee, your Judiciary House committee, listened to the questions. And I had a couple questions and maybe some observations that I had put together from that. There was one of the things I was kind of struck by was the clergy panels that showed up, okay? And any of you saw my testimony there was a section where they had asked me, Mr. Sullivan, do you have faith? What is faith like in your life? And the defense wouldn't let me answer that. As soon as I tried to say something, they objected, and they went to the white noise, and I never got to come back. So I'm going to tell you the story that I wanted to tell them. See, Terry and I were brought up as Catholics, and certainly the Catholic Church isn't the same Catholic Church that Terry and I grew up in. It's changed. I mean, it's hard to really recognize it anymore from the one that we used to know. But Terry's family is a big family, and they're all still back, in upstate New York. So when her mother and father passed away, they would have big Catholic funerals. And we flew back with the kids for the funerals. And we had gotten the kids baptized, of course, but we never went through the rest of the stuff. We didn't get them their sacraments. We didn't get them confirmed so that they'd have the ability to receive communion. So they went to 2 funerals, and both my kids sat there and couldn't go get communion, and all of their cousins are going up getting communion while, for their grandmother and grandfather. And I think that really kind of ate at Alex a little bit, because he didn't kind of understand it, and he didn't know, what he needed to do. So when he came back, he started going to Mass more often. And that was good for his mom, because she found out that he was going, and they would meet up and go to Mass, go to St. Michael's together. And so then he started taking the class so he could get, his sacraments, and then he would be able to get, his first communion. And I asked him, I said, where did this all come from? Why did you want to start to do all of this? And he said, Dad, it's kind of embarrassing to go to a funeral and not get to receive communion with the rest of your cousins. He says, I don't want that to happen again. And the way it was, the next funeral that they all went together was his. So that's what I wanted to tell that story. But like I say, the clergy all showed up here, and the Catholics are telling me what a barbarous thing this would be. And quite frankly, I mean, like I said, when you saw the picture of the car out there, if I was just bent on vengeance and revenge, then I would have wanted that to happen. That's not what I wanted to happen. I mean, I accept what happened to us, okay? I don't forgive him. I'm not going to forgive them. But I accept what happened. And we can even get to the point where sometimes you think, okay, well, how can there be a God if they're going to allow something like that to happen? Well, I am for certain that the presence of the Lord was in that theater that night, because he moved people around. And at that point, when he decided that's enough, That gun jammed. Nobody else died. Nobody died. All the kids that went to the hospitals, as badly as they were hurt, none of them died. It was just the 12. It was up to that point where he said, that's enough. And he made sure that it happened to people who then could, as clumsily as we do, articulate this so that we can do something that this doesn't happen again. So I still believe that, but for the Catholics to show up, I mean, and I've asked them, I've been at so many events where every denomination is there. When we went into Gateway, they were all there. One of Alex's friends still is in contact with one of the Billy Graham ministries. Helped him out that day. I've been on steps of Congress with other clergy, and they're not. And I've asked. Do you remember when we went after the Christchurch massacres in New Zealand, and we all went to the mosque? And the Jewish rabbis walked 6 miles because it was on the Sabbath, so that they could be there to say prayers and be with us. There wasn't a Catholic priest anywhere near that place. And they have the audacity to come to my office with their cards. I called them. So where are you guys? This is my faith, and you can't even show up? But they're going to show up for something like this, and they're going to dictate to us what's right and who's wrong. One of the other things, and a couple of you already mentioned this, is that line. That line that separates in your districts between who's going to get charged to a capital offense and who's not. After I'd been listening to that, I called Megan, and I told her, I told her this is what they had said. And she said, Dad, there's a reason they call us victims. And that was it. You talked about the defendants, about what was going to happen to them on what side of the line they were on. When are you going to think about the victims who were on the other side of the line? I didn't need that. Depending on what side of the line you are is going to be who is going to be fighting for you. Who you're going to be stuck with. I don't know if you recall this, but in 2012, the Arapahoe County District Attorney was term limited. There was an election going on. I didn't get to play in that. I wasn't paying attention to that because we're burying kids and trying to get our lives back together. So I don't know what that sounded like. I don't know what that was. I know I didn't vote for the guy that won. Nobody in our house did. We didn't vote for him the second time when he ran unopposed. But that's who we got stuck with. We got stuck with whoever was in that office and had the ability to do their jobs that day. Whereas the defendant, regardless of what side of the line they get on, they get the full power of the state's public defender's office to defend them. That's who they get. Those defenders who came and defended Alex's killer, that was the best and the brightest the state of Colorado had to offer. They didn't live in our district. They came from all across the state. The word is that they built them a home or had them a home, and they lived in that home. We paid them per diem. We paid them mileage. They went back home to their districts on the weekends, while we, in the 18th Judicial, all of our people schlepped back and forth from the courthouse to their homes and back and forth, and that's who we were stuck with. If you really want to change this, why don't we come up with something like a state prosecution team? If the defense is going to get the best the state has to offer, why doesn't the prosecution get the best? That way, we don't have counties having to take care of this on their own. If there's an outrageous crime done in their district, then we'll let the state handle it. And we'll bring in our biggest and brightest. That way, we get away from this on who gets to get charged and who gets to be let go on the other side. I mean, that's what really disappoints me in all of this. All the time, we always are trying to fix things. There isn't anything that's wrong in this state that we can't figure out a way to fix. Except this. Except this. I mean, I've been waiting since the day Alex was murdered. I would have been down here. I would have been helping you. I would have been testifying for you to try to figure out what is the best way to do this. But the only option was throw it out. It's no good. I don't believe that. I believe we can do something. We can fix this. And I hope at some point we'll get together and do that. Instead of sitting back and waiting until you get the supermajority, and then it doesn't matter, and you're just going to throw it out. And the whole business there with the paperwork and the filings. I don't know about, for some reason, it just gets me about how much paperwork we've got to, I mean, there has to be a better way. Can we fix that? I don't know why it takes all of that kind of stuff. Here's one of the things, this Dylan Roof, okay? This is a white supremacist, an avowed white supremacist, whose idea was to start a race war. And that's why he went into the AME church and murdered 9 people. He did that because he wanted, like I say, to start a race war. Because he was a white supremacist. He hated them. That's what his deal was. He pled guilty, and now he's set to be put to death in Virginia. Now, all of a sudden, they're arguing that maybe he wasn't mentally ready. They got a 321-page legal brief. They got 20 issues that are wrong with this. That's ridiculous. Hatred is not a mental illness. He knew exactly what he was doing. He wanted to do that. I don't know why we're having to go through all of that again. One of the, and I don't know if you guys all saw this, the ACLU had this 60-page report on ending the death penalty. I mean, I read it a couple of times. I hope you guys all saw it. I mean, the ACLU, generally, I think on death penalty type cases, they generally show up around, they didn't show up anywhere around our case. I'm not even sure that they knew I was here when they were working on what they were working on here. But I read all of that, and there are some, I mean, and again, I mean, I probably agree with 90% of it. Yeah, we can fix it. I don't know why. I don't know why one death causes all of the actions that it does and another one doesn't. I mean, there was down the street from my house was the day after the STEM shooting. Lloyd Chavez, young high school kid, murdered in his front yard by another high schooler. We didn't have a press conference there. Nobody showed up in front of his house to talk about what happened to Lloyd and his family. You didn't put put his funeral on TV. Governor didn't talk about him. Did Lloyd's mom and dad lose anything more than I did? Lose anything more than the Castillos did? No. It's just the way things work out sometimes, and that's wrong. And I try and talk about that all the time. I feel guilty because we had a slew of victim advocates who were there available to us. We had all kinds of services that were available to us that we could get, at any time. I don't think the Chavez family got the same kind of services, that I did. And that's wrong. We should be handling these all, the same kind of way. And I know how difficult that is. Our defense team, they wrote about our trial. Apparently, the word evil really made them upset, that the mental health problems that our killer had, somebody must have said it was evil, and they're talking about how that was wrong. They also went into about the holdout juror. So I wanted to talk about that because what that meant was, I don't believe for a second that we had a death penalty qualified jury. That would have meant that they were ready to, depending upon what the evidence was as it went all the way through, that they would have claimed death at the very end. Because we got unanimous during the guilt phase. We got unanimous during the aggravating phase. We got unanimous during the mitigating phase. The only place that we lost was during the victim impact part. So what they're telling me is this was my fault. I wasn't convincing enough. This is when that juror changed her mind and said, no, we're not going to put him to death. I think I've still got it here. Do you guys recall when we had our budget reports? And there was the supplementals there. There's $1.6 million because we're having problems keeping our prisons maintained. And following through on that, it said that we're $33 million behind on maintaining our prisons. Now, if you're going to repeal this death penalty, and you're going to send all of these people to prison, you can't even guarantee that they're going to get hot and cold running water tonight, because we're not taking care of our prisons. But somehow you're going to tell me and the rest of us that you're going to keep them safe from one another, that you're somehow going to keep our employees safe. I don't know if you guys remember, Jeffrey Dahmer was the serial killer in Wisconsin who killed men, brought them up to his room, chopped them up, and ate them. When they finally caught him in Wisconsin, they didn't have the death penalty in Wisconsin, so they put him in and were supposed to be taken care of. Didn't take very long for another prisoner with a metal pipe to beat him to death. And so his mom goes to the people of Pennsylvania, of Wisconsin, and say, well, is that what you wanted? Are you happy now? Because you couldn't keep him safe, and now something like that happens. And I know that you say the 3 killers that are on death row here right now, that if you repeal this, they're going to stay there. I hope so. I doubt it. I think they're probably going to go back to general population in a short period of time. Because there's people up there that are waiting for that. There's people there that want to kill him. They're waiting for him to get there. just like they did with Alex's killer. He was in confinement for 3+ years while the trial was going on. Took less than 60 days for him to be with the rest of the general population that someone tried to kill him, and then they moved him out of state. I think that the same thing is going to happen here. We can look forward to something like that happening. And I'm being told that our case, the defense said they weren't going to appeal our case because there was a death penalty hanging over them. If you repeal this death penalty, that opens that case back up. We're going to be back in court again next year. We're going to be in court where all these families are going to be coming back to Colorado and listening to this. The killer's going to come from Pennsylvania. He's going to come here, and we're going to retry this case all over again. And this time, if they can't get the life, apparently there's a new Senate bill that they're running through. I got a press release. This has been filling up my inbox. There's a press release that says, see, he was only 24 at the time he murdered my son. We're trying to pass some type of legislation that would make it so that he only has to stay in prison for 28 years. So for all of that he did, he'll be out in another 20 years once we let the death penalty, we repeal that, and then we bring in this next stuff. I have here a thing from, and that was one of the things people always said, put them in prison for the rest of their lives, and they'll make them think about that. And that's one of the things. There was an article here, one of the wardens. Well, this is at Supermax. That's a little bit more intense than the stuff that we've got. But to say that prison life is worse than death. What can be worse than death? So we don't have the mental health help that we need for our kids in school, for our coworkers, for our parents. What makes us think that we're going to provide the health care and the mental health that these guys in prison need? There's stories in here about guys who have gone completely crazy, and again, they're killing one another and dismembering one another. I've sat in rooms and talked with more people who have been affected by gun violence and death in an afternoon than most of you will ever speak to in your lifetimes. Whether it is a mass shooting like ours, an accidental shooting, urban crime, domestic violence, or suicides, one thing is clear: the pain we all endure is never ending. There is, though, a sense of comfort whenever I find myself in a room with others who are on the same road that I am. They all seem to understand. We don't have to explain to one another why we're feeling the way that we're feeling. I remember, if you remember the Isla Vista shooting, it was over Memorial Day weekend. Kid was driving around, couldn't get a date, and started killing people. Richard Martinez, his son Chris, was murdered. You may remember him, white-haired, bearded guy. He was the one who was standing up and was talking to all of us about the craven politicians are responsible for this. I've become friends with Richard. A couple of weeks after that, he came out to Colorado, and I was at a barbecue with Alex Teves' mom and dad, A.J. Boyk's aunt and uncle, and myself and Richard. We had a barbecue. We had some beers. We smoked some cigars. And when that evening was all over, Richard said, this is the best day I've had since my son was murdered. And that was because he was with people who understood. The time just after the shooting and during the trial was really some of the most support we ever had around us. When those times are over, we're left to take care of ourselves. One of the defense attorneys said that when a trial is over, we get to have the defendant put away and never be heard from again. If there's a death penalty trial, they stay in the limelight. Well, I know they want the same thing to happen to victims. You just want us to go away. You maybe want to bring us out, on the anniversaries or when you're having a new memorial or something gets set up. But really having to see us all the time is just really just too painful. Because then it causes your humanity to kind of be exposed. And you really don't like how that feels. I think that's probably about all I got. I don't know, I've probably said too much, probably haven't said enough. I don't believe that will know what the answer is to any of this. I do know that I had to say these things out loud, once and for all, because they've been rolling around in my head for the past 7 weeks. And I continue to try to push forward. And it'd be nice to try to get a decent night's sleep here. Just to be clear with you all, I will not be the one to tell the next family who has to endure a lifetime like I have what justice must look like for them. I will be a no on the repeal of the death penalty, and I hope that you'll join me so we can do what I believe the citizens of Colorado want us to do. Fix the wrongs that are in front of us, even when they're hard and painful, not just taking votes and moving on. Thanks for your time.
Thank you, Representative Sullivan. Representative Wilson. Committee would take a short recess. The committee will come back to order. Representative Wilson, are you ready?
Thank you, Mr. Chair. Pretty much out of character for me, have as many pages of notes as I've got. Most of you that have been in this chamber for a lot of years know I sit at that chair and listen a lot. And get up here and try to say things that'll make some sense. We were listening in this chamber to Representative Sullivan, but I want you to consider, did you really hear what he was saying? Did you really hear, even though you were listening out of respect, did you really hear? It's easy to look at each other and debate. It's easy to get up here and pontificate about all these things up at this level. But it's difficult to look into the eyes of parents and decide and make a decision. We keep talking about the dignity of the person. After listening to Representative Sullivan, who speaks for the dignity of the victims? This is a difficult, difficult decision, folks. And obviously, as you look at the history of the death penalty in Colorado, Colorado's had a tough time making up its mind. It's vacillated back and forth. I don't think now is the time to vacillate. I listened to Representative Sullivan. But more importantly, I heard what he said. Please, this is not the time to change this law. Thank you.
The next on the list was Representative Arndt. Are you still looking to come up? All right, who would like to speak next? Representative Carver.
Thank you, Mr. Chair. Mr. Chair, I would offer an amendment, L026, and ask that it be displayed.
The amendment is properly before us, and I'd like us to stand in a brief recess to consider whether this fits under the title. The committee will come back to order. Representative Carver.
Thank you, Mr. Chair. Amendment L026 would refer this issue to the people for a vote. And, Mr. Chair, I certainly understand that we may have a sidebar discussion, but if I may, even though the title of the bill was amended by the Senate, it currently says concerning the repeal of the death penalty by the General Assembly in all circumstances charged on or after July 1st, 2020. Respectfully, Mr. Chair, this amendment does concern the death penalty by the General Assembly. It is our decision as proposed by this amendment to refer the matter to the people of Colorado, which we do all the time as a General Assembly. Respectfully, it is within the rules, and at this point, I would move L026 and ask for an aye vote.
A division has been called, but the debate continues. Representative Benavides.
Thank you, Mr. Chair. I'd ask for a title ruling on this amendment.
The committee will stand in a brief recess. committee will come back to order. After a great deal of deliberation over the precedence of different motions, I rule that the amendment is out of order. Representative Carver.
Thank you, Mr. Chair. I offer amendment L027 and ask that it be displayed.
The amendment is properly before us. Please proceed, Representative Carver.
Thank you, Mr. Chair. Mr. Chair, this amendment would delete the safety clause and instead add a petition clause.
Representative Carver, you offered the amendment, but would you also move it?
Yes, Mr. Chair, I move L027. And at this point would like to speak to the amendment.
Please proceed.
Thank you, Mr. Chair. Members, an issue that we have covered before last year and this year. In the early 1900s, Colorado voters added 2 provisions to the Colorado Constitution. This was at a time in our state of populism and citizen action. And the 2 provisions added to the Colorado Constitution, the one indicated that all acts of the state legislature shall have a petition clause. And then it did an exception on when a safety clause could be done. But what the Colorado Constitution says is that all acts of the state legislature will have a petition clause so that should the law be passed and signed into law by the governor, it would not go into effect immediately, but rather it would stay suspended as to its effective date for 90 days, giving the people time, if they did not like the law, to gather significant signatures to place the issue on the ballot. And should such number of signatures be gathered in that time frame, the law would continue in suspension, not go into effect until the voters have their say. Now, the only exception to the rule in the Colorado Constitution where a petition clause need not be placed on the bill, but instead a safety clause can be done where the law can go into effect upon the governor's signature, is when such law is necessary for the immediate preservation of public health and safety. Members, there is no reasonable argument to say that this bill, indicating prospectively a repeal of the death penalty for homicides charged on July 1st, 2020 and past, there is no argument that this is a bill that the safety clause is warranted, that it is needed for the immediate preservation of public health and safety. So I ask for an amendment, ask for approval of this amendment to delete the safety clause and add the clause that the Colorado Constitution directs be part of this bill, a petition clause.
Representative Arndt.
Thank you, Mr. Chair, and thank you, Representative Carver. My colleague stated there is no argument for a safety clause on this, and I respectfully disagree. So Representative Strode and I ran last year a national popular vote, and we kept you guys here late that night, too. You're welcome. And some people said, hey, you know what, why don't you put the safety clause on there? Because, you know, then they couldn't petition, and we'd get it all wrapped up right away. And I said, no. Let's look up what a safety clause does. Safety clause is for the immediate preservation of public peace, health, or safety. There is no way the national popular vote fit under that. Absolutely not. Not in the wildest stretch of your imagination. Not even if you really, really believed in a bill and it was really a hard bill and you really wanted it and the governor signed it, you know, with no press conference and, you know, that was fine and it got done. No way was I going to put a safety clause on there. I am an honest broker in this. That bill, I think, is since 1936. When I was a freshman, I said, what's the difference? And they said, well, we've never seen a petition ever, you know, it's never going to happen. Well, it happened. And it happened for a good reason. Because the people of Colorado used the process that we have in place to gather the signatures to petition that on the ballot. And I was interviewed thousands of times about that. And I said the same thing every time. If I run in the national popular vote, I believe in process. And I believe that everyone should have their voice heard. So wouldn't it be ironic if I didn't believe in the petition process to try to repeal the work of the General Assembly? That would be dumb. Because one of my points about that bill is I want to have every single voice heard. This bill is different. This bill, I don't know if y'all had a chance to meet Ray Cohn last week when he came, the gentleman who was exonerated. I've talked to 2 people who have been flat out exonerated. Not guilty, didn't do it, on death row. Years, one for 17 years in Florida, Ray, 10 years. Did not commit the crime. The gentleman from Florida couldn't speak English when he was convicted. Mr. Cohn, if this bill isn't to preserve the health and safety of the potentially wrongly accused, I think that's a pretty good argument on why we should use the safety clause. And I urge a no vote on this amendment.
Representative Holtorf. Representative Carver.
Thank you, Mr. Chair. Well, respectfully, you know, we are talking about the way the bill is written right now. We're talking about charges that are brought when there is a charge, an incident of homicide, and a charge is brought, where the charge is going to be brought post July 1st, 2020. So were we to add the petition clause, and it would move the effective date, obviously, to August. So we are talking about the difference of 4 to 5 weeks from what the bill says right now to what it would, the implication would be if we added the petition clause. So the immediate preservation of public health and safety and the discussion and debate at the time was if you had an outbreak of an infectious disease and the quarantine laws were not sufficient, or you needed some kind of emergency response. But that was the immediate public health and safety. And here, respectfully, what the example given by the sponsor is that somehow the charging date, moving it 4 to 5 weeks out, I see no relevance in that impact to the potential of a wrongful conviction potentially sometime 3 or 4 years into the future. So I don't think that there is a basis for the safety clause, and that this should be governed by the provision in the Constitution that says the bills will have a petition clause unless the safety clause criteria are met. And so I ask for an aye vote on the amendment.
Representative Holtorf.
Thank you, Mr. Chairman. Once again, we have another false argument. We have to have a safety clause. We have to have it right now. It has to be in this bill because I'm sure that in the next 30, 60, 90, 120 days that safety clause will save a life. Well, I don't think the hands of justice move that fast. Number one. Number two, a petition clause. Why do we fear a petition? Why do we fear a ballot initiative? Why do we not offer this to the citizens of Colorado as I look up into the gallery for those citizens that are watching? Well, I think we know why. Because there's a strong possibility that the citizens will reject this legislation and say no. But we can't do that tonight. We can't even offer the citizens of this great state the opportunity. We're not going to do that tonight. We're not going to look at the First Amendment, and we're certainly not going to offer and look at and consider this amendment. Because we don't want the citizens to decide. We don't. Because the work is too important tonight. It's too important by the bill sponsors to get this thing done tonight. Put it in a can and send it out. Well, I don't think we were listening most of the night. Because now we're back.
Representative Holtorf, please stick to the content of the amendment.
Okay, back to the amendment. Let the people decide. Give them the choice. Pass the bill, if you will. You have the majority. Most of your minds are already made up. Make no mistake about it. I can tell by the sentiment in this chamber. But with this petition clause, what have you done? Nothing. But allow the citizens to vote in future time if they so choose. Do not deny the great citizens of this state that opportunity by voting against this amendment. I strongly encourage you to vote aye and support the will of the people.
Representative Arndt.
Thank you, Mr. Chair. Colleagues, the citizens of Colorado always have access to the ballot through the citizen initiative process. That's all there is to it. We have, how many? I think I counted 274 potential ballot titles coming up. This does not deny the citizens of Colorado from ever repealing this law. The safety clause put on here is the chance small that someone between July 1 and August 9th would be charged with the death penalty wrongly? That's small. But that is absolutely something that I'm willing to do on that off chance, because I know that we're not denying the citizens of Colorado the chance to go to the ballot.
Representative Benavides.
Thank you, Mr. Chair. Members, the plain language of the safety clause is for the preservation of the public peace, health, or safety. Public peace is disruptive if we continue with the death penalty, because even though we've had a lot of discussion, and I know there is an agreement on this, but again, as sponsors, we're bringing this bill because we feel that executions do disrupt the public peace. They also disrupt our legal system because it would distort charging decisions that would have to be made without a date certain. As far as health, the language does not say the public health, it says health. And clearly, if innocent people were prosecuted, it would disrupt their health. We heard from many families of victims and families of victims who spoke to us about the emotional and physical health and well-being and the trauma that they endure during those capital trials and after that. So it does disrupt that. One of the other things with regard to health, it disrupts the correction officers. I don't have it right in front of me, but we received a letter from a number of corrections officers and what they undergo, the nightmares they have in having to participate in executions or the potential of executions. So it does impact health, and it also impacts safety. As we continue to divert resources for death penalty prosecutions, it does leave fewer resources for safety issues like police officers, like drug rehabilitation programs, like pursuing unsolved crimes. So I think there is the argument, and I think it's a good argument, and that's why we put it in the bill, that in order to preserve the public peace, in order to preserve health, and in order to preserve safety, that it is necessary that there would be a safety clause. So I ask that you oppose the amendment.
Representative Liston.
Thank you, Mr. Chairman. Representative Arndt, I commend you for last year adding the petition clause to the national popular vote. Pardon? I certainly not going to impugn your, like I say, your motives. There was intense debate on that, and like I say, while I applaud you for that, I also heard from a lot of the proponents that said, well, sure, go ahead and put the petition clause on, because number one, the opponents out there will really never petition. And number two, if they do try and petition on to have the national popular vote, they'll never make it. You know, they just kind of blew everybody off. And there was, as many people in this audience know, there was a immediate groundswell of support. And people thought, oh, there's no way that the supporters of the national, or the opponents of the national popular vote, will ever get 125,000 signatures in the time period. I think it's 90 days they had to do it. There's just no way. They just can't do it. You know, they're a bunch of hayseeds, and they just can't get the organizations together. And of course, those hayseeds and those ignorant people who were...
Representative Liston, you're drifting a bit far afield. Would you redirect to the amendment, please, sir?
Mr. Chairman, I'm trying to tie it together with all due respect, Mr. Chairman. So those people who were concerned enough about the petition clause, lo and behold, they didn't get 100,000 signatures. They didn't get 125,000 signatures. They ended up getting 240,000 signatures, and the signatures were continuing to come in. And I think, to the amazement of a lot of the people who were supportive of the national popular vote, that is now going to be on the ballot this November. Pardon me while I put on my Karnak hat. I'm feeling that it's going to pass overwhelmingly by the people of the state of Colorado and reject the national popular vote.
Representative
Liston,
where am I going
please
with this,
direct
Mr.
your
Chairman?
attention
To the
where am I
amendment on the
going
screen.
Is that, what do you have to fear, Representative Arndt? What do any of us have to fear by putting the petition clause on it and letting the people decide? We have nothing to fear. It's a real steep hill to climb to get that done. So I ask you, and then it was brought up that about the necessary for the public peace, health, and safety. Well, what about the public peace for the citizens who are concerned about taking away the death penalty? Don't you think that they are due some peace? And what about the health of the victims? The health of the victims, shouldn't they be taken into consideration? So why are we fighting this? Let's give the people of Colorado the opportunity, instead of, if they can't go through the referendum, which has just been shot down, at least give them the opportunity to petition. It is so easy. So I ask for an aye vote on L027. What do we have to fear?
Representative Williams, you are next on my list. Are you still interested in speaking? And then next up, I have Representative Sandridge, Larson, and Rich.
Thank you, Mr. Chair. Members, I rise in support of this amendment. Currently, on page 17, the last section, we have the safety clause here. I'll read it again. The General Assembly hereby finds, determines, and declares that this act is necessary for the immediate preservation of the public peace, health, and safety. I mean, I honestly don't know what to say. I mean, I've heard the arguments from the proponents and the bill sponsors of why this is exactly needed. And it's just, it's on its face, it's not, right? A safety clause to protect criminals who are convicted of Class 1 felonies. This is, I've never seen anything like this before. I mean, I'm sure it's been done in the past before, but it's never, I think, really gotten legs and gotten to this point. But we're talking about criminals here. We really are. And there are going to be people that are charged and acquitted. I fully understand that. But to not allow the people the chance, just the chance, to go out there and get petition signatures so that we could have a vote on the ballot is unimaginable. I don't know why this body would be afraid to do it. Scratch that. Excuse me. I don't understand why the majority would be afraid to do that unless we're worried that it might be overturned. I mean, that's really, I think, the only legitimate reason that we could come to on why we wouldn't want the petition clause on here. I mean, a safety clause on this shouldn't be on this. We're talking about people who are definitely being charged, potentially being convicted, and we want to do it because the General Assembly finds and declares that it's necessary for the immediate preservation of public health, our peace, health, and safety. That's sort of the definition of irony. I mean, I'm kind of at a loss for words here, but I definitely don't want to impugn anyone's character. I don't want to impugn anyone's motives, but I think it's very clear, why we're having a debate here and why it appears that the majority is not inclined to let the people even have a shot, not even let them have a chance. It's because if they took this up, they would probably overturn what we did. Poll after poll after poll shows that there is support for the death penalty, and if we allowed the people a chance, then it would probably bear out in this instance. And it's certainly what happened in California. It happened in Nebraska. Representative Soper was kind enough to give us those examples where this type of thing went to the ballot. And in places like California, they not only upheld the death penalty, but they also voted to hasten the execution of those people. That's astounding. It's probably the one time I'll say in this chamber that we should follow California's example. That's amazing. I never thought I'd say it, but that they were right. But it wasn't the legislature that did it, it was the people that did it. And so we should allow the people to be able to mobilize and get together if they so choose, like they have in other areas, get the signatures, and let the people vote. Because I'm willing to bet anything that the majority of Coloradans, whether they be Republicans or Democrats or in between, are going to support the death penalty. And they're going to reject this. And I think it's unconscionable that we as a body would deny them that opportunity, but by putting on a safety clause that is meant to protect the public, law-abiding citizens, we're putting it on there to protect criminals. That's crazy. And so I would urge a yes vote on this amendment, and I would plead with the majority, don't deny the people the right to even have a shot. And I do want to point out one thing about the process. The process with the petition clause is a little bit different from going to a title board and going through that process. That's much harder than having to do the petition clause in many respects. So, let's not kid ourselves here. Let's at least know what we're doing and have our eyes wide open that having the safety clause in here unnecessarily burdens people that would otherwise mobilize and reject what's trying to be done. So I'd ask for a yes vote, and I would plead with the majority not to shut out the will of the voters and at least give them a chance. Thank you.
Representative Sandridge.
Thank you, Mr. Chair. I stand in support of this amendment. I'm just a little bit confused about the safety clause. You all know I don't like the safety clause too much. So we've killed one person in the last 50 years. It's not like we do this every day. It takes years for a death penalty trial to take place. I don't understand why whose safety is in immediate need. Where's the evidence of, in the state of Colorado, of false convictions? There's been one in the last 50 years. One death penalty, one murder, or one taking of a life. There's just no justification. And if we're worried about health, how about mental health? We have family members here. We have Representative Sullivan here getting up and having a talk. Who's worried about their mental health? So, what I'd like to do is maybe ask the people who are against this amendment, give me a situation, a specific situation that maybe somebody will be put to death within maybe the next 8 months. Give me a specific situation where someone would go through trial, get arrested, go through trial, get put to death in the next 8 months. Just give me a situation where there's an immediate need to abolish the death penalty. Because we already know, we've already heard statements from the governor. You know, he's not going to break out his pen in the near future and sign death warrants. So I want an example of an immediate need. And let's not go into this health issue. Well, if we cared about health, mental health, we probably wouldn't be here today. An example would be great.
Representative Larson.
Thank you, Mr. Chair. I rise in strong support of this amendment. Echoing what Representative Williams and Representative Sanders has said before, with all due respect to the bill's sponsor, I think the notion that there is an immediate threat that somebody could face execution in the interceding year that it would take to get final judgment from the people by adding a petition clause is disingenuous.
Representative Larson, please refrain from words like disingenuous.
Indeed. I apologize, Mr. Chair. However, I would like to draw your attention to a statement that was made by our governor in February, where he made it very clear that were the death penalty to be repealed, and that to have taken effective law by the signature of his pen, that he would commute the sentences of the 3 people that are currently on death row. If you'd like to go online, you can Google it. It's a February 7th story from NPR. Good story, pretty brief, to the point. So what I will posit to you is if we do not put the petition clause on here, and there is a period of doubt as to whether this will be put onto the ballot, or because of a title ruling issue that perhaps is delayed a year, what we will have is a very real situation where the popular will of the people may be expressed that they want to retain the death penalty, but 3 people that are currently on death row are commuted by action of the governor. And unlike legislation passed in this body, there is no petition clause for commutation, which would leave a member of the other body in this chamber with 2 of her son's killers with a sentence that they will never be able to get back. She will never be able to get the justice that she seeks for her son's killers. And I implore you to think about that. Because if, as the sponsors profess, they believe that there is recourse for the people to get this placed on the ballot and petition, as is their right, then why should we not preserve that right for the 3 people that are currently on death row? Because the governor, again, has made it clear that he will commute those sentences. So in all seriousness, if you're being genuine when you offer that, then why not put a petition clause? Because if we put the petition clause and this petition is filed within that 90-day period, I suspect the governor will hold off until the people have spoken. But if he signs it with a safety clause and this goes into effect, we can only take the governor at his word, where he has said that he will take that as a strong indication that these sentences should be commuted. And he will go forward and commute the sentences of these 3 individuals. So, what is the risk in the petition clause? I think we all know in this body that this is deeply unpopular and that the majority of the people of this state will vote to retain the death penalty. So why should it matter if they do that via a petition clause or if they do that via a title board ruling and filed through the normal petition process? But what that will give us is at least quick notice that this will be put on the ballot and will perhaps stop the governor from taking an action that is irrevocable for the 3 people that are currently on death row. And I want you to seriously think about that, because setting aside all the other arguments about potential mental anguish from the people that are on death row now and the guards that are potentially thinking about having to participate in this execution, which, by the way, has not taken place in the 20 years that Nathan Dunlap has been on death row, and I sincerely doubt will take place in the interceding few months between now and the November election. But you do have real families, real victims of the 3 people on death row who will never be able to get that back if that commutation is done. So I strongly urge you to at least give us the opportunity to put the petition clause on here. And you know what? If you're right and this is popular, and in fact, the people, when they voted for us, knew that we were going to drive forward and repeal the death penalty, and they don't file a petition clause, and they don't file the petition, then great. Then the people have spoken. But give them that opportunity, and give them that opportunity to also see justice done for the 3 people that are currently on death row.
Representative Pelton.
Thank you. Thank you, Mr. Chair. Thank you, Representative Carver, for running this amendment. I stand in full support of Amendment 027. I have had several citizens from my district reach out to me, and they can't see why this bill didn't have this in the first place. They think something this huge, compared to the national popular vote, this bill is magnitudes above national popular vote. And they think it's only fitting that a government of the people, by the people, should get to vote on this. And I happen to agree with them. So with that, I am in full support of this amendment.
Representative McKean.
Thank you, Mr. Chair. We heard one of our colleagues come down and talk a little bit about humility. And I listened to that carefully, and I actually appreciated those thoughts very much. This, I think, is a question of humility. I think it's a question of looking through the lens of kind of how we move our work through this body and through these 2 chambers and down to downstairs. And what we have heard, many of us, in doing some of the work ourselves, but what many of us have heard from other organizations when you talk to the population in general about this issue. I'm not surprising anyone here that this is a pretty divided issue. It's not a 66 in favor and 33 opposed kind of issue. In fact, in my district, it's the opposite. But we know that this issue is significantly more complex than just the folks in this chamber. So I would ask for support for this amendment out of the humility to go and examine the hearts of our voters. give them the opportunity to say, this is something we feel important enough to put on the ballot. And as Representative Larson said, if that effort does not mount, so be it. The humility to give our citizens the opportunity is what they deserve. And the humility to also take a look at this issue through the lens of how do we want to go about our business? Because when we see an issue that's this complex, this charged, I think that we have every reason to not only trust our voters, but honor their voices. Please vote in support of this amendment.
Representative Geithner.
Thank you, Mr. Chair. And I appreciate you allowing this amendment to move forward without title challenging before the amendment had been moved or presented. Members, I stand before you and I too rise in support of this amendment. I think simply what we're really getting at is 90 days. We're simply allowing the public of the citizens of Colorado 90 days to determine whether or not they would like to weigh in on this. That's all we're asking for. 90 days from the time that the governor signs it. I don't think that's a big ask. The First Amendment wasn't even allowed to move forward. At least let's use this opportunity to say that we won't impede the citizens of Colorado and their ability to go ahead and weigh in on this matter. I think it's important that we do this. I think it's important that we allow them 90 days, 3 months, less time than this body is even convened. I think it's fair. I think it's appropriate. I don't see how there is an immediate need to for risk and safety that we have to do this immediately. I think taking those 90 days and allowing the public the opportunity to contemplate whether or not they want to move forward, I think that's appropriate. And I don't think that that's asking too much or putting too much risk or too much safety in jeopardy. And so I rise in support of this amendment. Thank you, Representative Carver, for bringing it.
Representative Wilson.
Thank you, Mr. Chair. Colleagues, it's interesting as we listen to this because in the 8 years I've been here, I really can't remember a time that I couldn't pretty well predict where each of you in your district and how they might feel about it. But this one's really confusing to me. I mean, we have a member of the supermajority coming down and passionately arguing against this bill. And we have sponsors of this bill that are on the right side of the aisle in the Senate that I would never have guessed that would have been in favor of this bill. So it's really perplexing as we look at this one. I don't think we could predict. If we sat down right now and just took one of those famous little long sheets out there on vote counting and filled out how this body would vote individually on this bill right now and on this amendment, I'm not sure we could guess even close. So my challenge is, and I agree with the ones that have been up here, what's 90 days? I mean, seriously. The ones on death row will not be executed in 90 days. So I don't think there's an issue there. There's not obviously a long line of people. We've only executed one in 50 years. But I don't think we really know how our people feel. Now, many of you may have addressed this in our famous town halls. I'm not going to ask for a show of hands on that, but people have probably been there. But do you understand? Well, you understand. I apologize for that. But do you realize how many people you really represent? It would fill Bronco Stadium, which they may need that unless the Broncos start winning a little more. But the people that we represent would fill Bronco Stadium, and I'm not sure that many of us have really contacted that many. If you look, we've just had a whole bunch of presidential candidates here in Colorado, and I mean, I'm not making this to have you rise up against me here, but President Trump had literally thousands there. He didn't have 77,000 people there. Even our presidential candidates don't get that kind of participation. We don't know on an issue like this when we say, well, I know where my redneck folks come from, and they're all going, no, I can't say that. I can't say that. There are people of faith that will say keep it, and there are people of faith that say don't keep it. There are Republicans that say keep it. There are Democrats that say keep it. Vice versa. You're starting to get the picture? I don't think we know. So even though we talk about, well, what are we afraid of and so forth, it's not the afraid of piece. It's I don't think any of us really know where those people would come down, and this is the way. If they want that opportunity, it gives them the opportunity to be heard on this one. Because this is one of those times in our careers, we don't want to be wrong on that one. Some of us may be more concerned than others, like myself, but I don't have to worry about that anymore. But we want to be careful on this one, folks, because we can't guess where our people are coming from. So with that, I thank the sponsor of the amendment for bringing it. I thank the bill sponsors for bringing it because it's an issue we need to address. But I don't think 65 people in this chamber need to address it. I think the people we represent need to be heard on this one. Thank you.
Representative Melton.
Thank you, Mr. Chair. Well, 3 things about this amendment. I rise in opposition to it. One, we're not talking about convicted felons. In the bill, it is if you are charged by this date, it applies, not if you are convicted. And I'm sorry, I believe that you are innocent until proven guilty. So that's 1. 2, a safety clause is absolutely appropriate because we are talking about equal protection under the law. I just talked about how all 3 people on death row come from my district. You cannot say that it is applied evenly across this state in its current form. And so therefore, it does violate the safety, health, and wellness of our citizens when some are in jeopardy while others are not, simply based on your zip code. And thirdly, and I'll point this out, and I want to make sure it's clear, and I want to make sure everybody in this chamber understands, this is not just a 30-day delay. This is a 1-year delay if a petition is filed. Look at line 12. We are striking 2020 and replacing that with 2021. This is a 1-year delay. So we're talking about, could someone get charged in a 30-day period? Sure. Could someone get charged in a 1-year period? Almost certainly. So for that reason, members, I ask for a no vote on this amendment.
Representative Soper.
Well, thank you, Mr. Chair. I rise in support of this amendment. And to respond to what my good colleague just said as well, I think that it needs to be touched upon. It's my understanding that the governor of this great state has actually pledged not to sign any death warrants during his time in office. And if that is true, and we can presume that he will still be in office for up to another year, no one is going to be executed in the state of Colorado within the time that would be presented under the petition clause. Second, I believe we need to respect the Colorado Constitution. In 1910, Colorado adopted an amendment to our state constitution that gave the people the right to propose laws through initiatives, but it also created the right to approve or reject laws passed by the General Assembly, and that's the right of referendum. And that's exactly what we're talking about right here. All this does is put into the bill the option. And only twice in the last 88 years has this option ever been used by the people. The people tend to agree with what we do. I mean, we're their representatives. But what this does is it adds the assurance. And where the exception to not having this in is found in our state constitution, we'd look to Article 5, Section 1, Clause 3. And that's what we've talked about a little bit here, that it's necessary for the immediate, and I would stress immediate, preservation of public peace, health, or safety. I do not see any element of this bill that requires the immediate preservation of public peace, health, or safety. As I just said, no one's lives are at risk. We have the assurances from the governor. As a matter of fact, the last time, well, I shouldn't say the last time, but in 1966, the time before last that this issue appeared on the ballot, as some of you may remember in this room, Governor John Love made a commitment to the people of Colorado that he would not sign any execution orders until the people had had an opportunity to weigh in. Now, that was a referred measure in 1966 to the ballot. But it's important to remember that when a governor makes a pledge, governors tend to honor that pledge. And when we look at historic gubernatorial practices, they honor that. And so I would just push back a little bit and say that we don't have anyone who's at risk of dying from the death penalty. Not now, not today, not in the next year. Vote yes on this amendment. Thank you.
Representative Sane.
Thank you, Mr. Chair. I want to say that it took 8 years, but I finally heard the full story of Tom Sullivan. And it's probably still a snapshot in time, but I've only heard bits and pieces so far. 3 minutes on a timer, maybe up to 15 minutes if the chair allowed it. I am deeply honored to hear that whole story. A snapshot in time still of the most horrific thing you can do as a parent, which is outlive your child. And he said something very powerful here today that I hope we're going to remember because it's here echoed through this chamber. I will not tell another family what justice looks like for them. And that's what this bill attempts to do today. Without this amendment, the door is closed on this particular issue that we vote on today for Colorado families to answer back, to say we don't agree with this, to say this is a tool that prosecutors can use to get a confession, to find the bodies of 2 little girls and a pregnant mother. Without this amendment, this is the full weight of the tyranny of the majority saying, we know what's best. We are the judge and the jury. And this is what justice looks like for you. Urge a yes vote on this amendment. I love you all, but think carefully about making sure that we're honoring the wishes of our Colorado families today.
Representative Benavides.
Thank you, Mr. Chair. And members, we've been debating the amendment, and you all know what a petition clause is, and you know what a safety clause is. Most petition clauses that you've ever seen say that the bill takes effect 90 days after the end of our session, which is sometime in August, and this allows, if there's enough signatures, then it goes to the ballot in November. And most of your petition clauses say then it takes effect after that. This doesn't do that. This is much more than just a petition clause. It changes the effective date till for offenses charged after July 1st, 2021. So this is more than a petition clause, and please consider that when you vote, and please vote no on the amendment.
Is there any further discussion on Amendment L27? Representative Catlin.
Thank you, Mr. Chair. It's an honor to serve with you.
And with you as well.
Well, I've come back down to the well to talk to you folks again about the opportunity for the public to decide. This clause will allow that. You've heard my impassioned speech, so I'm not going to go through that again. This is an opportunity for us to look back to those people and say, look, we do understand. If you feel strong enough about it, collect the signatures and let's go to the ballot. This is an opportunity for us to look back to the people that own this state, honestly own this state, and what it does and what it doesn't do. This would be a good opportunity for us. I would recommend a yes vote and ask for a yes vote, please.
Is there any further discussion on Amendment L27? Seeing none, the question before us is the adoption of Amendment L27. A division has been called. The question is the adoption of Amendment L27. A division has been requested. All those in the chamber not entitled to vote, please be seated and remain sitting. All those in favor of Amendment L27, please stand and remain standing in one place until the count is taken. You may be seated. All those opposed, please stand and remain standing in one place until the count is taken. You may be seated. Amendment L27 is lost. Representative Williams.
Well, thank you, Mr. Chair. Members, I obviously, and we're to the bill, right? So there's been a lot said tonight about the bill itself, and there's been, obviously, both sides have spoken about why they like it, why they don't like it. But one of the things that really does concern me is the possible use of this bill to commute the death sentences of people that are on death row currently. And I understand in the bill title it says that we're trying to only make this apply in all circumstances to people that were charged on or after July 1st, 2020. But we've already heard from the governor that he's probably going to do it. And I do think that this is potentially upending the will of our legislative branch, and I would say at least the bill sponsors from the Senate side. To be fair to the bill sponsors on the House side, I don't think we've ever really dived into this much, but I think with the words on or after July 1st, 2020, I think we're making it clear that we want to at least have the death penalty apply to the current people who are on death row. So with that, members, I move L044 and ask that it be displayed.
The amendment is properly before us. Please proceed, Representative Williams.
Thank you, Mr. Chair. So what this amendment would do effectively is it would protect the will of this General Assembly. The governor has made overtures, signals, I think has made his will known that he is going to commute the sentences of the current people who are on death row. And his justification is the potential passage of this bill. And I think that's a problem. And I think we need to know exactly what we're getting into. I think we need to have our eyes wide open about this. I think it's the will, at least it was the will of the bill sponsors in the Senate, that it wouldn't apply to those people, that this bill here would only apply to people charged after a certain date. And I think it's important that we talk about, who's on death row currently, because this amendment, this bill, is certainly going to have an impact on them, especially from as stated by the individual parties that are advocating for this bill. There was a Denver Post article, and the title of it is, "Who is on Colorado's Death Row?" It was written by Noel Phillips, and it talks about 3 men await execution at the Colorado State Penitentiary while the state's political figures debate the future of the death penalty in Colorado. The first person is Nathan Dunlap. Dunlap is 44, was sentenced to death after he was convicted in 1993 of 8 counts of first-degree murder for shootings at a Chuck E. Cheese restaurant in Aurora. Dunlap was 19 when he gunned down employees who were closing the business for the night. His victims, Ben Grant, 17, Sylvia Crowell, who was 19, Colleen O'Connor, 17, and Margaret Colbert, 50, died in the shootings. Bobby Stevens survived his gunshot wounds. What's his current status? Then Governor John Hickenlooper granted a temporary reprieve to Dunlap in 2013, meaning the execution most likely would not happen during Hickenlooper's tenure. Hickenlooper completed his last term in January, and the new governor, Jared Polis, was sworn in with showing no signs of any attempt to lift that reprieve. The second person currently on death row is Robert K. Ray. Ray is 33. He was the mastermind behind the 2005 execution of 2 people who were going to testify against him in another murder trial in Arapahoe County. Ray had fired shots during a 2004 party at Lowry Park where Gregory Van, 20, was killed and Javad Marshall Fields was wounded. Ray ordered the killing of Marshall Fields and his fiancée, who were witnesses in the Lowry Park shooting. His status, his case, and I think this is a little outdated on this one, but it says here that his case is in the appeals process, which is mandated by Colorado law. The other person is Sir Mario Owens. Owens is 34, was sentenced to death in the same case as Ray. His first was convicted of murder in 2007 and the death of Van. The next year, he was convicted in the killings of Marshall Fields and Wolf, both 22, as they were driving on an Aurora Street. Members, these are the people that are currently on death row. And with the passage of this bill, you're already seeing the executive branch indicating that they want to use it as justification to let these people live. These people were sentenced to death, and rightfully so. And I think it should be the business of this body to ensure that at the very least, that those 3 people get the justice that they deserve. So I'd ask for a yes vote on this amendment and encourage everyone else to do the same.
Representative Benavidez.
Thank you, Mr. Chair. And members, for those of you that can't see this amendment from far away, basically what it does, it would invalidate the thrust of this bill if the governor commuted the sentences of the 3 people currently facing death sentences, or if a court would overturn the death sentences, it would say this doesn't take an effect. While it is not a direct separation of powers issue, it does make our work contingent on what the governor might do or the court might do, and that should never be the case. We are 3 separate bodies in this state, and we act independently, and our work should not ever be subject to what happens by the executive branch or the judicial branch when it would just wipe out what we're doing. So I would urge a no vote on this.
Representative Sandridge.
Thank you, Mr. Chair. I stand in strong support of this amendment. The current bill actually looks for the future crimes. This amendment looks at the current 3 people on death row now. We need to think long and hard about this. We have victims, families of victims watching us right now that have been through a lot of pain, and they want justice on these 3 people. And we need to make sure and give it to them. The victims of Nathan Dunlap are watching. They deserve justice. Rhonda Fields deserves justice. Her family deserves justice. The jurors who made a decision, their will needs to be respected. And this goes back to what we're saying earlier. We cannot put ourselves in their positions that understand the pain that they are suffering. And so let's not strip this away from them. With that said, I ask for an aye vote on this amendment. Thank you.
Representative Sane.
Thank you, Mr. Chair. There was some discussion about separation of powers in 3 branches of government. One of those branches should keep its promise to the Senator Fields. Urge a yes vote.
Representative Liston.
Thank you, Mr. Chairman. Members, I rise in support of Amendment L044. We talk about the different branches of government. It's been commonly said, this is the people's house. We are representing the people. And the people of Colorado, or at least the vast majority of them, have seen the 3 people who are currently on death row. Their names have been talked about. They are expecting and figuring that the death sentence will ultimately be carried out, as it should be. Actually, for one of the people on death row, it should have been carried out about 3 or 4 years ago, had the former governor, Governor Hickenlooper, just done his initials. It would have been carried out, but he couldn't have the courage or the guts enough to do it, so he just punted.
Representative Liston, please don't impute the motives of our former governors.
So Governor Hickenlooper just didn't know what he was doing.
Representative Liston.
And
Representative Liston,
people-
are you paying attention? You will stick to the contents of the amendment.
So the people are expecting that this sentence be carried out. And so let's listen. We're the people's house. We're the people's representative. Let's make sure that this is done. And we have a new governor, and hopefully he'll hear the wishes of the people, and will carry through with this amendment. So I urge an aye vote on L044. Thank you.
Representative Soper.
Well, thank you, Mr. Chair. I rise in support of this amendment. And it's quite simple. It's that the 3 current members on death row were convicted under our current laws. There's an expectation that when they were sentenced to death row, that they would in fact be executed. That may be a harsh reality for some, but that is the current law that we operate under here in Colorado. As a matter of fact, the current law was something we voted on in 1974 as a people. And that to do something that goes both forward, prospective, and backwards, which is ex post facto, actually means we're governing in both directions. And that to be able to support this amendment means that we're preserving the state of the law as it existed when these individuals committed their crimes, when they were tried, and now when they're on death row. So I would urge a yes vote.
Representative Williams.
I believe you. I believe you. Thank you, Mr. Chair. Members, I just wanted to get up here and clarify a little bit of what I'm trying to attempt here. There was a little bit of discussion of separation of powers, and if you read the amendment carefully, it does not infringe on the governor's ability to issue pardons or clemencies or commute a sentence. It simply protects our legislative intent. And as I read this bill, the legislative intent is for death penalty sentences to not be an option on or after July 1st, 2020. But as I stated before, we've already had reports that the governor is going to use the potential passage of this law as an excuse to commute the sentences of people who are currently on death row. And I think that if we're talking about separation of powers, then I think we should all agree that the separation of powers goes both ways. If we are in fact co-equal branches of government, then we have a responsibility to ensure that our intent and what we're trying to do here is completely upheld. And I don't think it would be appropriate for the governor to utilize this bill as a vehicle to justify whatever decisions he wants to make with the current people who are on death row. That would be absolutely inappropriate, and I would hope that the bill sponsors at least would agree that the intent is not to affect the people currently on death row. But absent some sort of protection like this, I'm not sure what to think. So I would simply ask for a yes vote. Let's protect our powers, let's protect our legislative intent, and let's let the governor, make a choice. He can either commute the death sentences of the 3 people and not have this bill in place, or he can have this bill in place moving forward and allow justice to be served to the 3 people that certainly deserve the death penalty. Thank you.
Representative Arndt.
Thank you, Mr. Chair. Colleagues, I urge a no vote on this amendment.
Representative McKean.
Thank you, Mr. Chair. So I heard the argument about separation of powers, and I got my brain working, and that's always dangerous at 11 o'clock at night. But what I would ask is, if what we're talking about is the ability for co-equal branches of government to do their jobs, then when we talk about an amendment like this, are we not preserving the separation of powers and allowing the judicial branch to have the work that it did and the juries did in these cases upheld? That's a question. is this amendment not a way to make sure that the judicial branch and the import to the juries is not infringed upon by the legislature? I urge an aye vote.
Is there further discussion? Representative Soper.
Thank you, Mr. Chair. I just wanted to come up here again and reemphasize what I heard my colleague from Northern Colorado say in regards to the amendment. And that's that without this amendment, we're completely voiding what juries have decided. We're also completely voiding, more importantly, what victims have decided. And as we recently heard this evening, there's a process to these trials. You first have the guilt phase. And then when it comes to the death penalty, you have do the aggravating factors outweigh the mitigating factors? And then you move to that last phase, the victim statement phase. And the victims have to be able to convince the jury unanimously. And without this, what you're saying is that that unanimous vote that the juries put in that last phase doesn't count. And so without this amendment, what is really being said is that the victim's voice doesn't count, and that under the current rules that we have been operating under, that doesn't count either. I would once again urge a yes vote on this amendment.
Is there further discussion? Seeing none, the question before us is the passage of Amendment L44. A division has been called. Okay. The question is the adoption of Amendment L44. A division has been requested. All those in the chamber not entitled to vote, please be seated and remain sitting. All those in favor of Amendment L44, please stand and remain standing in one place until the count is taken. You may be seated. All those opposed, please stand and remain standing in one place until the count is taken. You may be seated. Amendment L44 is lost. Majority Leader Garnett.
Thank you, Mr. Chair. I move the committee rise, report progress, and beg leave to sit again at 12:05 a.m. on Tuesday, February 25th.
Is there any objection? Seeing none, the committee will rise, report, and sit again at 12:05 a.m. on Tuesday, February 25th.
Ready to do the pledge and the prayer.
Great. Awesome.
So I'll just bring the House back to order right now. The House will come back to order. Majority Leader Garnett.
Thank you.
Okay, go ahead.
Thank you, Madam Speaker. I move I move to lay over the balance of the calendar until tomorrow, February 25th.
You have heard the motion. All those in favor say aye. All opposed say no. The motion is adopted. We have a couple committees to reports to read. The committee report. I'm sorry. Mr. Randall, please read the report of the Committee of the Whole.
Madam Speaker, the Committee of the Whole has met and reports as follows. It has risen, reports progress, and beg leave to sit again at 12:05 a.m. on February 25th, 2020.
Representative. Oh, just reports? But don't. We're just going to do reports. Okay. Mr. Randall, please read reports of committees of reference.
Committee on Public Health Care and Human Services, after considering the merits, the committee recommends the following. House Bill 1206 be amended as follows, and as submitted be referred to the Committee on Finance with favorable recommendation.
Signing of bills, resolutions, and memorials.
The Speaker has
Signing
signed.
of bills, resolutions, and memorials will be printed in the Journal. Delivery of bills to the Governor.
Chief Clerk of the House of
Delivery of bills to
Representatives.
the Governor will be printed in the Journal. Okay. Assistant Majority Leader Kennedy.
Thank you, Madam Speaker. I move the House stand in adjournment until Tuesday, February 25th at 12:05 a.m.
You all have heard the motion. Seeing no objection. Sit down. Sit down. Seeing no objection, the House will be in adjournment till Tuesday at 12:05 a.m.